All right. Good afternoon. This is Ask Judiciary Committee. It is the 19th of February, 2025, and we're starting with House Bill 113 and Delegate Ziegler, who has several panels. And we'll take her first panel now. Delegate Ziegler, come on up with Patrice Clark, Allie Clark, Gwen Marie Davis, Chris Norman, and John Goldberg. Are any of those virtual? I don't think so. No? All right. We'll have to add a chair, but that's all right. We're used to it. And we'll go from there, okay? We're good. Delegate Ziegler, you have 3 minutes. Everybody else has 2. Go right ahead.
So much. Good afternoon, Chair Clippinger, Vice Chair Bartlett, hardworking and esteemed members of the committee. For the record, I'm Delegate Natalie Ziegler here with House Bill 113, Non-Economic Damages, Personal Injury, and Wrongful Death. So this is the third time I've brought this bill. I want to recognize that by being as brief as possible. I do really appreciate your patience. Just to review, we're one of only 11 states that has a cap on what's normally called personal injury or pain and suffering. I believe this is an arbitrary, unjust, and outdated law. It disproportionately harms women, people of color, the disabled, the elderly. And I want to say of the states, the 39 states plus DC, which do not have a cap, 6 of those states had a cap, and their Supreme Courts overturned them on the grounds of separation of powers, equal protection, and the right to a trial by jury. There are a further 5 states whose constitutions explicitly prohibit personal injury caps. So I just want to hit 3 arguments that are commonly brought against the idea of repealing this bill. The first one is the idea that juries will inevitably award crazy damage amounts, and there's nothing you can do about that. That is not true. A judge can always lower a damage award if he or she feels it's excessive. And implicit in that argument is always the idea that juries don't reach reasonable, rational conclusions. And, you know, the right to a trial by jury is, of course, a foundational one. So I think that's something to consider. The second argument, which I do take seriously, is that it would be damaging to business and particularly to attracting new business to Maryland. So we're the only state on the Eastern Seaboard that does not have a cap. And yet, as our governor reminds us, we have been growing at about half the rate of the rest of the nation. So if that is supposed to be a draw, it doesn't appear to be working. We've lost a lot of business to Virginia, for example, most recently and notably the Amazon headquarters. So from what you read, businesses really look for housing, transportation, workers, tax incentives. They're not looking for where they can get away with egregiously bad behavior, to be fair to corporations. So the third and final issue I want to address is the idea that repealing personal injury caps would open the door to repealing medical malpractice caps. This bill has nothing whatsoever to do with medical malpractice. And for those who think it's the thin end of the wedge, I would argue that 21 states have medical malpractice caps, but do not have personal injury caps, so they can coexist. Thank you so much, and ask for a favorable report.
Thank you. Good afternoon, Chair Clippinger, Vice Chair Bartlett, members of this wonderful committee. My name is Gwen Marie Davis, and I am the president of the Maryland Association for Justice. I'm also a lifelong Maryland resident, and I sit here today to tell you that decades of legal scholarship, including UB Law Review and several other law reviews, have shown that a cap is disproportionately lower and it affects recoveries for women, the elderly, minorities, and children. This hits home for me as I obviously am a woman and a minority. And that simply is not fair. There was a verdict in Maryland where a woman was injured as a result of being rear-ended in a tractor trailer, by a tractor trailer. She was hurt so bad that she had to have multiple surgeries and suffered from disfigurement of her breast. It was something that never got better, and even though she had surgery, she had to live with that for the rest of her life. The jury spoke, and the jury awarded her $2.3 million in non-economic damages. Her verdict was slashed as a result of the unfair caps. It is simply not fair. And as a Maryland business owner, and as a lifelong Maryland resident, and from District 25, I would ask you and urge you for a favorable report on this bill. Thank you.
Sure. Good afternoon, Mr. Chairman. Yes, sir. Good afternoon, Mr. Chairman, members of the committee. I am a husband and a father, a lifelong Marylander, a third-generation small business owner, and I'm also a registered Republican. And it's from that perspective that I urge a favorable report on HB 113. The Second Amendment to the Constitution guarantees Americans the right to bear arms. And just as the Second Amendment guarantees the right to bear arms, the Eighth Amendment to the Constitution guarantees Americans the right to a trial by jury in a civil case. Both of those rights, the Second Amendment and the Eighth Amendment, stand on equal constitutional footing and shall not be infringed, according to the words of the Constitution. Speaking to everyone, but in particular my fellow Republicans on this committee, as conservatives, we can't pick and choose which constitutional rights we decide to fight to uphold. Allowing our constitutional rights to be slowly degraded, as has happened with the Second Amendment, will undermine the foundational principles that fortify our democracy. The Eighth Amendment to the Constitution is an important component of that democracy and should be upheld and preserved. Lastly, as a third-generation small business owner, I am understanding of small businesses who feel that repealing this cap may have an adverse impact on their business. But simply put, those fears are unfounded and unsubstantiated by any data that I've seen. The rare instances really where unreasonably unsafe conduct severely injures innocent Maryland citizens does not drive the cost of doing business in our state. Echoing what Delegate Ziegler said, only a handful of other states in the entire country have caps on damages like this, and the most business-friendly conservative states in the union don't. Think Texas, Florida, South Carolina. It doesn't have an impact on small business, and I'd urge a favorable report. Thank you.
Good afternoon. My name is Allison Clark. I'm a constituent of District 31, a mom of 3, and a widow. On May 4th, 2019, a helicopter crashed into the Chesapeake Bay, killing the pilot and the passenger. The passenger was my husband, Matthew Clark. At the time, our daughter had just turned 5, and our sons were 8 and 11. My family hired an attorney to investigate the cause of the crash, and eventually, we learned that the engine installed on the helicopter was defective. The engine was manufactured in Pennsylvania by a Pennsylvania company called Avco, the parent company of Lycoming. My family filed suit against the engine manufacturer in Pennsylvania federal court. The suit is still pending. Pennsylvania does not have a cap on pain and suffering. Even though the engine was manufactured in Pennsylvania by a Pennsylvania company, the manufacturer is arguing that Maryland's cap should limit the amount that can be awarded to me and my children for our pain and suffering simply because the accident occurred in Maryland. There's no amount that could ever come close to compensating for the pain that Matt's death has caused, but it adds insult to injury when a Pennsylvania company can try to use Maryland law against Maryland citizens to avoid responsibility for the harm it has caused. For these reasons, I urge a favorable report on House Bill 113.
Thank you. Good afternoon, Mr. Chairman and members of the committee. My name is Jonathan Goldberg. I'm an attorney, and I'm here to testify in favor of House Bill 113 and requesting a favorable vote from this committee. You have heard and you've probably read what this bill will do for Marylanders who have been injured due to someone's negligence, such as in an automobile accident or in a premises liability or a helicopter accident. But let me tell you what this bill does not do. It does not change the cap that applies to non-economic damages in medical malpractice cases, as Delegate Ziegler said. House Bill 113 is limited to addressing Courts and Judicial Proceedings Article, Section 11108. Section 11108 does not apply to medical malpractice cases. The cap on non-economic damages in medical malpractice cases is found at Section 32809 of the Courts and Judicial Proceeding Article. House Bill 113 does not affect that statute. Doctors, nurses, hospitals, healthcare providers have nothing to worry about regarding this bill and the cap on non-economic damages, as that cap is still applicable in medical malpractice cases. And to the extent that anyone tries to argue that House Bill 113 does change the cap that's applicable to medical malpractice cases, that is just not correct. There should be likewise no concern that removing the cap in non-medical malpractice cases, as this bill will do, somehow makes the med-mal cap unconstitutional, and the decisions from the appellate courts in this state would confirm that. House Bill 113 does not change the damage cap for doctors, hospitals, and healthcare providers, and I encourage this committee to issue a favorable report on House Bill 113. Thank you.
Good afternoon, Mr. Chairman, Madam Vice Chair, and members of the committee. My name is Patrice Meredith Clark. I'm Allie's sister-in-law. I also happen to be a trial lawyer, and I urge a favorable report on House Bill 113. I'd like to address a few of the arguments I think we're going to hear from the opposition in a few minutes. First, I want to be clear that we all agree that there was a perceived insurance crisis in 1985. The General Assembly enacted the cap to try and address that crisis, and that was the goal. But over the past 40 years, we have learned a lot about the way that insurance markets work. We've learned about hard markets and soft markets, and what we know now that we didn't know then is that caps on the amount that individuals can recover for wrongful death, for personal injury, that doesn't affect insurance premiums. Over the last 40 years, states that don't have a cap saw the same insurance market stabilization as Maryland, but the rights of Maryland citizens were limited where the rights of people in other states were not. The other thing I expect that you're going to hear is that the insurance industry hired a private actuarial firm to conduct an analysis of how insurance rates will increase if we raise the cap to $1.75 million, which is what passed the Senate last year. The opposition will say that if we raise the rates, or if we raise the cap to 1.75 million, insurance rates will increase anywhere from 17 to 21%. But what are the assumptions underlying that actuarial analysis, that private actuarial analysis? And more importantly, can the insurance industry promise us that they won't increase our rates if we keep the cap in place? I seriously doubt it. They're not going to promise you that. If anyone is interested, I submitted written testimony with a couple of exhibits that have a plethora of citations to examples of how we know that insurance premiums are not affected by personal injury caps, and I would request that you take a look if you're interested. So with that, I request a favorable report. Thank you so much.
Questions, Vice Chair.
Thank you, Mr. Chair, and thank you all for being here today. You may find I have a bit more questions today than I usually do. So I'll run through them really quickly. And I think the last person who spoke could answer my one of my questions. So what is the largest recorded non-economic damages award in those states that have no cap? What has been the largest?
Well, I guess I would, in true lawyer fashion, answer your question with a question. Do you mean the largest that has been awarded by a jury or the largest that has actually been recovered? Because remember, a judge always has the ability to reduce the amount, as Delegate Ziegler was saying.
Why don't you give me both?
Well, I don't know the answer, but I'm going to find out for you, and we'll get you that information.
Does anyone else have that answer?
I don't have that answer, but I'll say that if there's ever a time that a judge feels like the jury shocked the conscience, there's an opportunity for a remitted, or probably have judges in places that can bring a jury down, verdict
Great.
down.
Okay, so I'm assuming that the lower judgments for minority women and older individuals is because of the actuarial decisions of life expectancy and work and all that? Is that the reason?
If I might, it's because we don't have a cap on economic damages. So you would receive compensation for lost wages, for example, but if you don't earn much, that doesn't amount to much. So, you could have a CEO and a janitor who get the same injury, but get very different awards.
Right, but you all focused on women, so I was trying to understand, is that because women make less?
Because women make less money.
All right.
Exactly.
And has the constitutional argument been challenged at the Supreme Court?
The Supreme Court of Maryland?
No, the Supreme Court of the United States.
I'm not sure if the constitutional argument has been argued at the Supreme Court, but I can tell you that in terms of the constitutional argument that if you have a special cap for personal injury versus medical malpractice, is that what you're asking, Delegate?
No.
Oh, I'm sorry.
No, I was literally asking if the constitutional argument, I heard a lot about the Second and Eighth Amendments. So I wanted to know, since it was a constitutional question on Second and Eighth Amendments that was presented to us, had it been argued by the at the U.S. Supreme Court yet?
I'm not aware of it ever being argued in the U.S. Supreme Court. The 6 states that I was referring to, their state Supreme Courts overturned it. That's the only.
Yes.
That's all that I'm aware of.
Right.
Yes, I'm going to say that too. I'm aware of it. Like in Florida, they said that the caps were unconstitutional. And
No, I got that part of the testimony. I just didn't hear the United States Supreme Court, so that's where I was going with that. And so we don't know the largest recorded non-economic damage award in any of those states, by jury or by anybody, by jury or judge. We don't have the largest?
we could get that information for you if we could find it for sure.
Okay. All right, that would be great. Just so I can get an idea of how high we could go.
But just because there was a recorded verdict doesn't mean that there wasn't a remitter per se or something.
Okay, so even with the remitter, I'm just trying to understand what is in the realm of possibilities. What does no cap on non-economic damages, how far could it go?
Well, for example, now in the case that I just gave, a jury awarded $2.3 million in non-economic damages, and it was struck down by, there being a cap. So.
But that was in the state of Maryland.
Correct.
Where we have a cap. What I'm asking
But the jury doesn't know when they go back into the jury room that there is a cap. That's all.
No, I guess, I don't understand why I'm not being clear, but what I'm asking for is a jury in one of the states that have no cap, what have they awarded? And I need to know that, and then I need to know what did that individual or family or whatever, what did they actually receive, at least that day? There might have been appeals and all that later, but at least that day, what were they thinking was the award on that particular?
Madam Vice
I
Chair, I will
understand your
get you
question,
that.
Madam Chair, and it's information that we will try and get for you.
Yeah,
I
thank
don't
you.
think any of us have it at our fingertips, but I understand your question, and we'll figure it out.
Okay, thank you so much.
Yes, ma'am.
Don't worry, I have questions for that.
Thank you, Mr. Chair, and thank you all for coming. Just trying to get a little clarity on your opening statements. So when it comes to non-economic damages and how it adversely affects individuals, I heard it affects black females, then females, or is that white females or all females?
All females.
Okay, and it affects the Republicans. And so I'm trying to say, do y'all have any data or data that indicates this information that y'all can present at this time?
Yes, there has been several law review articles from the University of Baltimore as well. So
Yeah, anything you can present at this time?
I believe that it was uploaded as an exhibit.
Okay, I didn't see it on there.
So I'll send it to you directly as well too. There's
Sure,
a lot
thank you.
of-
Yeah, just looking for some breakdown of those numbers so we can kind of get a better graph of the impact that you were speaking to.
Now, when I say law, there are a lot of articles, a lot of data has been said that minorities and women and elderly have been discriminated.
Is this like global? Is it specific to Maryland? Like where would the information?
Well, the article that was written is from the University of Baltimore School of Law.
Okay,
One, for example.
all right, thank you.
Sure.
Appreciate it.
Delegate Boucher.
Thank you, Chair. I want to make sure I heard something correct earlier. Why is the cap so important on a medical industry but not other cases? Did I hear that wrong or is that correct?
Well, see if I can do this. It's not a measure of importance, Delegate. There are two caps in Maryland, one for medical malpractice cases, one for personal injury non-medical malpractice cases. This bill addresses the latter. It doesn't address the cap that applies to medical malpractice cases. So that cap will remain.
So I guess the question is why? Why not put them all together? Why do they have to be separate? What's the difference?
Well, because they're different types of cases. So
May I take a crack? There's two different statutory schemes. One is the personal injury cap is in 11108, and then there's the Healthcare Malpractice Claims Act, which was a totally separate scheme adopted in a totally separate context. And the reason that we bring that up is because I think you're going to hear from the opposition that essentially Chicken Little, the sky is falling. This is going to affect all of the industries, including the healthcare industry. And our only point, and Delegate Ziegler's only point, is that's incorrect. There are plenty of states that have a medical malpractice cap to protect medical industries. And the reason that it came up was, again, because of the perceived insurance crisis in the context of medical providers. And so there was a cap put in place in 40 years ago for medical providers. But our only point is this is a totally separate statute, and it doesn't affect the healthcare providers, and it doesn't affect the cap that's in place there. So to the extent that anybody comes and says this is going to affect healthcare, our point is it will not.
Well, if it's good for one, why isn't it good for the other? That's what I'm trying to understand. It's not squaring up for me.
Well, the caps are already different. There's already a different number on the amount that
But
you
there
can.
is a cap.
Oh, there's a cap in both contexts.
That's why I'm wondering why advance this but not address the other. Will eventually that be addressed too?
Well, that's not what we're here to do
Okay.
today. I mean,
I'm just trying to
we're
square
not
it all
here to
make
do that
sense.
today.
All right, thank you very much.
Nope, and it won't address that. It will not affect that at all.
Thank you, Mr. Chair, and thank you, panel. So I think between Vice Chair and my colleague, Delegate Boucher, I'm going to kind of go in a little bit more on that. And yes, some of the folks who are opponents are asking the question, isn't this a slippery slope? And if there is a significant difference between the med-mal cap and the general liability cap, won't that be something that ultimately may make its way to the Supreme Court of Maryland? What do you say about that?
I say that this has already been decided by our courts. The appellate courts of Maryland have looked at the disparate cap, which already exists. There's already essentially, when you have a personal injury case in Maryland, you can get, and it's a wrongful death case with 2 or more wrongful death beneficiaries. The cap on medical malpractice is about half of the personal injury cap. And the Supreme Court, or I think it was the appellate court of Maryland, has said that the legislature in its wisdom has instituted that cap. It's not a strict scrutiny test. The test is to whether there's a rational basis for that cap. The court has said, yes, there's a rational basis. They have upheld the constitutionality of this cap, of the medical malpractice cap, and the difference between the caps. So to say that we're going to face some kind of swell of appellate cases, I just think that's incorrect. The courts have already weighed in on this and said that the legislature in its wisdom has the power to do this, to have these different caps.
Thank you. I have another question, and that, Mr. Chair, and this really goes to help me with reality checks. I'm a driver of a vehicle involved in a really terrible accident. That accident, there's a certain amount of insurance coverage for that accident. The jury decides to award huge non-economic damages. Who pays for that?
So,
My coverage is $1 million. Who pays for that $3 million judgment?
yes, what I'll say is typically there are essentially caps too on insurance policies as well.
Right.
So in a situation like yours, $1 million would be what the payout would be on a situation like that. So.
And so for the victim and for the perpetrator, who pays?
I'm sorry, except for the victim?
For the victim, what do they receive? And for the perpetrator, what do they pay?
So the insurance company would pay the $1 million. That's what would be what it is. And that's typically what happens. It's very rare that you'll see that they will have to come out of pocket or things like that too. That's why you have insurance policies there. There are certain situations where you can, if bad faith is involved and things like that, but that's not the example that you're giving here.
But I mean, I just want to add, that's kind of an important point because right now, we don't have the ability to really bring bad faith claims. But if you had that situation and you knew that you were going to have a potential for a $3 million judgment, and you said to the insurance company, we will take your policy limits. Right now, they have the opportunity to give you the policy limits. And then you go to, but they say, pound sand, sorry, delegate, we're not interested. You go, you get your $3 million judgment, then the insurance company is responsible. But they shouldn't do that, right? If they know that you have an excellent case, there's clear liability, there's clear damages. This should be open and shut. You have a contract of insurance. You've paid for it. You've paid your premiums. This is a contract. They should pay out their $1 million policy limits, and we shouldn't involve the courts. We shouldn't clog up the courts with these cases. They should pay it. That's what should happen. And hopefully, if we don't have these caps where basically insurance companies are able to roll the dice, hopefully if we have these caps, it will lead to less litigation because it'll lead to more incentive to settle the cases.
So I'm still trying to make sure I'm clear numerically here. So if we remove the cap, we took the cap to $1.7 million.
It wouldn't affect this situation. The example, the hypothetical that you just gave, it would not affect it.
So when would that come into play? It sounds to me as if it's not coming into play in a significant way where we have a personal injury matter involving an individual. Is this more something that comes into play where we have a commercial environment?
I wouldn't say a commercial environment. It depends on what the policy is. The example that you gave was the policy was $1 million.
What's the average policy for any one of us as individuals?
Oh, for car insurance?
Let's use car insurance.
Probably anywhere from 100 to 500,000.
And so for most persons, the cap is not going to affect them individually.
I agree.
Okay. I'm just trying to, I'm asking these questions. I'm trying to help you out.
As a defendant, it won't affect them
Right.
individually, sure. But if they were injured and there was insurance from a corporation, as you said, yeah, I think that would change it.
But there are instances too, I would say it depends on the person and their insurance coverage because people carry different types of policies and things like that as well too. Just, had a situation where an elderly woman hit somebody and he's paralyzed for the rest of his life and had a policy that, was a little bit higher than what you're saying. Something like that, it's just different and they don't want to pay.
Very good. Thank you, Mr. Chair.
Thank you, Mr. Chairman. Thank you, delegate and panel, for coming in to testify. So if the person who hits someone is worth $1 billion and they do $3 million worth of damage, but they only insured for $1 million, and the insurance company pays out the $1 million that their policy covered, what happens with the other $2 million?
If I could address that, delegate.
Yes, you can.
Typically, the way it works is the parties will engage in the process, accept the limits of insurance, and then the case is resolved. For the rare circumstance like you're talking about, where you've got an individual who's worth $1 billion, there is the opportunity to collect the amount above the insurance limits against the individual, or against, maybe you've got a multi-state trucking corporation who's coming through Maryland and has a big policy.
That's the point I'm trying to get to.
Yes, sir.
But the lady at the other end didn't say that. She did not say that.
Right.
Thank you very much.
Yes, sir.
I do have a couple questions, but I'll make them brief. Delegate Ziegler, I keep hearing from opponents of this bill, so I wanted to ask you directly. Oh, well, if you have success this year, it'll be medical malpractice next year. So do you have any intention of introducing legislation to adjust the medical malpractice caps?
I do not, no. I actually believe that they are really quite different And no, I have no intention of doing that.
Okay, and then my second question is, we often get rather apocalyptic pictures of what's going to happen when this cap is lifted, and it's almost like the sky will fall kind of thing. But have you seen astronomical increases in Delaware or Pennsylvania? I'm just trying to assess whether it's factual or anticipatory anxiety, some of the rhetoric we're getting from the opponents. And then I have one final question.
No, we honestly haven't. And of the 39 states in the district that don't have caps, they're red, blue, purple, some of the most business-friendly states in the nation. Texas has no cap. Florida has no cap. As I said, no one on the eastern seaboard has a cap. Virginia has no cap. So, no, I haven't seen either terrible results, problems in the insurance market, or businesses fleeing those states.
And my final question is for the lady, I'm sorry, I forget your name, who's the president of the Maryland Association for Justice. Delegate Bartlett inquired to you about, the highest levels of jury verdicts and different things like that, but forgetting jury verdicts and the cap, isn't another way for an insurance company to limit their exposure in a case to engage in what's called a high-low, which means, hey, Mrs. Jones, if you win, we'll give you a max of 4.5, and if we beat you, you'll still get, 500,000. Couldn't insurers engage in high-lows to limit their exposure?
They could engage in high-lows, but that's not oftentimes. You wouldn't believe some of the negotiation tactics that occur, and to quite frankly, that's rare that the high-low offers are on the table.
But that's an option available to them, is what I want to get on the record.
In all instances, I would say no, but they have happened before, yes.
Okay.
If I could address your question, I've been engaged in plenty of cases where there are limits in the amount of insurance coverage, and during trial or prior to trial, the insurance company does just what you're suggesting, Delegate, and that is approach us about establishing a high-low agreement to ensure on the low end that our client gets something, and ensure on the upper end that the insurer and their insureds are also protected. So it is something they can do to limit their exposure.
Thank you very much, Mr. Chair. Thank you all.
Yes, sir.
Mr. Chair, and thank you, Delegate, for bringing the bill, and also thank you for the entire panel for this information this afternoon. My question also piggybacks on the Vice Chair's question earlier about the highest known award or possibly agreement upon the conclusion of the case. My question is, and I believe most of you touched on the fact that other states have the ability in awards that do not have a cap, that have the ability, the judge in those cases have the ability to lower an award. I think the word shock the conscience was maybe one that was brought up. And I'm not looking for specific numbers, but maybe just in general terms. How often does that occur in some of these other jurisdictions where I'm looking at maybe 10% of the time, half the time, where a judge has to reduce it because it was such an outrageous award? And that's for anyone on the panel.
I don't know that I can give you a percentage. I can tell you that remittitor is the legal term for what you're talking about, where a judge reduces the amount of a verdict because it shocks the conscience. It actually happens in Maryland, even though we have a cap. It happens all the time. Judges are empowered to decide whether or not a verdict is unreasonable based on the facts and circumstances of each case. And we trust judges and juries to listen to the facts and circumstances of each case and come up with the right number that will compensate each individual plaintiff depending on that case. I don't know the percentage-wise, but I know it's a very common thing to make sure that judges are the gatekeepers. They make sure that people are compensated appropriately.
Now, in Maryland, is that done because of the cap, or is it done because it would, okay.
Well, it's done because of the cap, but it's also done not because of the cap.
So it's done in both circumstances?
Yes. Yes.
So my question is that kind of then, does that kind of give you an argument for the cap? Because they're lowering awards to begin with? Is that an argument for that?
No, it happens. I mean, Gwen Marie can tell a personal story.
That's why I was wondering about the other states. If someone was low.
I raised my hand because, I'm sorry, go ahead.
No, please, go ahead, please.
No, you go ahead. I want to make sure I'm answering your question.
No, it's about the other states, the states with no cap. If they're if you're seeing that these judges are lowering or remitted or are lowering because they are outrageous or shocking the conscience
I
awards.
can get some information for other states, but what I could say in the state of Maryland, where I practice, it's higher than you would think that remitters happen. I personally, I had to trust what the judge decided. My client had a remitter, I think it was last year or the year before, by the judge. So it's not uncommon at all if the judge believes that the jury, verdict was outrageous or shocked his conscience or her conscience, then the judge will issue a remitter. And I have experienced it, and several of my colleagues here have as well too. It's very common in Maryland, and and in other states as well too. It happens. They are not afraid to do that.
Thank you.
Delegate Congolo.
Thanks, Mr. Chair, and thank you, Delegate, for bringing this bill. I first want to say to Allie, I'll say I was just introducing myself to her, and we exchanged a laugh, and then just minutes later, you shared a heart-wrenching story, and that's probably the hardest part of this job. I don't think there's any amount of money that would compensate for your loss. I do want to ask a question, and it's a very simple question. Let's say, for example, with car insurance, there's a car accident, and, you get points on your license or you're found at fault. And I know in past experience that my insurance has increased. So my question is that if we start to see these increased payouts, will premiums increase for policyholders as if it would for other types of insurances?
I think I can address that. I think the cap right now is already $950,000. Most people have a lower amount of insurance coverage already. So right now, if you're found at fault for a particular accident, up to the amount of your insurance coverage, that's the amount that is going to get paid out under your insurance coverage. And the premium should be the exact same, because most people aren't paying for car insurance above that amount. So if you're paying if you have a contract of insurance for a certain amount of coverage, and you're not going to increase your amount of coverage just because the cap goes up. We're just going to have the same amount of coverage. Your premium shouldn't increase. The insurance companies are going to say it will, but that doesn't really make much sense when they're not increasing the amount of coverage that's available to you. Mm-hmm. Did I answer your question?
Yeah, I guess what I understand is that if the coverage amount is the same, it wouldn't have any impact. That's what you're saying.
Yeah.
Okay. Thank you.
Thank you, Delegate.
Delegate Conaway, briefly, second by.
Thank you very much. Thank you for bringing the bill again and bringing it to our attention that if you are in a serious accident and you do $2 million, $2.5 million worth of damage, and you only worth $1 million, you might still be on the hook. So you're technically underinsured. That's correct? Yes. Thank you very much.
I have a couple questions. You talked a lot about remitter, talked about that a fair amount. Do other states that don't have a cap, do they have a different standard or a standard on remitter than we have here in Maryland?
Not that I know of.
Are they looking at, that you know of, are they looking for exactly the same things, or are they looking, every state's a little bit different. I'm just wondering whether there's a different standard.
I have not done a 50-state survey on the standard for remitter, but I will definitely look into that.
Delaware, just, immediately surrounding states would be helpful.
We'll look into that.
I guess the other question, and it goes to the comments that were made about when there was a drop in or where one cap was lifted or raised significantly, then people went to court and said, well, because that went higher, this cap should go higher on medical malpractice. And that is what I think sometimes gets these two issues mushed together, perhaps wrongly. But in some cases, I wonder, based on the attorney's knowledge of Maryland case law, do you think that there's a significant difference, if there's a significant difference between the non-medical side and the medical side when it comes to non-economic damages? Do you believe, based on the case law that exists right now, that would violate the Equal Protection Clause?
No, I think that the case law is very clear. It's already actually been looked at in the context of the Healthcare Malpractice Claims Act and the current 11108 cap, the disparity between them. And the courts have said that, I mean, I will say there was a dissent, but the courts have said that that is constitutional within the Equal Protection Clause, and that it was within the legislature's discretion to enact that legislation that had those disparate caps.
But if they were significantly disparate, if there was one side that had absolutely no cap, one side that did, do you think that would violate the Equal Protection Clause based on Maryland case law?
As long as it passes the rational basis test, which I think it would, because the rational basis would be whatever limits the Seventh Amendment rights. Sorry, Chris, it's the Seventh Amendment right to a jury trial. Whatever limits the Seventh Amendment right to a jury trial, and to recover damages, that has to pass rational basis. Right now, we have two different caps. The courts have said it passes the rational basis test. I think that as long as, if you repeal this cap, you still have a rational basis for the Healthcare Malpractice Claims Act, which the courts have already looked at. I think it passes rational basis test, and I think that the courts would not have any ability to overturn it.
You were jumping up and down.
No, I was just going to say, based on Maryland case law, I think Patrice has hit the nail on the head, but there are other states where there is no cap on the non-med mal torts, but there is a cap on med mal torts, and those states have found, despite that disparate impact on the cap, that it's constitutional, that scenario.
I mean, from what I have seen, it appears that there are some states where they did use that as a reason then to get rid of the cap on the one side, but that didn't have it. But then other states where they didn't
Where
do
it's
that.
been upheld.
Yeah, and so, and I guess the question was both about equal protection and then trial by jury, and you kind of touched on that a little bit too. But you don't think, based on the case law that exists right now in Maryland, that those arguments hold any water?
No, Delegate, I think that the law of stare decisis, or the rule of stare decisis, would say that the courts are not going to go back and say all of a sudden that the cap on medical malpractice is suddenly unconstitutional just because you repeal 11108.
Let me ask it a different way. Do you agree with that?
Personally? Yeah, I mean,
no, she doesn't.
I'm going to defer my answer to somebody else here.
No, I guess that's the other side of this question, though, is, I mean, is that the next?
Actually, I do agree with it. I really do agree that the test to determine whether or not there should be, whether or not the legislature had the power to do what it did, was there a rational basis? Do I think that there was a rational basis for the Healthcare Malpractice Claims Act? Yes, I do. Do I think 40 years later? I don't know. We'll have to talk about that another time, but that's not what we're here to talk about today. What we're here to talk about today is 11108, which was adopted 50 years ago, by the way. And 11108, there was, again, a rational basis, but there's not anymore. And that's why I think it needs to be repealed.
All right, thank you very much. Seeing no further questions for this panel, we will move on. Thank you. We'll hear from Petra Aaron, Kara O'Brien, Jasmine Rogers, George Tolley, Tom Yost. And if Mr. Moronic is on virtually, we'll just take him at this panel.
Move one of these chairs. I'll move this chair.
Mr. Moronic.
Yes. Yes, Mr. Chair, I hear you.
I see you there, Mr. Moronic. We're going to hear from the people in the room first, and then we're going to go to you. Whoever would like to go first from the table, please.
Good afternoon, Mr. Chair, Madam Vice Chair, and the members of this esteemed committee. My name is Kara O'Brien. I'm an attorney and a small business owner, and my family and I reside in District 31. You've heard some testimony about why this cap is arbitrary and unfair. I'm here to give you a real-life example of that. In 2014, I had a jury trial involving two sisters at the time they were 18 and 22. They had permanent brain damage from lead paint poisoning as children. The jury listened to 12 witnesses for both sides and over about a week. An expert for the defendants actually testified that the older sister had no joy left for life, which is the saddest thing when you're 21 years old. She was 21 at the time of the interview. That to me is the epitome of non-economic damages. After hearing all of the testimony and deliberating, the jury came back with a verdict for the older sister of $1,031,567.67. That's a very specific and deliberate number. They came back with a verdict for the younger sister of $851,714.50. Again, another very specific and deliberate number. The jury did their civic duty and they left thinking that was their verdict. But a couple weeks later, it was reduced under the cap to $350,000 for the older sister and $515,000 for the younger sister. So the older's was reduced to about a third, and the younger sister's was reduced by about half. So not only was the jury's careful deliberation for nothing, we had to explain to our clients why it was arbitrarily reduced, and then we had to explain to them why it was unfairly reversed, because the older sister ended up getting less in non-economic damages than the younger sister because of when her cause of action arose. And I really think that's worth repeating. Because of this cap, the jury's award was reversed. There was more economic damage to the younger sister when the jury decided they wanted to award her less. This is just such a good example of why this cap is so arbitrary and unfair. These sisters were 22 and 18 at the time of the verdict. They had a long life ahead of them. I think by the tables they had 50 or 60 years, and that was the non-economic damages that they were able to walk away with under this cap. I hope that this gives you a real-life example of why the cap's arbitrary and unfair. And on behalf of myself, my clients, and my family, I urge a favorable report on House Bill 113.
Thank you. Good afternoon, Mr. Chair, Madam Vice Chair, and members of the Judicial Committee. Thank you for this opportunity. My name is Petra Aaron. I'm an attorney that handles, amongst other things, personal injury cases. I'm here to talk on behalf of my client. We'll call him Mr. C. He was 59 years old when he endured a crash, and he suffered permanent grievous injuries. He's still in pain to this day. And I'm here to speak on his behalf. The jury heard from him over several days, heard other evidence in the case, and gave him an award above the cap. To sit down and discuss with him afterwards that his award was going to be facing a cap, he just couldn't understand it. I'm going to quote from him. "Why would my state do this to me? This is so unfair." I don't want to ever have another conversation like that with another client. It's very hard to explain to them that a jury that hears their story, that hears their experience, that weighs their evidence, that considers their expert testimony, the testimony of their medical providers, their doctors, that their award would be reduced arbitrarily. And that is the word that stands out to me. He was 59 years old. He is unable to take care of his family in the way that he did before. That was a consideration that the jury made. And to this day, he still talks about that. And so I'm here to talk to you about him. He wants this law changed, and I would love to deliver good news to him. I urge a favorable report on HB 113.
Mr. Chair, Madam Vice Chair, delegates, my name is Tom Yost. I urge you to report favorably on House Bill 113. 39 states in the District of Columbia do not have a cap. They're doing fine. Maryland companies like Marriott, Northrop Grumman, and others do business in probably all of these states. Maryland companies that manufacture goods sell their products in all of these states. And when they cause significant and grievous harm to these people in those states, they pay for the harm. Because there's no caps, it's not a deterrent for them. They still do business in those states. As soon as any Maryland company's motor vehicle, whether it's a car or a truck, crosses the state line, there's no cap. There's no cap in Virginia, there's no cap in West Virginia, there's no cap in Pennsylvania, Delaware, or the District of Columbia. They still do business in those states. The insurance that they buy to do business already reflects that they do business in states without caps. There should be no increase. When foreign corporations catastrophically injure people in our state, they get the Maryland discount. These could be international medical device companies, drug companies, car companies, foreign car companies that cause harm. They get the benefit of paying less to people because they were injured in the state of Maryland. That's what this law does. It helps companies and insurance companies. It doesn't help constituents. Many of these companies have plenty of insurance to pay for catastrophic injuries, but they can't use the whole policy because there's a cap. This law does not affect local government or the state government. There's still going to be state caps and local government caps on damages. It's fiscally neutral. Thank you.
Mr. Murphy, you're not signed up, I'm sorry. Mr. Collins.
May I let Ms. Rogers go first?
Go ahead.
Okay. Good afternoon. My name is Jasmine Rogers, and I live in District 46. On February 29th of 2008, I fell approximately 20 feet from the balcony of a public establishment because the railing was not secured. It had been cut and not welded back properly. I shattered my T12 and L1 vertebrae and compressed my spinal cord, leaving me paraplegic. I also fractured several ribs and my skull, causing a traumatic brain injury. In addition to my paraplegia, I am in constant severe pain. I've lost my sense of smell, and I've lost function and control of my bowel and bladder. I filed a lawsuit against the property owner and the company responsible for cutting the railing. A jury awarded me approximately $3 million in non-economic damages, but this was automatically reduced to $695,000 because of the cap. $695,000 for an injury that was due to someone else's negligence, yet affects me every minute of every day and will for the rest of my life. There's no cap on the struggles I deal with daily from a wheelchair, or the bowel, bladder, and kidney infections I deal with due to having to use a catheter, or the guilt and heartbreak I feel telling my 7-year-old she can't sit on my lap because my pain is so severe, or explaining to her why I can't go be a chaperone on her school field trip to the pumpkin patch. Why should there be a cap on my compensation? I'm sharing my story with you today, knowing that it will have no bearing on my life, but hoping it will urge you to report favorably on HB 113. Thank you.
Thank you, Mr. Chairman, Madam Vice Chair, members of the committee. My name is George Tolley. I'm a trial lawyer. Trial lawyers are here asking for a favorable report on House Bill 113 because we're the ones that tell your constituents, that tell folks in Maryland who have been catastrophically injured that the cap exists, because most of them don't know. We're the ones that have to explain that their rights to a jury trial have been impaired, that what the jury decides based on the evidence in an individual case is not going to happen, not because the judge thinks it's wrong, but because the legislature 38 years ago chose a number, an arbitrary number. And that number has changed over time. You'll hear, oh, it goes up every year. An arbitrary number that increases by an arbitrary amount every year is still arbitrary. We all have stories to tell, and we could fill the record with those stories. The important thing, the right to jury trial, I would add to what you've heard already, is actually in the Bill of Rights twice. It's the only right we have as citizens in the United States that's in the Constitution 2 times, in the 6th and 7th, or maybe the 8th. I'm not going to arm wrestle Chris Norman about which amendment it is, but it's in there twice. The states that don't have caps, as Mr. Yost pointed out, Marylanders go to those states. If they're injured, then no, there is no cap. If Maryland businesses like Marriott have a hotel outside of Maryland, which of course they do, they build those hotels knowing that if something happens there because of negligence, sexual assault, whatever it is, they're responsible for all of the damage, whatever a jury might decide. The my time is up, so I ask for a favorable report. Thank you very much.
Vice Chair.
Mr. Moronic?
Mr. Moronic.
Mr. Moronic is here. Mr. Moronic, please, for 2 minutes.
Thank you, Mr. Chair, Madam Vice Chair. This is a matter of justice. This is a situation where so many of our neighboring states have this justice and we don't. It's really ironic that you could be, in my practice, Moronic Law LLC, where we do criminal defense and personal injury matters. One of our offices is in Ocean City. It's interesting because you can drive just a few blocks up Coastal Highway and find yourself in Delaware. And the difference between someone's life changing for the better is just a few blocks. Think about that. When you think of somebody who's catastrophically injured, their life as they knew it is gone. They can't do the things that they would have done in the past because they don't have the same justice. But yet just a few blocks away, they go from having some semblance of a life, being able to have money to meet their needs and be able to have money left over. But you go down the street to beautiful Ocean City, and unfortunately, because the laws in Maryland are a little different than the laws in Fenwick Island, you don't have that same justice. And that's just one of the states, Delaware. We could look at New York. We could look at Florida. Pick any number of states that don't have these caps. The insurance companies don't have the same fears in Maryland because they know where it ends. And this bill will finally change that. I ask for a favorable report. Thank you.
Thank you, Mr. Chair. So, as promised, I have questions for this panel. So, everyone, thank you for your testimony. My question is, because I hadn't actually thought about it this way, is it the remitterer that's the problem? And should we be looking at that angle? Because it sounds to me that even the states that have a that do not have a whether you have the cap or not, a remitterer is possible. And therefore, your award may be large, but it could possibly be reduced. So I have two questions. That was one. And then I have another question, and that is if you could explain the remitterer process. Is it a whole nother hearing, and how does that work?
All right.
Thank you.
Thank you for the question, because it is important. The process that we're talking about, someone is injured, they bring a lawsuit, the defendant responds, there's maybe an effort to resolve the case, and it doesn't get resolved, the case goes to trial. At trial, there's evidence, and the plaintiff has the burden of proof. The injured party has to bring evidence to court to prove not just that the defendant did something wrong, but also what are their injuries and damages. And the jury and the judge hear all of that evidence in that individual case, and the jury comes up with a number. If they find that there was negligence and that the negligence caused harm, they come up with a number that will compensate the plaintiff for the injuries in that case. And a remittitor is a reflection that the judge finds the number the jury chose to be so high as to be evidence that they were carried away by their emotions or otherwise shocked the conscience of the court, which is the term of phrase, it's an ancient term of phrase. In what a cap does, a cap doesn't care about the evidence in the case. The cap is just the number that the legislature picked. And so you can have a remittitor from $10,000 to $5,000 because all that happened was the plaintiff hurt their foot for 3 weeks and had a little bit of care, and it's not a catastrophic injury case, but you have a remittitor because the number the jury picked was too high in that case, far below the cap. But that's not why we're here. We're here because in cases like Ms. Rogers and the others that you've heard, and the others that you've heard in the past, where children are run over by delivery vans, and there's plenty of insurance, but the number that this legislature has in the law is just too low.
Okay, you had me at, CAP doesn't care about the facts. That's very helpful. So the second part of my question is, how is the remitter? Is there a motion that is filed?
There is.
So it's an active, it's something actively that has to be done by the other party.
The defendant will file a motion under Maryland practice, and I also don't know what the rules are in all 50 states in that regard, but in Maryland, the defendant asks for a new trial or in the alternative for a remitter of the verdict on damages, which gives the trial court a choice, or gives the plaintiff a choice. The trial judge decides whether the court's conscience is shocked or not. And if the court's conscience is shocked, the judge will enter an order granting a new trial conditioned on whether the plaintiff will accept a lower number that doesn't shock the judge's conscience. And the plaintiff then has the choice to take the lower number or, consistent with the constitutional right to have your damages decided by a jury, go to just try the damages part of the case again before a new jury. And that can happen more than once. Each time, the court is getting more information about what jurors in that jurisdiction feel is appropriate for compensation, but the plaintiff gets to choose. They get to choose, is that number acceptable? And it looks like settlement negotiations, but it's different. Mm-hmm. And if you don't like that number, you can go and try it again.
Okay, thank you. That's helpful since we are, throwing the words around. I wanted to make sure we understood exactly what we're talking about. Thank you very much.
Thank you, Mr. Chair. Hello, this question from Mr. Talley. Good to see you again.
Thank you, Delegate. Good to see you.
So my question is, would you go into more detail about what it means for businesses to, feel comfortable enough to be sued in Maryland versus other states? And are you saying that they intentionally build their businesses, like you use Marriott, for example, brand new building in Bethesda? Are you saying it's more likely for them to come here to build their headquarters versus, say, Virginia? Just kind of delve on that a little deeper for me.
So I can't speak for every business in the state of Maryland. There are a couple things I can say in response to your question, and hopefully they're helpful. The comptroller did a study for a year on the state of the Maryland economy. It's a 150-page report. She or her staff interviewed business leaders and industry leaders throughout the state, trying to figure out what's important, what's not, what are we doing right, and what are we doing wrong. And in all 150 pages of that report, nobody said the cap had anything to do with anything. Nobody said it's important to them that Maryland even has a cap. Mm-hmm. All right. What they did talk about is that we have a highly educated workforce, that we have access to natural resources, that we have transportation and infrastructure, that we have the things that Maryland has, not the law that limits damages. And that's reflected in, and there's been testimony, and Amazon was looking for some place to put their second headquarters. They didn't pick the state that has a cap that applies to everything they do. They picked a state that has no cap, Virginia, to put their headquarters. When businesses, if two Marylanders, we talk about two Marylanders in a car accident. Mm-hmm. If the car accident is in Delaware, there's no cap. Doesn't matter that they're from Maryland. The Maryland insurance covers you even if you go out of state.
Sure.
In terms of the effect of repealing the cap on businesses that have appropriate insurance, insurance companies, this gets to Delegate Phillips' question to the last panel too. There's a duty that insurance companies have to protect their insureds from the kind of excess liability that Delegate Conaway was talking about, right? If you've got $1 million in insurance, maybe you've got an umbrella policy, your insurance company has to try to settle the case within those insurance limits rather than saying, well, I'm only liable for the first $1 million, so go roll the dice with the jury and expose you to $2 or $3 million in liability that now you're on the hook for something that the insurance company could have protected you from. We call that, in shorthand, we call that bad faith. And when an insurance company acts in bad faith, then the insurance company pays the whole $3 million. Not they don't put you, you can say, you didn't protect me, you were wrong. And because you didn't satisfy your duty to protect me, not you personally, Delegate Conway, but because the insurance company didn't protect you, they're on the hook for the consequences, just like any negligence action, you're on the hook for the negligent harm that you cause. And so for a business, if a business is appropriately insured, it shouldn't matter what the cap is, other than to their insurance company about what the potential negative effect of a large verdict might be, which would increase, it seems to me, their incentive to protect you from that. I'm not going to say that insurance rates won't go up. Insurance rates went up for most everybody in the state in their auto. We didn't repeal the cap last year, but insurance rates went up anyway. I'm answering, this is a very long answer, and maybe I'm straying too far afield, but if you watch the briefings that MAIF has been doing in the insurance committees, they explain that rates are going up because people driving after the pandemic are just causing more damage, and rates are going up to cover the fact that across the country there's more vehicular damage being done because people are driving faster and so forth. During the pandemic, when nobody was driving, rates went down for everybody. It's a reflection not of verdicts in individual cases or runaway juries. It's a reflection of overall what's the state of damages in the United States.
Okay, let me add one piece to the question. Sure. If a business picks Maryland for their headquarters, right, they're only going to get the cap for the harm they cause in Maryland. The person falls down in the hotel in Maryland, not outside of Maryland. It doesn't matter. So the same thing for a helicopter. If the helicopter's engine is defectively manufactured in Pennsylvania, and that's where the company is, the last thing that happens is where the person gets hurt. That's whose law applies. So even if people pick Maryland to have their headquarters, as soon as they do something and somebody gets hurt outside of Maryland, that state's law applies, not Maryland's law.
Okay.
That's true in many instances. Different states, again, have different choice of law questions, and so it gets complicated that way too.
This is all complicated, so we appreciate you for your responses. Thank you, Mr. Chair.
Thank you, Mr. Chair. And again, another heart-wrenching story, and that's always the most difficult part to hear. And the two cases we've heard so far are two very black and white cases. I mean, it is pretty obvious that the damage had occurred during the event. But how does an insurance company determine those gray area sort of incidents? Because I'm a mental health therapist. So let's say someone says that they're now suffering from post-traumatic stress disorder, but how do we know that trauma didn't start in childhood or there were some pre-existing issues that contributed to the event?
In every case. If I may, Delegate, if I may, as a lawyer who tries a lot of cases, I will say the answer to that is it depends on the trial itself. We have an amazing jury system. The jury is able to listen to the facts of the case. They're able to make those determinations as far as what case is the gray area and what case is the black and white. And they're going to consider all the facts that are put out. They're going to consider the arguments of the different sides, and they'll be able to make that decision. And what this does is it provides them that opportunity, if they feel it's right to do so, to make an award that will actually stand.
If I can add to that, even before the trial, the plaintiff has the burden of proof. The plaintiff has to bring evidence to prove that what they say is true is actually true. And so the injured person or the injured person and their lawyer, if they hire a lawyer, has to send the information or the documents, the medical records, the psychiatric evaluations, this and so forth, to the insurance company to say, this is what happened to me, and this is how I know it happened from the accident. And the insurance company, if it chooses to do so, can ask for an independent evaluation of the plaintiff with their own psychiatrist to say, well, let's check and see what your people say is true. That all happens in the context of litigation before there's a trial, so that everyone who goes to the trial knows what the plaintiff's doctor said, what the defendant's doctor said, and then the insurance company, they have centuries of experience doing this, evaluate that evidence and make a risk determination about what's likely the damage in the case. Does that help?
It does, it helps. I mean, it's, obviously in my mind, I'm thinking, okay, this person may have had a pre-existing physical injury, a back injury, and now all of a sudden, this event happened and now they're,
And they're complaining about pain in the same place. And the question in a case like that is the pre-existing condition, which isn't the defendant's fault, made worse in a measurable way? And the plaintiff has to prove that that's true. Or is it just the same injury and the negligence didn't make any difference?
Yep. Okay, thank you.
Thank you, Mr. Chair. Is there a standard formula or metric that's used by juries to determine awards?
I don't believe so.
There's nothing.
I believe that lawyers like to use metrics when we talk to each other in negotiations, but I don't think, we don't share those with the juries, we can't. And I think the juries wrestle with that question. They are chosen from the community to listen to the evidence and come to a unanimous verdict, and their verdict has to be a verdict they all agree on. So it isn't just one opinion. And I think they take it very seriously. But I'm not aware that there's certainly no, and we could provide you with what the standard jury instructions are. There's no formula in those instructions.
Okay, and I have a couple other questions. We've heard several different awards where the juries have awarded, huge amounts or large amounts, and then a remitter gets involved and those amounts are lowered, even lower than the cap, because the cap is somewhere around, is it $890?
Depending on what kind of case it is, but the cap for a personal injury claim that's not med-mal and not against a state or local government agency that happens in calendar year 2024 after October 1st of last year, the cap is $950,000.
So $950. So if a remitter comes back and says, it's $500,000 instead. How was the cap influential in that decision?
It may not be. It may not be at all. Every case is going to be different, but the jury isn't informed of the cap ever. So the jury, when they wrestle, getting back to your last question, when they try to figure out what the number is, they don't have any information that there even is a cap, let alone what the number is.
Right.
So they're basing it all on the evidence in the case.
I get that, but the remitter.
Yeah, the remitter. So some judges.
That process. And
I've had the experience where a judge in a judge trial. So it's not always a jury. Sometimes the judge decides.
Yeah.
Where the judge's verdict was the wrongful death was the result of negligence, and the damages are going to be the cap. And in that instance, the judge knew what the cap was, obviously.
Right.
So the cap can affect it in an individual case when the judge is aware of it and the judge is the fact finder. When the jury is a fact finder and the judge makes a decision about remitter that doesn't seem to have a relationship to the cap, my guess is the cap has no effect on that.
So
that it was the evidence in the case that mattered.
whether we remove the caps or not, they may not be influential in the final award.
I think for the vast majority of non-catastrophic cases, the cap is irrelevant.
Okay.
Right? It's the catastrophic cases
Yeah.
that's really unfair.
I get it. And May I? Just, it is briefly. Are lawyers' fees tied to the award normally?
Plaintiffs' attorneys generally can be hired in a couple of different ways. You can pay me by the hour, but that's expensive, and most of my clients don't have a bank account full of money they've been saving up because they might need a lawyer someday. You pay also by contingency, where I, or any of my colleagues, agree to advance the costs of investigating your case to determine whether the evidence even is there to prove what you say. And that goes all the way through trial. And we only get paid for our time if there is a recovery for the client.
Right.
And so if the jury says, no, we don't get anything. And if the jury says, yes, we can get a percentage, that percentage is not set by law or otherwise, so we don't collude on it. But I think that generally in a personal injury case, car crash, something like that, is 33% or one-third.
And it normally comes out of the final award then? So
It would ultimately come out of whatever the final award is after everything is said and done, all the adjustments that need to be made.
Thank you.
Thank you, Mr. Chairman. Thank you, panel. As I recall, when you go to the jury trial, it bumps up to 40%, or at least that was back in the day. But anyway, this, when a company has more than 500 employees, what's the cap for a Title VII civil rights discrimination claim?
I don't know the answer to that.
That's $300,000.
Okay.
And so you brought up, you could sue the company, but you brought up the insurance company. You brought that up after I brought that up. And you didn't mention that the cost of vehicles is driving up the insurance premiums. But in reference to the lead paint example, how many lead paint manufacturers were the defendants?
Can I answer that question?
No, I think he's asking about Karen.
It wasn't the manufacturer, it was the property owner and management company.
So for failure to check for lead paint?
For keeping the property in a condition that violated the Baltimore City Housing Code, with deteriorated lead paint.
And so that was capped?
That was capped, yes.
Yes, okay. And, well, that's good enough. Thank you very much.
Yes. My first question, and thank you, Ms. Rogers, for sharing your story. It really touched me because as a person with cerebral palsy, I know living with a disability is not easy. But we've been throwing out a lot of numbers here and the cap and this and that. I was just wondering if you could detail the real world consequences of the cap for you, because you got $3 million, but you actually only got awarded $695,000. And I think it's important for my colleagues to understand the real world consequences of the cap. So if there are any consequences, like something you couldn't purchase or whatever, please let us know. And also, my second question is for Mr. Tully, and I'm just going to get them out, and then Ms. Rogers can answer and you can answer. The American Property and Casualty Association fears nuclear verdicts and lawsuits, and it would just be terrible. But along the lines of Delegate Taylor's questions, aren't you rather judicious about which cases you take? Because if you lose a case, you eat your shirt because you have to pay all the expenses and you lose all that time. So don't you think people would still be judicious even without the cap in terms of what they take?
I'll have Ms. Rogers respond first.
It's hard to. I'm gonna be honest. I'm finding your question a little bit difficult because it's hard to quantify, really. I mean, there are special circumstances that I need for certain things, like I can't always just use street parking, for instance. I might have to go to a garage because I have a ramp van. So street parking doesn't always allow for safe exit and entrance to my vehicle. Something that most people would think would fall under insurance. my insurance company doesn't qualify me, doesn't see me qualify as disabled enough to qualify for an electric wheelchair. So if I would want to save my body, save my shoulders, because I have repetitive stress injuries from my shoulders and my elbows, my hands, I would have to pay for that out of pocket versus my insurance company paying for it. Huge difference, as I'm sure you know, that in wheelchairs. I mean, I could get a manual wheelchair for a few $1,000s versus upwards of about $20,000 for an electric wheelchair. And since I don't believe that that is something that would fall under the the damages, because that's, insurance is taken into account for that. My mother and I are going to a concert this summer, and there are only seats in certain areas of places. Most of those seats are better seats. I'm forced to buy those better seats. I'm forced to pay the higher price for those seats if I want to go to that concert, if I want to live a life, if I want to, just do the things that everybody else is doing. I don't get to sit in the $70 seats. I get to pay, I have to pay $125 or $150 for those better seats. It's just the little things.
Thank you, Mr. Tully.
Thank you.
Mr. Tully? Oh, I had asked Mr. Tully a question.
No, yeah, just very briefly, Mr. Chairman. So it's certainly true that we have to be judicious. I heard you ask about the APCIA's concern about nuclear verdicts. Repealing the cap won't change the amount of the verdicts in cases because the jury gets no information about the cap. So we don't have a history of $100 million cases in Maryland happening all the time, and I don't expect that to change if the cap were repealed. As far as lawyers being careful, taking on cases, we do, at least I do. I can't speak to everybody, but I want to be sure that we're not using the money of the firm and my partners to investigate a case that doesn't have merit. And so for the most part, we proceed with caution, and the cases that we take to trial are cases that, for whatever reason, there's a disagreement about the strength of the evidence. Every time there's a loss and the plaintiff gets nothing, if it's a contingency fee arrangement, then the plaintiff's firm gets nothing. That's part of the bargain. And it's usually written into every retainer agreement.
Thank you, Mr. Chair.
Thank you, Mr. Chair. And Mr. Talia, this is going to be for you. And I don't practice in this area, and so
Understood.
I'm going to ask some questions, and you all have been great in the past. You just mentioned something that will help me as well. Can you mention the number of cases where a jury has exceeded the cap, or at least give me some anecdotal evidence of, is this something that juries do often? Where do we stand with that?
It's very, very difficult to gather the data that you're asking about, in part because when the jury returns a verdict, and this has happened to me, I had a case where the jury returned a verdict of non-economic damages far in excess of the cap. The jury was excused, and 90 seconds later, the judge reduced that number to the cap because the defense lawyer made an oral motion, didn't wait 2 weeks. So when the clerk entered the verdict as a judgment, it did not reflect that the verdict had been high and was reduced. It was just a judgment for the amount of the cap. The only way to know that the verdict was initially higher and was reduced to the cap would be to go into that particular court file in that particular courthouse, because it's not available online, and look at the verdict sheet. And to do that for every case that goes to trial in Maryland going back, I don't know how long you want me to go back, that's just not practical research that I believe anyone has done. And so all we're all left with is anecdotal stories.
So we would not be able to have a fair assessment of what the impact of this might have on on settlements or on verdicts. Kind of we really don't know, right?
Well,
so there's some level of uncertainty.
I'll borrow a line from Mr. Enton, who testified last year that it would be his expectation that if the cap were repealed, more cases would settle.
Okay.
And I agree with that. So I don't think that's a point of contention. I don't think that's a controversial opinion. As far, and if cases are settling, they're settling typically within the resources of the defendant and for a value that the plaintiff feels is fair given their injuries. The issues of trial is, it's not predictable. And, we can't cover every possible permutation of that. But for the most part, juries in Maryland are not returning massively huge verdicts.
And that's what I was trying to understand.
And frankly, I don't think that necessarily the evidence is that juries around the country are doing so, or it'd be in the papers every day, and it's not. There are verdicts that are very, very high. I don't want to, but some of those include punitive damages. Not to complicate this conversation, the largest verdict I'm aware of is over $4 billion. It included an enormous punitive damages award. It was paid by Johnson & Johnson, and they didn't blink. They didn't dim the lights for a day. So, the large numbers are daunting. That's a number bigger than the current deficit some of the other committees are worried about. So, and yet they're still making drugs. So the numbers are certainly big and scary sometimes. But each case is different, and part of what we take into account is how much insurance coverage there is. Because getting to an easier and less traumatic and less risky result is usually in our client's interest.
And I understand that. I got another question really about insurance and insurance rates. Currently, well, I'll get there. We don't tell a jury that we have caps.
Absolutely true.
Right? In some states, they do tell juries that there is a cap.
So I'm not aware of any states where that is. It used to be the rule in West Virginia, you could tell them, but that was changed. It used to be the rule in Maryland. Well, it was unclear in Maryland initially, and then it was changed in 1989.
What's the logic so my colleagues understand?
Why, whether to tell them or not?
Yes.
So the initial thought, the law says that the verdict shall not exceed what the cap is. And the initial thought was, well, you have to tell the jury what the cap is in order so that the verdict doesn't exceed it. Folks who are going to come up here maybe can explain better than me why they didn't want that. And so they asked for the jury to be not told what the cap is. And that's what they got in 1989. I think the rationale is that a jury, if they know that there's a cap on non-economic damages, would factor that into their verdict on other aspects of the claim like economic damages. Because what they want to do is justice. And if there's an unjust limit on non-economic damages, they'll make it up somewhere else, and that would mean more money for the plaintiff than the insurance company might otherwise have to pay. But maybe they've got a different reason. That's my understanding of it.
And then my last question, if I could, my last question is and you can address this because I'm sure your colleagues on the other side are going to do this. The number and the dollar value of settlements, do they affect insurance rates?
I think the answer to that has to be yes. If there were no payouts, insurance companies would not have to take premiums. And we saw in the pandemic when people were at home and not driving, rates went down because there were fewer accidents, less need for the money. And then when people started driving again, rates went back up. But
let me ask you, would this in any way increase the number or the dollar amount of settlements?
I think by and large, if the question is are we gonna see a 20% jump in rates in Maryland? I don't know what assumptions underlie that. They did a study, but they won't share it with us anyway. Maybe they've shared it with you. The numbers seem incredible because 39 states in the District of Columbia have no cap, haven't had a cap. We've got a cap for almost 4 decades.
No, that's not, I'm just asking, and I really just want to know, does this increase the number or the dollar amounts in states that have done it, has increased the number of settlements or cases or the dollar amounts in general?
I don't know if this answers your question. The evidence that I can give you is that in the states where caps like this have been declared unconstitutional and they're gone like that, there's no evidence at all, and I've looked, that rates went up at all, or that there was a crisis, or that anybody really complained.
Okay.
I forget who it was. I provided somebody with the example in Oklahoma where the cap was declared unconstitutional by their court, and the Oklahoman, the newspaper did an article about how the legislature kept passing these unconstitutional laws, and the court had to strike them all down over and over again, but didn't say in the news reporting that there was anything bad happened when the cap was declared unconstitutional. It was really kind of, can you believe they even passed that unconstitutional law? I hope that answers your question.
Not quite, but it's okay.
Delegate Boucher.
Thank you, Chairman. If a defendant is negligent, is it not within the discretion of the judge to increase the punitive damages to compensate the cap on the economic damages? And is that what happens?
That never happens. So let me tell you, and I didn't mean to bring up punitive damages, but I guess I did. In Maryland, the standard for punitive damages is actual malice. That's a finding the jury has to make. The judge can't make it.
But if they find it?
They almost never do.
Okay.
Because it requires that, first of all, that the plaintiff and the defendant knew, or the defendant knew the plaintiff before the accident. There has to be ill will or spite or some, it's a very, very, very hard standard to prove.
Thanks for explaining.
So a drunk driver, 5-time drunk driver, driving without a license, overrides the interlock device and gets on the road and rear ends up, this is a real case, a reverend, his wife, and his daughter in the back seat, kills the daughter. Well, there's no punitive damages in a case like that because the drunk didn't hate or have actual malice toward the people he hit. And so the judge can't find punitive damages, even in a case like that, to offset the injustice, which I think is what you're getting at, and say, well, I'm going to make up for the fact that there's a cap by giving you punitive damages. That's
Thank
not
you
how
very
it works.
much.
Thank you.
Conway, 30 seconds, second bite.
Yes, sir. Could the jury verdict amount be described as a recovery for the client before the cap and for the second witness from the end? Do the attorneys tell their clients the cap amount in the case up front upon taking the case?
So I guess would you like to answer the first question?
Was that for me or for?
The first question?
It's 2 different questions, but one is specific for the lady at the.
Could you repeat the first question? She didn't hear it. Thank you.
Could the jury verdict amount be described as a recovery for a client before the cap? In other words, if the jury says somebody is awarded $20 million, but it's capped at $200,000, could you say I got them back $20 million? The second one is, do the attorneys tell their clients the cap in their case up front when they take the case?
I wouldn't call it a recovery. I would call it a verdict. The verdict was X, whatever the X is, the large number. That was the X. The recovery is the actual amount recovered, whether it's from the insurance company or otherwise, for the client. That's the recovery. And the verdict may be different than the recovery for lots of reasons, one of which is the cap.
But it could be described as that.
I mean, you can call it anything you want.
I don't want to take up, I don't
Yeah,
want to annoy the
and then the second thing is, yes, I think we tell our clients what caps are.
Up front?
I mean, it may not be the first thing that comes up, but at some point.
Wait, you said that at the end, you had to explain to the man why his verdict was dropped down. And you explained that he could not understand it. So if you told a client,
I'm happy to explain
all you can get is 30,000 or 50,000, they would know that up front, right?
So let me explain. Yes, I had to truncate my comments to meet within the time. But to be clear, we prepare all of our clients for anything that can be anticipated in trial. All right. So in my preparation, yes, a cap is discussed, right? But a client is thinking, that's not going to affect me. But the weight of the cap settles on a person after a jury returns that verdict. And that's what I want to make clear. The weight is what got to him.
Sure.
He was
I've had experience in several cases and did several legal things, but I've never heard that the cap was discussed up front.
Absolutely. No, that's part of preparation. You have to tell your client what the good, the bad, and the ugly. And that's part of, the cap is included. But the weight of it hits after when you realize that this is not fair. A jury saw and heard from me, heard about my injuries, heard from my doctors. My doctors came into trial to testify on my behalf. And an arbitrary number, this arbitrary number is going to cut that. That's when the weight fell upon him. And that's when he spoke to me and said, this is not fair. This is not right. And that's why I'm here. Okay. All right.
Okay, this has been about an hour and 40 minutes. I'm not going to extend it too much longer, but I have two questions. One, building on a little bit on Delegate Phillips' question from a minute ago with regard, and it bounced around the room a little bit, and the increasing costs of insurance, which we've seen for auto and for home. Do you have statistics, and I'm sure you may not have them right now, do you have statistics that could show the increase in replacement costs for cars for property damage and putting it in the context of the increase in rates that people have seen? My point broadly being there has been an increase in the cost of a car and the cost of fixing a house. Are those increases consistent with the increases that we've seen in rates generally for the last 5 years or so? I don't know. I wouldn't imagine that you have that right now, but it would be interesting.
I'll make sure we make an effort to get you a satisfactory response to that.
Thank you. And then the second question goes to the fiscal note, which nobody picked up on. There is one, and it goes to the Transportation Trust Fund because this would impact the MTA. So if the fiscal note is an issue, would you support a cap on MTA's non-economic damages in order to avoid that?
If I may.
Yes.
The MTA is not within the State Tort Claims Act, and that was a deliberate choice by this legislature many years ago when the State Tort Claims Act was drafted. MTA took on the commercial interests of the Baltimore transit system, and the MTA has asked several times to be added to the State Tort Claims Act in 2019 and 2021. Currently, there's a bill in the Senate. In I think it's 2019, this committee voted unfavorably on capping the damages caused by the negligence of the Maryland Transit Administration. The Maryland Transit Administration, according to the fiscal notes over the years, carries hundreds of millions of dollars in liability insurance because CSX has a contract to share the rails with the Maryland Transit Administration, and if there's an accident on the rails, the MTA has to repair them. That if you cap the State Transit Administration's exposure when there's an accident, you take away CSX's bargain that they bargained in the contract that they would be, even if it's $500 million, they would be made whole. All of that said, I know they're here, or they're not here, they wrote a letter. I don't think it's warranted. The $400,000 hard cap that they're asking for is not warranted. There are no caps on the transit administrations in DC. If there's a metro accident on WMATA, the only place that anybody, is limited in what they can recover is if the accident happens in Maryland. If it's in Virginia, if it's in DC, there's no cap on a WMATA accident.
Okay.
So that's my response.
Thank you very much. Seeing no further questions for this panel. It's been an hour and 40 minutes. We're going to move on.
Thank
you all very much.
Thank you very much.
We're going to go to the first panel of unfavorable witnesses. Grayson Wiggins, Carrie Silverman, Gina Rotano, Nancy Egan, and Robert Anton.
Mr. Chairman, Ms. Egan had to go up to another committee to testify.
I understand.
Mr. Collins, join us.
So you're asking for Mr. Collins? All right. Okay. Whoever would like to go first, please, Mr. Anton. We'll go from my left to my right.
Left to right? Okay, I think he wants you to go first. You want to go first? He does.
Whoever wants to go first, let's go.
Well, I'll start out, I guess. Mr. Chairman, members of the committee, Robert Anton on behalf of the American Property Casualty Insurers Association. I've met with a number of members of the committee. I think you have our handout, this document. I've walked it around today in case anybody didn't have it. It's part of Ms. Egan's written testimony. Let me just say that in my years of coming down here, if you flip this over and you see the coalition that's opposed to this bill, it's one of the broadest coalitions I've ever seen in all my years of coming down here to oppose a piece of legislation. And it's not just insurance companies. It's insurance companies, it's FedEx, it's Uber, it's UPS, the Restaurant Association of Maryland are all opposed to this legislation. And why? It's a very simple answer. It will significantly drive up the cost of insurance. Now, I would call your attention, I would mention that the Maryland Insurance Administration, when the bill was up last year in here, and it's again this year, says clearly and categorically, and it's not us saying it, this is your insurance administration saying it. It says that this bill may result in increased loss costs for insurance. To address increased loss cost, insurance generally, 1, increase rates, 2, reduce limits of liability, and 3, stop writing impacted lines of business altogether. It says that we expect the bill could adversely impact the affordability and availability of liability insurance products in the state over time. This is not us saying this. This is your insurance regulator saying it. I'll close by saying this, Mr. Chairman. If anybody on this committee thinks for 1 minute that going from a cap of $1 million to no cap whatsoever is not going to increase insurance rates, then I really wonder, how that could be. Thank you.
Mr. Chairman, members of the committee, I am Carville Collins, representing Maryland Employers for Civil Justice Reform Coalition. We are comprised of many of the largest employers, businesses, and healthcare providers in Maryland. There's been discussion about the history and the rationale for why we've had these caps in the first place. These caps have been an important public policy for more than 38 years. Back in 1985, when the state faced an acute liability crisis, task forces were formed, this issue was studied, this committee helped craft the solution. There's been suggestions all day so far that this cap amount is arbitrary. We respectfully disagree, and it is documented in that 1985 study from one of those task forces. They made a very specific recommendation about the amount of the cap. It was $250,000. This committee adjusted it to $350,000. In light of this well-studied foundation for the current caps, on non-economic damages. 2 task forces, they spent a year on this. And in light of our current economic conditions for consumers, and in light of our fiscal conditions for our state, why ever would the General Assembly want to risk inviting back the insurance crisis of 1985 by removing these caps? On the fiscal note, the chairman mentioned this, there is a material fiscal liability for the state, and the fiscal note documents it well. It's not only that it would create significantly greater awards and settlements against MTA and a lack of predictability in litigation and settling MTA cases, but what that fiscal note tells you is it's the same impact for all the rest of us, non-governmental entities, the private sector and others that are not under the Maryland Tort Claims Act, Maryland drivers, Maryland homeowners, consumers, employers, healthcare providers, insurers, all of us would be affected, and all of these groups have filed testimony for your consideration today. Thank you, Mr. Chairman.
Good afternoon, Mr. Chairman and members of the committee. My name is Kerry Silverman. I'm here today on behalf of the American Tort Reform Association. I've submitted written testimony, but I'd just like to make 3 points with you today. First is that the limit that we have in place has been in place for 40 years now, and at nearly $1 million and up to in personal injury cases and $2.4 million in wrongful death cases. It's kept up with inflation, and it provides reasonable but not unlimited compensation for the subjective part of a damage award that's on top of what may be already substantial compensation for economic losses. Anything that can be measured, that is quantifiable, is uncapped in Maryland. 2, Maryland's current level is on the higher end of state limits on non-economic damages, whether it's in personal injury cases, wrongful death cases, or medical malpractice cases. You have one of the highest limits. Third, you've heard repeatedly today, and I imagine you'll keep hearing that the cap is arbitrary. I understand that sentiment. But what is more arbitrary is the alternative. What is the alternative? The alternative with not having a limit is that plaintiffs' lawyers will ask juries who understandably struggle with placing a financial value on a person's pain and suffering to award entirely arbitrary amounts. What we see in other places without damage caps are plaintiffs' lawyers asking for a certain amount of money, $40 million, $80 million, $120 million. We see what's called the per diem, asking for $1,000 a day, $100 an hour for the rest of their life. We even see in some cases, and I can provide you citations for these, cases in which lawyers will ask juries to consider how much a professional baseball player makes, how much the defendant's CEO makes, how many miles the defendant's trucks drove that year. We've seen all of these, and that's the alternative we'll see in Maryland without having any cap on damages. Thank you.
Good afternoon, committee. Thank you so much for allowing me to be here. My name is Gina Rotuno, and I am the Regional Vice President for the Mid-Atlantic region on behalf of the National Association of Mutual Insurance Companies. NAMIC is the largest property and casualty insurance trade association in the U.S. with more than 1,300 member companies. We support regional and local mutual insurance companies as well as some of the country's largest national insurers. Our member companies write $383 billion in annual premiums nationally, and our members account for 61% of homeowners, 40% of automobile, and 25% of the business insurance markets. The longstanding non-economic damages cap has been in place for over 25 years, and its removal would significantly disrupt the stability of the insurance marketplace. Caps on damages help create a more predictable environment for modeling insurance costs, and without these caps, inconsistent and unpredictable judgments could result in outlier verdicts, creating one of the highest cost drivers to Maryland's insurance markets. The unpredictability makes it difficult for insurers to accurately model potential losses. Without these caps, it becomes increasingly difficult to maintain consistent, fair pricing for consumers, and we risk destabilizing a system that has served Maryland well. By keeping these caps in place, we ensure that juries have clear guidance, helping to prevent unpredictable, excessive damages that would affect both insurers and policyholders alike. For these reasons, we strongly oppose House Bill 113.
Mr. Williams. Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Chamber of Commerce.
I was struck by something that one of the supporters of this bill said on the initial panel, which is that this doesn't apply to doctors, so they don't need to worry. And that inherently tells me that the businesses that I represent, specifically the small businesses, do need to worry because their liability will increase under this bill. And I think to your point, Mr. Chair, the MTA is telling us there's a fiscal impact on them. That same fiscal impact will be felt by the members that make up the Chamber of Commerce. They will be felt by the businesses in your communities. That liability will have reverberating effects, I think, on the economy here in Maryland. We're talking a lot this year about economic growth. Maryland, the recent data I've seen, we were 49th in job growth. We are 44th in new business applications since 2019. We have the 46th ranked tax climate in the country. And so you've heard some of the proponents talk about other states that don't have caps. It's not an apples to apples comparison. The tax policies are different in different jurisdictions, and this is one additional factor that will play a role in the state's economy, and that will have subsequent effects on things like jobs, because the increased price of goods, the increased price of doing business in the state will make it more difficult to hire people. One of the statutes that I've talked about on this bill in years prior is negligent hiring, which is designed to promote reentry, and a bill that was put in 5 years ago, and is designed to promote reentry for returning citizens. Those types of cases will be impacted by the same liability cap removal. So for those reasons, we're concerned. Thank you, Mr. Chair.
All right, thank you very much. I'm going to ask a couple questions and we'll go around. The issue of the amount not being arbitrary, and Mr. Collins, you made the point that the work group 42 years ago set a number of $250,000, and then 5 seconds after that said, and then this committee decided to raise it to $350,000. Why did this committee decide to raise it to $350,000?
Mr. Chairman, we've looked at the bill file very carefully, and we can't discern. But we assume that in an abundance of caution, the committee exercised its discretion.
Well, I thank you for that. But at the same time, I guess, it kind of contradicts the argument that it's not an arbitrary number when there was a work group that did X, and then $100,000 later, the number just changed. This number is a number that it's either a number that we choose or there's a lack of a cap. What seems clearer to me is that it's a question, it's just a policy question as to whether we think there should be a cap or not, or how much that cap should be. Is that right?
That's a fair point, Mr. Chairman, but let me submit this to you, that the work of those task forces, and this particular task force was the executive branch task force chaired by Joe Curran, who at that time was Lieutenant Governor, also a former Attorney General, and also a former committee chair of the Senate Judicial Proceedings Committee. That task force looked at what was the extent and nature of the risks, what was the problem, what were the quantities of the verdicts, the awards, and they made their best assessment of what cap would be sufficient to address the problem that was occurring in the mid-1980s, an acute insurance crisis. It was a crisis of both affordability and availability of liability insurance. And so they came up with a number, and then subsequently, not 10 years later, the General Assembly decided, let's increase the number and let's also put an escalator on it so that it stays current. So based on what was initially a number that was developed after that 1 year of study, the number has attempted to keep up, and so I think there is a rational basis. There was a concerted effort to identify a specific number. Yes, the General Assembly did adjust it, probably erring on the side of caution, but it is close to the number that was originally recommended.
And if I could, Mr. Chairman, just very quickly say that one of the keys was that they added an increase, an annual increase, and if you take the rate of inflation from 1994 up to today, and you increased it by the rate of inflation, you'd be at $1,002,000. So it's kept pace with inflation, that number.
So I'm going to go to Ms. Rotunno, because during your comments you said that this provides clear guidance to juries, but juries aren't supposed to find out about this.
Fair point, Mr. Chairman.
So how does it provide clear guidance to juries if they're not supposed to know about it?
My fault.
Okay. All right. That doesn't happen very often in here. All right. Okay. I guess I go back to whether this is really a public policy question as to whether we're relying on perhaps an arbitrary or maybe not so arbitrary number, I'm not sure, or what a jury is actually looking at when they get the case. They get a case and they hear all the evidence and they can determine what they believe is the appropriate number. I mean, isn't that the appropriate public policy question for us to consider, whether we should set a number or not?
Well, let me try to answer that, Mr. Chairman.
I
practiced law for many years before I came down here to be a lobbyist. And, I think that from a public policy point of view, what the policy recognizes is that depending on the ability of the plaintiff's lawyer, depending on the ability of the lawyer who's handling the defense, and the fact that there is no way, on non-economic damages aren't capped at all. Why? Because they're quantifiable. But I think the legislature made the decision that we have to have some cap on this non-quantifiable measure of damages.
Is that just in case they just have a bad defense attorney?
I'm sorry?
Is that just in case they have a bad defense attorney?
Well,
is that your argument?
I'm just saying that, look, I know that you're involved in litigation of a different type, but you see it too. Much depends on the acumen of the lawyers on both sides, the emotion that gets presented in front of the jury, and here, while you can, quantify economic damages, it's much more difficult to quantify the non-economic damages. And that's why we decided as a matter of policy, we had to have a cap.
I don't think you mean to sort of vaguely denigrate the quality of defense attorneys in the state of Maryland. But having said that, that's kind of what that just sounded like, is that we have to make sure that there's a backstop against bad defense lawyering.
I'm telling you what the reality is. The reality is that you have 12 people.
And he doubled down on you're doubling down on it.
Are they going to quantify it?
I'm sorry. Well, I guess, okay. All right. I will stop digging, I guess, for the moment, but the vice chair has questions.
Okay. Thank you, Mr. Chair. I have a couple of questions, because what I'm hearing almost is this argument, that no caps equal an increase in insurance premiums. That's what I'm hearing almost. Okay, so if that's the case, then I need you all to fill in a blank that I literally have in my notes. It affects the rates because, and I have a blank. Now, you hit on it, ma'am, a little bit when you said the unpredictability, but can you fill in that blank? It affects the rates because of why? Because are we just assuming that because there's no cap, then the awards will be higher?
Absolutely. When you have those outliers, you have to have that predictability for risk. So insurance companies, in order to be able to predict for that risk measurement, then they'll have to, what we're assuming from this, and I think we've seen from studies we passed around, is that it would have to be able to increase it in order to predict for that coverage.
So is that what states did that have a non-economic damages cap?
I'm not sure.
Well,
Madam Vice Chair.
I need that answer.
Absolutely, I'll get that for you.
Yeah, because otherwise the argument continues to be circular. So I need to fill in that blank line. So somebody's going to let me know if those other states and some data on whether that the non-economic damages states, cap states, have actually increased their insurance premium. The other thing is, and this is for Mr. Carville, or for Carville, I'm sorry, I'm so young. I don't know what was going on in 1985 that created this insurance crisis. Just briefly.
We were all young, but I happen to have been here. That was my first session, 1985, a long time ago. But What happened was, according to the report of the task force, which has been provided to the committee previously, we will provide it again, what they observed and what caused those task forces to be created with a charge that they make a recommendation for reform and a solution very quickly, was that insurance availability and insurance affordability, there were severe problems in both categories, such that institutions in Maryland were not able to get insurance. Institutions in Maryland were closing. Institutions in Maryland were changing their mission, changing their activities. It was that serious.
Okay, so that confuses me even more because as a result of the task force, there was a raise in the non-economic damages cap, right?
Actually, Delegate, as a result of the task force, the first cap was instituted.
Because there wasn't a cap before.
That's correct.
Okay, I get it now. I get it now.
Before that, there was no cap.
Yeah, I got it. Okay, so one more thing is, do any of you, does anybody practice now as defense counsel? Nobody?
We do have several defense counsel behind us.
Are they coming up?
Yes, they'll be coming up.
Okay. All right, I'll ask them my question. Thank you so much.
Just for the record, I saw Ms. Egan coming in, so we'll put her on the second panel here in a second. Delegate Cardin, then Tolles.
Thank you, Mr. Chair. Thank you all very much, and thanks for your patience. And I do have some sympathy for some of your arguments, but I have to ask so I think the testimony from the proponents of the bill, I believe, it's my wife calling, said that 39 other states do not have caps. Is that correct? Do you guys know? Do you guys not know? Is that okay? I'm going to assume that's correct. If that is the fact, then what is it about Maryland that makes us special in terms of the insurance market and or the increased costs that is not unique about those other 39 states or the 4/5 of our country? I'm wondering if you can answer that. And then I'm also going to give Mr. Anton or somebody else, it can be just one person, another bite at the apple, and say, if you have two very similar cases in two different jurisdictions, and one has, the jury decides $20 million, the other one, the jury just let's say in an urban district, maybe it's a higher verdict, maybe Baltimore City, a $20 million verdict. And maybe in Caroline County, a much more rural district, it might be a much smaller verdict, say $2 million. That inconsistency, is that something that you guys can suggest that might be a problem with having, or why we should have caps because it keeps everything very consistent? And I'm wondering if you can just
No, I think it adds a certain amount of consistency to the system by having the cap, number one. Number two, every state is different. Every state's insurance laws are different. It's a much different business climate. It's a much different personal climate. And, the fact that we have these caps was something that your predecessors decided. They decided back in '85, and then they came back again in '94. But no one suggested at that time that we shouldn't have any cap whatsoever. Let's just get rid of the cap. Now, I would say this to you: when you think about it, give you an example. So let's say that under the current cap, there's $1 million amount of insurance available right now. And if I'm the plaintiff's lawyer, that means, typically in the engagement agreement that you sign, the typical today, it's 1/3. It's 1/3 if it settles out of court, and it's 40% if it goes to court. That's the fee. Now, whether the cap is $1 million or $2 million or no cap at all, the amount of work is going to be the same, You're not going to, the plaintiff's lawyer is going to do the same amount of work, correct? I mean, whatever the cap is. But now, think about it, that let's say the verdict now without a cap comes back at $10 million, right? And let's say there's, the defendant has a umbrella policy. And let's say that's a, $4 million or $5 million umbrella. Now, all of a sudden, they know that instead of making a fee of, say, $300,000 or $400,000 under the current cap, now they're going to make a fee somewhere maybe between 900,000 or maybe, 1.3 million. But the workload is the same. I don't think anybody's suggesting that we should regulate the contingent fees that plaintiffs' lawyers charge. But that's part of what happens. And the atmosphere in one state is different than the atmosphere in another state. The only thing I would tell you is that in Maryland, we have a very robust Maryland Insurance Administration, and they're the ones that are saying that regardless of what happens in other states, in the state of Maryland, premiums will go up if you pass this bill, period. I rest my case.
So I'm going to, adding a question to Delegate Cardin. So, and kind of riffing off a question I asked before of the other side, looking at surrounding states, I asked a question about remittitor to representatives from the trial lawyers. Are there other standards, other case law, other, dare I call them guardrails, in place that lessen the likelihood of large verdicts in states that don't have a cap on non-economic damages? I'm looking at immediately surrounding us, Pennsylvania, Delaware, Virginia. I mean, are there things that impact remittitor, impact different standards that could explain why the cap doesn't have the impact that you say it does?
Mr. Chairman, I'll attempt to address that. So we did hear a lot about remittitor today. And it was characterized as happening all the time. We respectfully disagree. What the proponents have omitted from this characterization of remittitor is that the standard for remittitor is profoundly high in Maryland. And thus the incidence of remittitor is extremely rare. The Supreme Court of Maryland established the high standard. It's been mentioned here that the verdict must be grossly excessive, not just excessive, grossly excessive, or the other test, as Mr. Tolley correctly referenced, shock the conscience of the trial judge. Those are the standards. We submit, based on experience in Maryland, this idea that remittitor would serve as a readily available safeguard or a cure for excessive verdicts in Maryland, we submit that has no basis in fact or law. It's extremely rare. So first and foremost, as a safeguard, it's not available.
So would you get back to the committee as to what the standards are in Pennsylvania and Delaware, Virginia and West Virginia?
We can do that.
Happy to do that, yes.
Right. And then going to a question which I may have inartfully put, I'm going to try and slightly more artfully put it at this time. Again, we've seen, I've had plenty of constituents talk to me about increased auto rates, increased personal property and homeowners rates. Do you have, I'm looking for information about the increase in rates and also the increase in costs to fix cars, whatever else. And I'm curious to see whether they parallel each other or whether there's a significant difference. And so to the extent that you all can provide that information, that would be helpful.
Be happy to.
Okay, thank you. Delegate Tolles, and Delegate Schmidt, and Delegate Kaufman.
Thank you, Mr. Chair. You stole my thunder, but that's okay. You the chair. You have the authority to do that. What he said, I piggyback off what he said because that was part of my my line of questioning, what other states are doing, and give us some information on that. Because you all did meet with me, and you know, thank you, madam. You you said that insurance rates would go up, period. As our chair indicated, insurance rates have gone up. So what do you mean when you say they would go up? They already have gone up.
Well, let me respond. I represent the insurance companies.
I know.
And, so I think the driving factor right now, it's causing an increase in insurance rates, is that with inflation and, post-COVID, and with the advent of electric vehicles, the cost of auto repairs have gone up significantly. Okay, and I don't care whether you have a fender bender and you're going to, because of your deductible, you're going to pay it yourself, and you go to a body repair shop, and you're going to pay much more than you've ever paid before. But I would say this to you: in the state of Maryland, okay, all the rates that we have must be actuarially sound and approved by the Maryland Insurance Administration, and they have to be based on actual claims losses. And that's what they do, and that's how they regulate us. And so they're the ones that approve the rates that we charge. And if they find that our rates are arbitrary or excessive, they will not approve them. So the rates reflect what the actual cost of claims is in the state of Maryland. And I can tell you that if, I don't know who in the room has an electric vehicle. And, we're moving to a period in, I don't know, whatever it is, 2030, whatever it is, when, everybody, auto dealers will only be able to sell electric vehicles. And I have to tell you, and you can ask your colleagues that have an electric vehicle, the cost of repairs for electric vehicles is tremendously higher than in all the other vehicles. And that's driving up cost as well. So don't think that cost, that the costs that we've seen before, wherever they are, rest assured, according to the Maryland Insurance Administration, you pass this bill, those costs will go up even more.
Well, good thing I have an old car and not an electric vehicle. So
Me too.
Yeah, so you would agree that everything, the insurance rates has gone up because the cost to fix everything and to repair everything?
That's my
So why can't caps increase? Why can't, if everything has gone up, what is the issue you have with caps? That's rhetorical. I'll leave it there.
Okay.
So I've said this to you before.
Yes.
When we met, so I'm not, I'm very real and transparent. You heard this.
Delegate, if I may, if caps were removed, what your regulators are saying, as recently as yesterday in a written statement, the Maryland Insurance Administration expects, if you remove the cap, they expect adverse impacts on availability and affordability of liability insurance over time.
Okay, well, I will wait to get that information that our chair requested, because we'll see. Thank you, Mr.
Thank you.
Chair.
Delegate Schmidt.
Thank you, Chair. That's all right. Thank you, Chair. And you've answered a number of the questions that I had here, Mr. Enton and Mr. Collins. Mr. Enton, you had brought up umbrella policy.
Right.
And this only strikes a nerve for me. Did you know public officials cannot get umbrella policies? How is this going to affect umbrella policies, and is this going to open up a market for more umbrella policies?
Yeah, once again, particularly for I think the lawyers in the room, as much as, and the business people in the room, I've had, because I'm a lawyer and I know what the exposure can be, and the umbrella policies, are I think affordable. You're going to see now, once again, without any cap at all, there's going to be an increase significant increase in the cost of trying to protect yourself by having an umbrella.
Well, you represent the Maryland Insurance Administration. What's the highest umbrella policy available?
I'm not sure. I've had one. I increased mine. I think
So
I started
did I.
out, the first one I had $1 million, and now I think I may be up to, I don't know, $3 million or something there. But once again, that's going to have this is going to have a significant impact. And, all of a sudden, you're going to have a $5 million verdict, an $8 million verdict. We're going to go from a cap of $1 million to no cap whatsoever. It could be, you know, who knows what it could be?
Yeah, I mean, I look forward to seeing what the adverse impacts or the significant impacts, because without a number, it's hard to
Once again,
correlate
you know,
that.
I'm relying on what the Maryland Insurance Administration has said. There's no reason for them whatsoever to misrepresent to this committee what's going to happen to insurance rates if you pass this bill.
Gotcha. Thank you. I'm good.
Thank you, Mr. Chair. I'm really, and you all have to help me with some statistics, if you can get them, right? Insurance rates are based on a number of things. They're based on the accidents, they're based on repair costs, they're based on, you know, people's, it'll increase based on lost time from work, all that stuff. But one of the things I know goes into the factor is the amount of settlements, the number of cases, et cetera, right? My question is, and I was saying this to the trial lawyers, they don't have this data. You guys are the industry, you probably do. So the number, when states have gone from, for those states that had caps, when they've gone from caps to no caps, what has been the impact on those states in the dollar value of settlements and the number of cases brought? Has it affected the number of cases brought? And I don't know whether it has or it hasn't, right? But I'd really like to understand that. And then if there is any data specific to those states, how has it impacted rates once they've gone? Because that transition year is the year. So if you have any data on that.
We can certainly try to find that for you, Delegate. We can try to find that data for you. But I just think common sense.
I'm asking facts, not common sense.
Okay, well, we'll try to find it for you.
Thank you.
I have a couple of questions. Mr. Enton, it's always nice to hear from you. You're one of the most gifted lobbyists
Are you
down
being
here.
sarcastic?
No, I do like you as a person. But my question is this. My state senator managed to get a similar bill through the House, Senator Waldstreicher, last year. And because of your effective advocacy, it did not lift the entire cap. It merely increased the cap. So I'm a man of the House, so of course I prefer the Ziegler approach. But could your clients live with the Waldstreicher approach that just lifted the cap?
Well, let me say this, that, you know, the quote Waldstreicher approach, unquote, increased the cap from what was then maybe 930,000 up to 1,750,000. Okay, so it was almost 100% increase, doubled the cap. When you once again look at the increase in the cost of living, going back to when the cap was bumped up to 500,000 and we added a 15,000 a year increment, we would have been at 1,000,002. I don't think the industry, you know, if you wanted to adjust the cap based on the cost of living and adjust it going forward based on the cost of living, I don't think the industry would have any problem with that.
Okay. This will be my last couple of questions on this bill, so I have a couple more. And my second question is, you keep saying that the Insurance Administration says that rates will go up, but as I understand it, they actually say may, and that's a big difference because I may find the woman of my dreams or I may not. So
what, do you want to roll the dice? I mean, you know.
And so, I just want to clarify that that's how I read the letter. They say may. My last question is for Mr. Silverman. Were you here when Ms. Rogers testified, sir? That's the woman in the wheelchair?
Oh, yes, so was.
She talked about all the different issues that she had, all the different issues that she had. She said she had kidney issues because of negligence. She said she had incontinence and catheter issues, and all these really unfortunate situations. And in your testimony, sir, you kept lamenting, how insurance companies the rates would increase so much, even though Delegate Ziegler testified that she hasn't found that. But in a case like Miss Rogers, where there's such an extensive need, isn't it appropriate for insurance companies to lose their shirt sometimes because the needs are so expensive? And if you don't want to increase the insurance, if you don't want to keep paying out those high numbers, then drop a client. But could you also see that, yes, somebody gets a big number, but that's because they need it, because the extensive injuries caused by your client?
Absolutely, Delegate. And the tort system is there to make a person whole. And people that have catastrophic injuries, lifelong injuries, and it happens a lot, ought to be fully compensated so that they can have the best life possible in their situation. And that's why we have no limit on economic damages, whether it's any medical expenses, whether it is lost income, whether it is the need to replace services because you can't do things around your house anymore and you need help. All of that should be fully covered. And in cases with people who have had catastrophic injuries, those non-economic damages could be over $100 million. We've seen those kinds of cases, and they're not capped. They shouldn't be capped, and they're not capped here. So the pain and suffering award is on top of that amount, and that's the part that we're talking about today. It's the part that we can't put a number on. There's no objective way to do it, and so we have this law that's imperfect to have some level of predictability.
Well, your client and I will just disagree on this, because when she couldn't put her daughter on her lap, I think pain and suffering is necessary. But I thank you, Mr. Chair.
Thank you. I got a question for Mr. Wiggins. What was the point you were making about returning citizens?
Yeah, I apologize, Mr. Chair. Kind of stumbled through that. So my understanding is that there is a lawsuit that can be brought for negligent hiring in Maryland. And so there was a bill 7 years ago when I was at the Maryland Department of Labor that was annually brought, and I believe Chairman Wilson had it the last couple of years, and the idea behind it was to limit liability for negligent hiring, to promote employment of returning citizens. The trial bar, the same group that supports this bill, would annually oppose that bill. And so the concern that I had was that this cap removal would apply to those types of cases too. And the point I was trying to make is that this isn't just about insurance, but there's a larger cascading effect here for different types of cases beyond things like car insurance.
Okay. Delegate Valentine, and then we're going to move on.
Thank you, Mr. Chair, and thank you, panel, for being here today. I'd also like to thank the previous panel. The very good arguments on both sides of this equation, so I just wanted to thank both. My question goes back to our DLS briefing earlier this year, and it got me to do some research of my own because I wanted to see how we got here. So at the very end of that task force liability report, their conclusion states the task force believes that the implementation and recommendations outlined in this report, meaning the cap, will appreciably improve the likelihood that affected entities in the state will be able to more easily obtain and afford general liability insurance. Is that still today a fair and accurate assessment by keeping this cap? Do you feel that if anything has changed since 1985 to today, that would still be a fair conclusion?
Delegate, I would say yes, and that's evidenced by what we've observed, which is quite simply stability in the liability insurance market. Yes, rates have gone up, rates have changed over time, but stability. not like what was the condition prior to 1985, when businesses had to stop or change their mission, or literally could not continue to function in the things that they wished to do because they couldn't get insurance or they couldn't afford it.
Prior to 1986.
And if I could just chime in very quickly, once again, if you look at the coalition membership, you'll see that that's what the business community thinks. It's not just the insurance companies.
Thank you, Mr. Chair.
All right, thank you all very much. That concludes this panel, and then the final panel, 2 hours and 30 minutes into the hearing, is Louis Campion, Nancy Egan, Steve Wise, Joseph Johnston. I'm going to say, and I think that we can stick to this, we're not going past 4 on this bill, please. So we're not going to go any further than a half hour more because we've driven everybody else crazy at this point. And I think that still will be fair with how much time each side has had. So if we want to, I don't care which side, which direction we start on. Bob, you can't testify anymore. All right, and Nancy Egan, would you like to start?
I'll start in the middle, but before I start, Delegate Kaufman, I hope you like me too, because today's my birthday. So you know I'm wishing that this bill goes unfavorable.
All right.
But,
not voting today. Okay.
I'll start my testimony now.
Go ahead.
As you know, Robert Enton testified before. I represent the American Property Casualty Insurance Association. If you look at my testimony, we represent 82% of the commercial auto market, 75% of the commercial general liability, and 66.9% of the personal auto that's written here in Maryland. My question for you all is your concern about rising cost of insurance. Yes, auto rates have been going up, and under personal auto, this we're seeing because of increased severity and increased frequency of losses. If you look at my testimony, however, you'll see that the National Association of Insurance Commissioners compared the cost of liability insurance between those states that had caps and those states that did not have caps, and the states without caps had higher cost of liability insurance in those states. Now, getting back to last year's bill, we hired an outside actuarial firm to actually try to give a specific cost of what would happen if the cap was raised from, at that time, $935,000 to $1.75 million. And I just want to give you a little bit of the impact that we found. Other liability, which would be your premises liability other than products. We're talking about commercial. Those costs could go up 12.8%. Products liability, this is for your commercial ventures. We're talking to possibly 12.4%. Private passenger auto, 19.3%. And this is specific, Delegate Bartlett, to taking off the cap, not the cost of other repairs, et cetera. And the biggest impact, and this is why you see so many members in this coalition, the cost for commercial autos, where we're going to see the biggest increase, and that is up to 30%. For that, I ask for an unfavorable report. Thank you.
Oh, go ahead. Thank you, Mr. Chairman, members of the committee. For the record, Louis Campion, Maryland Motor Truck Association, representing about 1,000 trucking companies and their suppliers around the state. And we are here in opposition to this bill, due to the tremendous rise in nuclear verdicts we have seen around the country. Right now, nuclear verdicts over $10 million, about 42% of those verdicts are non-economic damages. And to give you a sense specifically around trucking, the increase, the average award for a trucking company against a trucking company right now is $27 million. In 2012, it was $2.6 million. It has gone up more than 10 times in the last 15 years. At a time between 2000 and 2020, when the actual fatal accident rate for trucks has dropped considerably. What are the impacts? It's bankruptcy filings, right? It's businesses closing. It's unsustainable insurance premiums, where we've seen carriers like Nationwide, ENS, and Zurich who don't write truck insurance anymore. That's reality. Another outcome is staged truck accidents, typically side swipes, where we have seen approximately 90 defendants around the country, places like Louisiana, Nevada, Michigan, Washington, California, where people intentionally collide with trucks in the hope of a large award. Removing the cap will make Maryland a laboratory for similar incidents. And we heard proponents talk about the cap being arbitrary, but so are jury awards. Jury awards against trucking companies in Georgia, $280 million. Texas, $260 million. New Mexico, $165 million. And so recognizing these shocking amounts, we're actually seeing states look at tort law around the country and try to scale that back. Florida, Iowa, Montana, Texas, Wisconsin, West Virginia, all taking aim at lawsuit abuse, right? So we just encourage you to, report unfavorable on this bill. We're trying to deliver the products that our citizens need. Thank you, Mr. Chairman.
I can go. Mr. Chairman, Ms. Vice Chair, and members of the committee, my name is Joe Johnston. I am here on behalf of Maryland Defense Counsel. We asked for an unfavorable report on House Bill 113. I'm a defense attorney. I live in Baltimore County. I specialize in medical malpractice defense and personal injury litigation. I deal with the non-economic damages cap on a regular basis. The cap on non-economic damages works in allowing for predictability and certainty in resolving personal injury cases. Predictability and certainty allows for rational decision-making in civil litigation. There's been a lot of talk today about jury verdicts, but most personal injury cases never get to trial. They settle usually at mediation. There's an important distinction here between non-economics is one component of damages. The other component is economic damages. So when I go to a mediation with the client, I have to tell them, if we go to trial and we lose a trial, here are the economic damages. The past medical bills. If it's a catastrophic case, you have to consider future medical bills. The amount of money it's going to take care of that person for the rest of their life. There are things like lost wages, future lost wages. There's loss of household services. That's just economic damages. Then we get to non-economic damages. What we can tell our clients today is that the maximum cap is $950,000 if it's an individual plaintiff. If it's a wrongful death claim with multiple beneficiaries, it's $1,425,000. That allows certainty and predictability going into mediation. By eliminating the cap on non-economic damages, it invites unpredictability and uncertainty. As the defense counsel telling an individual defendant, whether it's a blue-collar worker or a corporation, if you tell them it's unpredictable what the jury verdict could be, that invites anxiety. And plaintiffs' attorneys know that, and they seize upon that. Anytime there's a prospect of a runaway jury verdict, plaintiff's attorney seizes upon that to try to extract a higher settlement at mediation. Thank you.
Mr. Wise.
Thank you, Mr. Chairman, members of the committee. My name's Steve Wise. I'm here today on behalf of MedChi, the family physicians, and a number of other provider organizations. You have our written testimony. Over the last year and a half, my friend Mr. Tolley has reminded me multiple times that med-mal is not in this bill. And on that one point, he and I agree. We are not in the bill. But you may ask them, why are you here? I'm here because I want the committee, as you deliberate this bill, to recognize that what you do here is going to be a marker for what is next. And whether that next comes through litigation, and I heard the discussion with Delegate Phillips and others about, well, this is settled law, that couldn't happen. There's been multiple cases that have taken a run at the constitutional issues around the cap. And I'm pretty certain that if you set up two caps with a wide difference between them, there'll be another run. Whether they're successful or not, I don't know. But rest assured, there will be one. Or it will come through future legislation. And I honor Delegate Ziegler's word that she has no intention of doing that. But somebody might, and somebody probably will. And when they do that, the number that you pick here or removing the cap altogether is going to be what's pointed to. So this bill, no, doesn't directly affect med-mal, but indirectly, it certainly does. So thank you, and I'm happy to take any questions.
Questions, Vice Chair?
Thank you, Mr. Chair. So we have defense lawyers now, right?
I'm a defense lawyer,
Okay.
yes, ma'am.
So you said that most of these cases settle, right?
Correct.
Okay. So I'm going to talk about the ones that don't settle. I'm going to talk about the ones that, well, let me just make sure before I make an assumption. The cases settle before trial and before any award, correct? Or before any award, I should say. So they could settle like literally on the courthouse steps, right?
That can happen, correct.
Okay. So what is the average award, if you know? Well, that's not my question for you. Hold on, I'm sorry. My apologies, Mr. Chair. I have a different question for defense attorneys. Hold on. Oh my goodness. Did I not write it down? All right. Well, my question basically for defense attorneys was going to be something in line with, given the fact that there is a remitterer, and given the fact that we know that there is a high bar for the remitterer, and given the fact that most of the cases settle, would the rise in the non-economic damages cap, what effect would it have if we were to go to, let's say, 1.75 million?
If the cap was raised to 1.75 million, I think the practical effect is it would make anyone, an individual or corporation that has insurance up to 1.75 million, more of a target for these types of cases. That's typically, I think the other plaintiffs, there are a lot of plaintiffs attorneys here today, I think they're correct, and generally they don't really have an interest in going after an individual person who doesn't have any personal assets and they've got limited insurance coverage.
Okay,
Yeah.
so my other quick question, Mr. Chair, is how often do you, as a defense lawyer, how often do you ask for a remitterer, and how often do you win? I think that was going to be my question for you.
Well, I can actually say I don't believe, well, I've had one case I've lost that was in North Carolina, but I never lost a case in Maryland. I think I've tried maybe 4 jury trials in Maryland. I've never been in the situation of remittitor. What I can tell you is it gives no, it doesn't give me any calm to know that there's remittitor. It's essentially what it is. It's a Hail Mary. You've lost the case, you got hit with a verdict, and you're going to beg for the judge's mercy to exercise his or her discretion to lower the verdict, and you've got to demonstrate that it shocks the conscience.
Right.
That's a very, very difficult burden to establish, and I believe it's an arbitrary, it's a discretionary ruling by the court. Okay. And that means on appeal, you've got to establish abuse of discretion, which is an even harder burden to prove on appeal.
Right, okay. And so those 4 awards in Maryland, about what were they? What was the average? Or can you give us some idea of those 4 awards that you received?
There were no awards. They were defense verdicts, meaning that $0. I was involved in one case that actually was tried right here.
That's right, because you said you won. I'm sorry.
Yes.
Okay.
I was tried in one case right here, actually in Anne Arundel County. This is the last case I tried in Maryland because I moved to North Carolina for a couple of years. But that was a case, actually, punitive damages was at issue because there was an allegation of actual malice. Thankfully, my client was not, he was acquitted, he was found not liable. My co-defendant, unfortunately, was not. They were found liable, and they were hit with the $6 million verdict in punitive damages, which, as I think everyone knows, punitive damages are not capped.
Right. And did the plaintiff actually receive the $6 million?
I don't know. I wasn't involved. I got out of that courtroom as quick as I could.
Gotcha.
Once they said there was going to be punitive damages awarded. So I can't say. What I can say is I think it made that case challenging to try to settle before
Okay, and those 4 cases that you won, did the plaintiffs receive any economic damages? Those 4 cases that you mentioned that you won?
No, because there was a
just
finding of
zero
no negligence, no medical malpractice, or, yeah.
Okay.
They were all medical malpractice cases, so
Okay.
there was no award of damages.
All righty, thank you so much.
You're welcome.
Delegate Tomlinson and Williams.
Thank you, Mr. Chair. My question's for Mr. Campion. I know you were trying to get through a lot, kind of with a little bit of time there. Could you just talk a little bit more about what you've seen in other states with how this is similar, with how this has worked with the trucking industry and how it's affected the trucking industry?
Sure. Thank you for the question, Delegate. So again, just to sort of reiterate some of the numbers, right? The average verdict against trucking now is over $27 million, right? In Maryland, we don't see that, right? Why? Because we have these protections. And the other thing to realize is that the cap, the primary beneficiary of the cap in the trucking industry is actually your local trucking company who never leaves the state, right? It's one who, he's your local household goods mover who only serves Maryland, or your box truck delivery guy. Your long haul truckers are impacted by all of these very high verdicts in other states because they travel interstate and they're required to carry, certain insurance minimums, and then of course, subject to the rules in those jurisdictions where they travel. So we've seen these astronomical increases, again, things like $280 million in Georgia, $260 million in Texas, $165 million in New Mexico. These are all verdicts against trucking companies. So, the cap is a great protection for local Maryland trucking companies because their exposure is much more limited.
Gotcha. Thanks.
Thank you, Mr. Chair. I have 2 questions. My first question is for Ms. Egan. Ms. Egan, you had mentioned the actuarially study, I'm not talking well today, study that was performed. You mentioned it in your written and your oral testimony. Who paid for this study that was conducted?
We did, after a request by one of the delegates, a senator asked us to go ahead and see if we could get an idea of what the costs were.
And when you say we, do you mean the coalition or?
No, we actually paid for it on behalf of the whole coalition. So APCIA asked for an outside actuarial study, just because as an industry, we would be the ones to access insurance actuaries. Thank you.
Got it. And was that something that was provided? I was trying to find it in the testimony. Is that something that you could provide to us?
We didn't have a link to that study, but I can get you a copy.
Okay, that would be great, because I know in your written testimony, you talk about how just with what was proposed last year, the predicted percentages that would go up in terms of auto insurance, commercial, and things like that, general liability, and so that would be good to see. The other question I have, with regards to a death of a child, is that considered non-economic damages? How would that be classified in a general tort case?
That would be, so you're talking about loss of pain and suffering from the loss of a child. That would be non-economic damages.
Okay. And so you're against removal of a cap in those particular situations then?
Correct.
Okay.
One of the things I do want to add, there's been a lot of questions about other states that don't have the cap. I think that's a very complicated thing to answer, because I know many members of the committee are lawyers, trained lawyers. As everyone knows who went to law school, each state has its own set of laws, so it's a whole different can of worms per state. Just as an example, the District of Columbia does not have a cap on non-economic damages. However, for a claim for wrongful death, the District of Columbia statute does not allow pain and suffering. In other words, the surviving parents who had a child who has died, they're not allowed to recover for their pain and suffering on account of the child's death. Same with respect, if a child loses a parent, there's no recovery for what are called pain and suffering damages. So that's an important nuance that I think is important in District of Columbia, whereas in Maryland, you are allowed to recover if there are 2 or more beneficiaries up to $1.4 million for just your pain and suffering from the death of a loved one.
Gotcha. And that nuance in the District of Columbia, though, that's not in a lot of states that don't have a cap at all. Most of them don't particularly splice that out, though.
In terms, right, I don't know of any other state that has, that a wrongful death claim, you're not allowed to recover non-economic damages.
Okay. Yeah, I'm barred in Virginia also, and I don't think Virginia does. So, okay, thank you.
Delegate Boucher.
Thank you, Chair. I'm a business owner, and last year I was notified by my long-term auto carrier they were no longer going to offer the commercial policy I had, and I had to go out and find another carrier. Are you saying that definitively this law would negatively impact my business and other businesses?
If you're asking me, I cannot speak to insurance rates. I don't work in the insurance industry. I represent, a lot of my clients have insurance, and they're ultimately the payers. What I can say is if, again, the more insurance you have, the bigger the target you are. If you are a mom and pop shop with very limited, you're surviving on margins and you've got a $1 million commercial liability policy, you're not going to be a big target. If you're a bigger HVAC company, you do $5 million worth of business, you've got a $5 million policy, you're going to be a bigger target if this cap is removed. Because if one of your drivers is out and they get in an accident and someone is killed, unfortunately from the accident, and there's an allegation that your driver caused the death, then that makes you, the business owner, the target.
Well, I understand that, but the fact is my carrier stopped carrying the policy. I'm wondering if there's a trend going on here, and will this exacerbate it?
Delegate Bishop, actually, I want to answer that if I can. One, I'd point to all of the businesses that are opposed to this bill as part of the coalition as an example of those concerns. And two, I mentioned, truck insurance is hard to write. It's hard to write, I get it. We have accidents, I know. Okay, but the reality is we've seen big insurers, Nationwide E&S, Zurich, who won't write truck insurance anymore. As we increase exposure, that makes the pool of companies that might write it is going to be diminished.
So it can have a negative impact upon our economy?
Absolutely.
Thank you.
That was the last question on this bill. Thank you very much. Thank you to the panels. Thank you to all of you. We spent quite a bit of time, and we're done. On House Bill 113. Now that we've finished the first bill of the day, let's move on to House Bill 977. So we're going to hear from Delegate Crosby, John Duckett, Bryna Clark Braverman, Carolyn Gramis, and Shonda Greenwell, please. Yeah.
Mr. Chair, I'll get started as everybody's still coming up.
All right, if I could ask people who are leaving the room, please leave quietly. Please leave quietly if you're leaving. Thank you. Thank you. Madam State's Attorney, you're on the second panel. Delegate Crosby for 3 minutes.
Good afternoon, Mr. Chair, Madam Vice Chair, members of the Judiciary Committee. For the record, Delegate Brian Crosby here to present House Bill 977, Jamari's Law. This legislation is named for Jamari Duckett, who was a resident of St. Mary's County. And in 2022, Jamari was killed in a car accident caused by a drunk driver who was found to be driving at speeds of 76 to 91 miles per hour in a 40 mile per hour zone. Jamari was only 18 years old. Under the current law, a first offense for manslaughter by vehicle or vessel carries a maximum sentence of 10 years in prison, while subsequent offenses carry a maximum of 15 years. Since such a crime is considered a non-violent offense, those convicted could be eligible for parole after serving as little as 1/4 of their sentence. That means that even when a person is sentenced to the maximum sentence, they can still be released from prison after only serving 2.5 years. Although the driver who killed Jamari Duckett was sentenced to the maximum 10 years, he could still be released in as little as 2.5 years, which is only about 1.5 years away. This bill would increase the maximum penalties to 20 and 30 years respectively, and it is important to note that this bill will not create a mandatory minimum. It will only give judges greater flexibility when sentencing people who are found guilty of the crime. You'll hear from many families whose loved ones were taken from them far too soon in such a brutal and violent way. I respectfully ask for a favorable opinion.
All right, yes, how you doing? I'm Jamari's dad. I came here today, you know, I was thinking about a lot of stuff to say to you guys, but I really changed up because I saw those hats on the table, and then I wore my hat, and then I heard the people in the crowd asking what were the hats for, and then they said it was for a bar mitzvah. So I was like, oh, so they celebrating life, and so the way you celebrating life, you know, you can celebrate with your kids, and the way I have to celebrate now is by memorizing my son with this and going to his grave site on his birthdays, on holidays, and like he just turned 21 a couple of months, like last month, and I had to celebrate his 21st birthday at a grave site. So I asked y'all, you know, if you guys are for this community and for the state of Maryland, I ask you guys to find this law favorable. And that's all I have to say.
How y'all doing? I'm Jamari's mom, and I was gonna read this. Shonda Greenwell. My life changed that night when a drunk driver reckless took my son Jamari away. Jamari was a bright and ambitious young black man who laid out his path to success with college as his next step, only to have a careless drunk driver block his path with a fatal blow from a truck plowing down on him, like a tank to a bicycle. He had no chance. This is reckless and disregard for life when you get behind the wheel, drunk and driving over the speed limit. That could have been you, me, your kids, parents, or grandkids in that car. And to only get 10 years and out a few years later on probation is a slap in all the family's face that has lost someone to a drunk driver. Please send a message and increase the penalty because that is what is with a vehicle. It's no different than a gun. Just a bigger bullet. I know Jamari was going to contribute to make a world a better place to live. So let's help him still accomplish his goal and pass Jamari's law. Thank you.
My name is Carolyn Gramis. I'm an assistant. My name is Carolyn Gramis. I'm an assistant state's attorney here in Anne Arundel County. This actually is playing out right now today. A case of drunk driver on Monday at 2 p.m. in the afternoon. A family from Prince George's County was here in Anne Arundel County having lunch. They left a drunk driver across the center line, and the decision right now is happening at shock trauma. The woman is paralyzed from the neck down, and they're having to withdraw life support. He is a fourth-time drunk driver. Fourth time. And I am the one talking to this family right now about what the possibilities of what's going to happen. At the moment, he's charged with life-threatening injuries because she has not died. But this is a reality of what I deal with on a daily basis. And while I recognize not every drunk driver, not every case where someone is killed in a car is going to equate a sentence of 20 years or 30 years if they have priors, but there are cases. A fourth-time drunk driver, 83, 85, 2019, and now this one. It took someone being killed for us to now say, well, now what can I do with him? So when I have to describe to them that the penalties that I can get don't equate, at what point, what is the cost of the life that is lost? The chances, the times that we have taken, that is why we need more to work with. Again, not every case warrants a sentence. But a 10-year sentence for the loss of a life, especially in circumstances where it is so reckless and continuation and for multiple times that we need more penalties to work with. The reality of serving 25% of a sentence, they're not even touching that the Department of Corrections can put someone on house arrest without even sending them into the prison system because it's considered a nonviolent crime. The hits just keep coming to families, and I ask for a favorable report.
All right, we'll stop right here and take questions. Delegate Kaufman.
Yes. Mr. Vice Chair, I have a question for you, and that is, have you had an opportunity to read the public defender's opposition? Because they say, and I'm asking you this because you're a lawyer. First of all, I understand that they tend to have a allergic reaction to any penalty enhancements, but they say that you can already get what you want accomplished in this bill due to a decision in State v. Kramer, a 1990 case. And so what do you make of their argument that your bill is not necessary because, in their views, a person can already be charged with gross negligence if they kill someone?
Well, first, I'm barely an attorney. Yes, I did go to law school, but I'm not practicing by any stretch of the imagination, nor do I want to. On that front, I mean, I do not agree. Now, I haven't read that case in particular, and I have not seen their testimony, but what I would say is I don't find that to be the case that we can already be accomplished simply because, you know, we are asking to just extend the penalty. Sure, you can still be charged with gross negligence under the law. This bill doesn't change that. What it does change is taking it, the flexibility for a judge without a mandatory minimum from 10 to 20 years. So it doubles the penalty. So I don't really follow how they think. Certainly you can still bring that charge, but that does not equate to the same penalty being levied.
Well, thank you. I think it's a good bill. Thank you, Mr. Chair.
I was just looking up State versus Kramer because I'm not aware of what that is, but what I'm looking at very quickly is that there was a charge of manslaughter as well as other charges. So I think what they're implying, and again, I haven't seen what the Public Defender's Office has written, that, and I think I talked last year when I testified, that I have to go and try and find every single thing I can think of to charge to try to get a sentence that equates to what is happening. So we take the person I'm just referenced to from Monday. Do they have insurance? All right, I can tack that on, that's a year. Do they have a valid license? All right, that's 60 days. So what I think that they're implying from looking at this case is that there's other counts that you can try to pull in and say, well, you can get a bigger sentence if you find all these other reasons. But it's not dealing with what the actual crime of the killing of that person, and I think that is where we're trying to focus on and say, what is the cost of a life?
Further questions for this panel? Thank you both for coming here again today. Thank you all for your testimony.
Yes, thank you so much.
Thank you. We're going to go to the next panel. State's Attorney is here from St. Mary's County, Jamie Sterling. Bryna Clark Braverman, who I called, I think, for the last, but you're fine. Jeffrey Heisen, Office of State's Attorney for Wacomico County. Virtually, we can go to Nancy Zuzik is here, and that'll be that, and then we'll have those people in opposition. Madam State's Attorney, please.
Thank you. Mr. Chairman, Madam Vice Chair, distinguished members of the committee, my name is Jamie Sterling. I'm the State's Attorney for St. Mary's County. I'm here today to ask for your help. First, I want to pose the question that I am often asked by victims' families. What is a life worth? What is the value of my mom, my dad, my sibling, my child's life? How would you answer that question? Because I'm left with explaining to these grieving families that the penalty for vehicular homicide is 10 years. Or the same as someone who fraudulently applied for public assistance, threatened to set a structure on fire, falsely charged $25,000 to a person's credit card, or slapped someone. Yes, these crimes carry the exact same maximum penalty as gross negligence manslaughter, where an individual kills another human being with a 3,000-pound vehicle that literally crushed the life out of another individual, someone's family member, and oftentimes beyond physical recognition. So when I meet a grieving family, I don't want to have to explain to them that their child's life by criminal justice standards is the same as if someone wrote a bad check for the car that just killed them. That is not justice. First-degree intentional homicide carries a maximum penalty of life. We all agree that these cases don't rise to the level of first-degree murder, but the penalty should still match the crime. In all these cases, defendants will only serve a quarter of the time. So with the 10-year sentence, prosecutors and judges are left with having to choose one over the other. Is it going to be rehabilitation? Are we going to touch on deterrence? Or are we just going to punish? By raising the maximum penalty to 20 years, you will allow prosecutors and judges to carefully craft a sentence that achieves all of the goals of sentencing. Appropriate punishment for the crime committed, necessary rehabilitation for drunk and drugged driving, and specific deterrence for that individual and general deterrence for the community. I started this by asking you for your help. And as a prosecutor who has served on the front lines prosecuting these cases, I am asking you to provide us with the appropriate tools to create fair and just results, not only for the victims and their grieving families, but for the drivers that will be returning to the same roads that you and I, with our loved ones, risk driving every day. What is a life worth? Please provide a favorable report.
Thank you, Mr. Chairman and members of the committee, for the opportunity to testify in support of House Bill 977, also known as Jamari's Law, to combat impaired driving. My name is Bryna Clark-Braverman. I'm the Regional Executive Director for MAD Mid-Atlantic and the chapter of Maryland. MAD thanks Delegate Crosby for championing this important legislation. For those who have not personally experienced the devastation of a crash caused by an impaired driver, it may be shocking to learn that every day in the United States, 37 people are killed and more than 1,000 are injured due to drunk driving. These figures do not account for the additional crashes caused by other impaired driving substances, such as cannabis and opioids. Since 2019, drunk driving deaths in Maryland have risen 24%, resulting in 195 preventable fatalities in 2021 alone, according to the National Highway Traffic Safety Administration. This troubling trend is part of a broader national crisis as drunk driving deaths have reached historic highs across the country. Lawmakers must act, and Jamari's Law is a crucial step in the right direction. MAD strongly supports Jamari's Law because it provides courts with the discretion to impose longer sentences in impaired driving cases that result in a fatality. To be clear, this legislation does not establish mandatory minimum sentences. Instead, it ensures that courts can deliver more appropriate penalties when an impaired driver takes an innocent life. This is essential for justice and providing closure to victims' families. Jamari's Law is a victim-centered proposal that enhances discretion while holding impaired drivers accountable for their actions. Mr. Chairman and members of the committee, thank you for your time and consideration. On behalf of MAD, we urge you to support Jamari's Law.
Yes. Good afternoon, Mr. Chair, Madam Vice Chair, esteemed members of this committee. My name is Jeffrey Eisen Jr. I'm an Assistant State's Attorney for Wacomico County on the Eastern Shore. I'm here on behalf of my office, as well as personally, to speak in favor of House Bill 977, Jamari's Law, which, as you have heard, would double the maximum penalty for incarceration. Within my job, one of the key responsibilities is prosecuting fatal motor vehicle collisions within my county. I'm part of a small team that handles the cases from start to finish. I say small because we are Wacomico County, so that team basically consists of two, including myself. As part of our responsibilities, we remain on call to respond to the scenes. We arrive there and basically we stay with the case from that initial call and to the very end. That doesn't always result in a prosecution of that person per se. We have to look at it from the beginning and evaluate from there. In the past year alone, I've had to sit across the table from countless vehicular manslaughter victims' families. These families, just in the past year, they've lost husbands, fathers, sons, daughters, as well as an infant grandchild in a case. Their lives have been changed forever, and it is against this backdrop that I have to let them know that, as the law currently stands, the maximum sentence could be 10 years. Since it's nonviolent for purpose of parole eligibility, realistically, the perpetrator would only serve about 2.5 years maximum time. I usually receive a look of disbelief because most of the times, actually all the times, they believe their family's life is worth more than 2.5 years. I have a unique perspective because I've also been where the families of the victims are sitting. In July of 2023, shortly before I joined the small team, my family and I had a similar experience. My grandfather became the victim of a vehicular manslaughter in a neighboring Dorchester County. When this happened, my world and my family's world turned upside down, knowing that my daughter would never see her great-grandfather, with whom she spent nearly every weekday with for more than 2 years, broke my heart. I therefore would ask that you all vote in favor of Jamari's Law, House Bill 977. Thank you.
Thank you. We'll hear from Nancy Suzik, who should be virtual. Ms. Zuzik? SZEWCZYK. There we go. All right. Nancy, you have 2 minutes.
Mr. Chair, I was signed up to testify against House Bill 00977.
You're testifying against?
In favor.
All right, in favor. You go ahead for 2 minutes.
Thank you. Mr. Chair, thank you for allowing me the opportunity to speak today. My name is Nancy Sepchek, and I am a concerned citizen, wife, mother of 3 daughters, and a friend of the late Jamari Duckett. I am testifying today to urge
Okay, your microphone is not connecting properly, and she can't hear me at all. Oh, boy. She isn't going to stop either, I don't think. We can't see you. Oh, boy. Can't hear you at all. Hello? Can you text her? Yeah. We can't. Trying to see if I can flag her down. We can't. Now, we can't hear you. Her headphones are the problem, I think. They're not connected, or we can't hear anything that you say. Apparently she can read what I say.
Maybe. I don't think she can read what you say. Maybe there's a chat. We're trying. Yeah, ask her to take a headphone.
So we can't hear you at all. I am very sorry for this. We can't hear you at all. And if perhaps you could disconnect your headphones or unplug your earphones from the computer and then unmute yourself again, we could try again. Is she frozen now? Oh, now she's sorry. Okay, we apologize that we heard you for the first 30 seconds. And we, of course, will we're going to take your written testimony and we will add it to the record. I do apologize for that. Are there questions for this panel? Seeing none, we thank you very much. And again, we'll be in contact with the person who was trying to testify virtually to make sure that her words are included on the record. Thank you very much. We're going to go now to the opposition. There's one person testifying in opposition, Holland Brownlee. Holland Brownlee from the Office of the Public Defender is virtual. All right, Ms. Brownlee, please, for 2 minutes.
Yes.
Go ahead for 2 minutes.
Yes, thank you. Mr. Chair and members of the committee, my name is Holly Brownlee, and I'm with the Public Defender's Office out of the Talbot County office on the Eastern Shore. HB 977 seeks to double the penalty from 10 to 20 years for nonviolent offenders who have had no intent to cause harm. We ask for an unfavorable report on this bill. This bill is named for an alcohol-related crash, but I want to be clear, despite what I've heard, that this is not a drunk driving statute. There are specific drunk driving death-related statutes that exist that are not part of this bill and already have pre-existing penalties. The statute, however, does contain an enhanced penalty for someone who did have a prior drunk driving conviction. Currently, that is set at 15 years. The current penalty of 10 years is not arbitrary or a random occurrence. It is a recognition that the person at issue had no intent to kill. There are even statutory provisions that allow certain vehicular manslaughters to be served for longer jail times at county jails instead of prisons. Again, not a coincidence. It's a recognition that unfortunately, sometimes otherwise law-abiding citizens can end up with this kind of conviction. Distracted driving, speeding, falling asleep, medical emergencies, or even running a stop sign. These are all occurrences that can happen to any of us, but which our case law says can all constitute the kind of negligent driving that would be sufficient to prove these cases. The United States has only 5% of the world's population, but yet incarcerates 25% of the world's population. Increased prison sentences do not deter crime. They do not keep Marylanders safe, and unfortunately, they can't bring back our loved ones who are lost. Instead, with a bill like this, we will waste precious resources incarcerating nonviolent offenders by applying penalties that we normally reserve for the worst kind of intentional actors in our criminal system. By way of example, accessory to a murder is still only 10 years. Regular involuntary manslaughter without a vehicle still carries 10 years. Burglary, rape, robbery, all have 15 to 20-year penalties, all intentional actions. Instead of perpetuating a system of mass incarceration, we've asked respectfully for an unfavorable report.
Thank you. Other questions? Seeing none, thank you very much. That concludes the testimony on House Bill 977. House Bill 883 is next. We're going to hear from Delegate Wims, Earl Stoddard, Patrick Kepp, Councilwoman Dawn Lutke. Robert Hill should be virtual. And that will be the list of people who have signed up to testify in favor. Mr. Stoddard, if you're leaving the room, please.
That's easy.
Thank you. All right, Delegate Wims, when you're ready, you'll have 3 minutes. See, Mr. Hill is on here. And Delegate Wims, please.
Good afternoon, Chair Kippinger, Vice Chair Bartlett, and esteemed members of the Judiciary Committee. For the record, I'm Delegate Greg Wims from Montgomery County, presenting House Bill 883, and this is my second time coming here. I was here last year pretty much with the same bill. The bill would prohibit a person from driving or operating a vehicle or vessel in a criminally negligent manner. If found guilty, the person would be charged with a misdemeanor and sentenced to imprisonment not to exceed 6 months or a fine not exceeding $5,000 or both. The current law, person needs to cause a life-threatening injury to another person as a result of an operating vehicle or vessel in a criminally negligent manner to be in violation of the law. The new provision would allow the driver to be charged with criminal negligence without harming an innocent individual. We should not wait for the outcome of a criminal negligent individual to keep our community safe. Violators of criminal negligence need to be held accountable before the next injury occurs. I have been in contact with the group that last year was opposed to this bill, and they're no longer opposed it. I'm asking for a favorable report on this bill, and before I get my first panelist to come, I wanted to tell you that the bill is called the Sergeant Kepp Act, because to my right, and he'll be the last to speak, is Sergeant Kepp, who's an outstanding officer with the Montgomery County Police, who was attempting to slow down or stop and arrest a driver who was speeding over 130 miles an hour. The driver at that time decided that he was going to try to injure, and in my case, I'm saying try to kill the officer by running directly into him. Sergeant Kemp lost both his legs. By the grace of God, shock trauma, and Walter Reed, which is now, is that the name of Walter Reed? Mm-hmm. He recuperated and he's here today and he's back on the force. Unfortunately, according to the records that we have, Maryland is one of the worst states in the nation per capita when it comes to injuries from negligent drivers. As a matter of fact, it says here that NHTSA estimates that there were 2,600 injury crashes in 23, but 110 total crashes. This bill, we think, will help slow down or curtail those crashes, curtail the injuries that are happening, like to Sergeant Kemp. And so again, we ask for a favorable report, and next will be our delegate from Montgomery County, Don Lukey. Councilman.
It's okay. I do get called Delegate Lutke now and again. Thank you, Chair Clippinger and Vice Chair Bartlett. I am here testifying in favor of House Bill 883. I am Montgomery County Councilwoman Dawn Lutke, and I respectfully ask for a favorable report. I do want to clarify, because I know we were here last year. We were here coming at this problem from a different angle last year. And so this year, I hope it is not lost on anyone, and certainly we collaborated with the Maryland State's Attorneys Association to work through some of the challenges that were surfaced last year in the separate approach we took in a different part of the criminal law code. But this does not alter the definition of criminal negligence. However, it gives us a mechanism for dealing with incredibly egregious driving behavior that, but for the grace of God, has not seriously injured someone. And I say this because under current Maryland law, there is a gap that exists. So in the case of the types of repetitive conduct, because I know the night that Pat was struck was horrific, and that person is being charged with first-degree murder, attempted murder. But I'm talking about all the other times, because that was not that driver's first time engaging in this type of conduct, nor was it the first time he was stopped. However, there was no mechanism to bring that individual before the court. This would allow that. And so, and I know I listened to yesterday's, you had a really long day here yesterday, and I've listened to some of the testimony here today. And I understand that there are folks who are concerned about overuse of potential incarceration. What this does do is force someone to have to come before the court, which can allow for other things as well, such as diversion programs and other mechanisms to try to ensure that you're getting someone off that path of destructive conduct. We see it time and time again, and we need to be very serious and very intentional about closing these gaps in order to reach our Vision Zero goals. With that, I ask for a favorable report.
Good afternoon, Chair Clippinger, Vice Chair Bartlett, members of the Judiciary Committee. My name is Earl Stoddard. I'm an Assistant Chief Administrative Officer in Montgomery County, here testifying on behalf of County Executive Mark Elrich in support of House Bill 883. Montgomery County continues to endeavor, much like the rest of the state and country, to achieve its Vision Zero goals through a combination of infrastructure changes, education, and local legislative initiatives aimed at addressing the balance of design and behavior. Unfortunately, as we all know, those efforts will always rely on roadway operators acting in good faith to follow the rules and the ways that the roadways are designed. House Bill 883 endeavors to address the consequences of individuals who should be aware but fail to perceive that the manner in which they are operating their motor vehicles creates a substantial and unjustifiable risk. It does so by creating a parallel criminal negligence pathway for motor vehicle operators that does not rely on injury or near or death to charge. It still requires the same high threshold for the establishment of criminal negligence to be established, but it allows drivers operating in a dangerous way to get in front of a judge before their actions cause irreparable harm. This is about inducing behavior change before lives are lost or severely altered. I suspect that at some point over the last few years, everyone in this room has seen someone driving in a manner that made them think that person is going to kill somebody. We cannot normalize, accept, or trivialize this type of behavior, nor can we chalk it up to just being bad drivers. Since COVID, it's only gotten worse. We've all seen that. Now is the time for us to review and ensure that there's a legal framework for establishing acceptable driving rules, behaviors, and etiquette, meeting the best interests of Maryland's roadway users, and updating the criminal negligence statute for motor vehicle drivers is an important part of that legal environment. For those reasons, we ask for a favorable report on House Bill 883.
Chair Clippinger, Vice Chair Bartlett, members of the Judiciary Committee. My name is Sergeant Patrick Kepp, Montgomery County Police Department. I want to thank you for allowing me to speak to you again today, as I've appeared before you a few times in the past. As Delegate Wims mentioned, on October 18, 2023, you all know that I was intentionally struck by a driver on northbound I-270 at Watkins Mill Road, resulting in the loss of my right leg on scene and my left leg after I was flown to shock trauma to Baltimore. First, I want to reinforce that this bill will not address the actions of that crash or that night in particular. Rather, it will enable law enforcement to prevent such a tragedy from happening to someone else. The individual I was trying to stop in October 2023 was a menace to the roadways of Montgomery and Frederick counties, endangering all those who drive on the roads in our state. I've spoken before. This committee has heard from me or in the media of the course of the conduct that the driver in my case has engaged in. All those actions, absent fleeing from the police, would have been punishable by maximum points on driving record and a $570 fine. Most traffic violations in our state are and should remain exactly that, traffic. However, when a pattern of conduct like this emerges, other situations such as intersection takeovers where drivers perform already prohibited driving acts, yet those actions result in someone getting seriously injured or killed due to a skidding car striking someone or flying debris, it comes time to file charges against those drivers for conduct that's clearly risen to a new level beyond violations of the transportation article. There are few, if any, appropriate charges that apply outside of potentially disorderly conduct, which is a stretch. There's no doubt that what repeatedly happened in 2023 rose to a level of criminal negligence that poses serious danger to life and safety of the community. In these and many other situations, individuals should know that their actions create substantial risk of harm and also should know that the actions are not what reasonable people would do. The proposed law change closes loopholes in driving behavior and provides law enforcement with one more tool in the tool belt to address situations so serious they move from the level of traffic to criminal law. The current law requires life-threatening injury in order to have criminal negligence. Why should we wait until myself or another member of our community is nearly killed to act? This bill provides intervention by way of appearing before a judge to prevent further tragedy, curb dangerous driving behavior, and provide stiffer penalties for those who continually disregard our laws and endanger community members with their driving. I encourage a favorable report.
Mr. Hill, please, for 2 minutes.
Thank you, Mr. Chairman. I want to thank Delegate Wims for his hard work on this bill. It's very important. This is Robert Hill. I'm an assistant state's attorney with Montgomery County. And this bill is all about deterrence. Right now, under this particular section, we have to wait till someone is either killed or receives a life-threatening injury. What we are proposing, we're not changing any legal standards. It's just simply now we don't have to have a person killed or injured. It's just simply the behavior itself that we're trying to deter. When I think about drivers, and I don't know, everybody I talked to in recent times has said, gosh, have you been on the Beltway and how crazy people drive? And you know, you look like it looks like a speedway. I think that the deterrence factor is all of us are familiar with the reckless driving provision in Virginia. Every time I'm at a party or something, people say, we're talking about driving, don't drive in Virginia because there's this reckless driving provision where you could go to jail. And I guarantee you that if this were to pass, word would get out in the community, and especially in the community of folks that engage in car meets where they bring out muscle cars and they drive around, and sometimes there's bets on who can drive faster and get to point A to point B. But if this passes, I believe it will be life-saving. I believe it will prevent people. People will start thinking twice about driving outrageously. And I think that it will be very important to all of us from the standpoint of just doing everyday mundane activities, driving to work. So it's a simple bill. It changes very little. And so I would ask for a favorable report. Thank you.
Questions for the panel. Delegate Conaway?
Thank you, Mr. Chairman. Thank you, Delegate and panelists, for coming in to testify. So why not just give the person 12 points, Delegate, and revoke their license, their privilege to drive?
You want to answer that?
Oh, you want to answer that?
I'm going to let,
But in this particular case, if you want to look at the one driver that we have highlighted in our testimony, they had no license.
Oh, did you say that early in the testimony?
I did not say that they had no license, but in this particular case, I will tell you that they had no license. So you can in fact be engaged in.
So that is a nuisance right there.
But yeah, that is a problem.
At 65 miles an hour, at what speed would the nuisance come into play?
A nuisance? I'm sorry.
I mean, at 65 miles an hour, what speed would the negligence come into play?
This is not a bill where there is a speed. It is the same. So the language in the bill as proposed does not change the definition of what conduct constitutes criminal negligence, the legal standard. It allows for a charge of criminal negligence where serious bodily injury has not occurred. So you can have it. Our proposal is that you would be able to charge it with or without that serious bodily injury if in fact the conduct met the legal standard already existing in Maryland law.
Okay, so the legal standard. So I'm from Baltimore. So is running bike lanes and bus lanes, you think, would that consider to be negligence?
Delegate Conway, there are traffic vehicle code violations that address that.
Okay, so I was getting back to the 12 points. So wouldn't the 12 points address the same thing? If you catch a person driving negligently over speed, you give them 12 points and revoke their privilege to drive, right?
So Delegate Conway, there is a separate, and if you look at the bill, there is also in this bill, so this is a criminal negligence charge, and there is a separate section in here that refers, we added language in this bill that specifically distinguishes this from the definition of negligent driving, which is a vehicle code violation, right? Under 21901.1 of the transportation article. Thank you, Sergeant Kep.
I'm sorry, I misunderstood the title. Thank you very much.
You're welcome.
Bill. Thank you.
You're welcome.
Thank you. And I completely understand and share your desire to strengthen the penalty. I just want to understand the thinking because we have the two standards. We have the negligent driving standard and the reckless driving standard. And either of those, you could make it a must appear and put the penalty. You could have used those as vehicles for this goal. I'm just curious, why add a third new standard? I think that would fall between the existing reckless and negligent standards. Anyway, I just want to understand the thinking of this strategy.
Funny you should ask, Delegate Embry. And actually, Mr. Hill and I had a brief exchange this morning about it. So first part of your question, there is a separate bill also sponsored by Delegate Wims and others, that deals with the transportation article, updating the reckless, negligent, and aggressive driving provisions that would include in the reckless driving provision a must appear. Okay. However, this criminal negligence would be something that's legally more significant than the reckless driving.
Okay. Really, right. Is it? Because it's wanton and willful disregard.
Wanton and willful is in there, and then this one has, I could pull it.
Oh, I'm sorry.
I might need reading glasses, however. but that this would be more egregious, right?
So you think this standard would be higher than aggressive or reckless?
Higher than reckless.
Higher than reckless.
Right, and in all seriousness, in the way this could play out, and Sergeant Kep would be better suited to speak to this than me because I don't do traffic enforcement. I'm a lawyer, not an officer. But that you could in fact charge both, and then it gets played out as it would play out in front of the court or with the state's attorney's office.
Thank you.
I believe that the traffic article, the transportation article, is better suited for individual situations. In this bill, what we're addressing, especially with regards to my situation, is a large course of conduct or something that is taken to more than just someone is speeding at such a great speed, which again, another bill deals with. This is a course of conduct that was over a period of time, not only one day, 1 month, many months, and that course of conduct repeatedly with other intervention, was it traffic citations and whatnot, there was no other ability to curb that. So we're adding another layer in something that is more it's higher up than the negligent and reckless driving of traffic to try to address that from the criminal side, because right now there is no criminal charge that allows for anything if someone drives in any way that the individual did in my case, certainly.
If I could just say one thing to Delegate Embry we're leaving the criminal negligence standard the same. All we're doing is saying that you don't have to hit somebody or cause or kill somebody in order to be guilty of driving in this manner. If you're driving a maniac in a neighborhood, maybe you're going 30 miles per hour of the speed limit, and you're weaving in out of cars. Reckless driving won't necessarily do it. It's something more than that, and we want to deter that behavior by saying, look, if you drive like this, you could go to jail.
Thank you.
All right, seeing no further questions, we thank you all very much.
Thank you, Mr. Chair.
Thank you. We'll go to those people who are opposed. Oh, that's the wrong list. Let's go over to this list. I believe it's a person, nope, Stephanie Wolf. All right. For 2 minutes.
Good afternoon, Mr. Chairman, members of the committee. My name is Stephanie Wolf from the Office of the Public Defender. Although this bill seems to create a new crime of criminally negligent driving that doesn't result in an accident or an injury, as Delegate Embry touched on, this in fact sets out an offense that's an almost perfect equivalent to reckless driving, which is already criminalized under 21901.1 of the Transportation Article. There is no practical daylight between criminal negligence as defined in this bill and reckless driving. And if there is any daylight at all, reckless driving would actually be the more culpable conduct. And so creating a new offense under the criminal law article, rather than discussing the penalties that are appropriate for 21901.1, creates several unintended consequences, and I want to talk about 3. First, allowing police officers the extremely broad discretion to arrest drivers for first-time routine traffic violations. Reckless driving is routinely charged based on all kinds of ordinary traffic violations, as I believe Delegate Conway was referring to earlier, running a stop sign, speeding, changing lanes without signaling. All of these things are routinely have tickets written for reckless driving. So giving the police the option to arrest and then search incident to arrest a driver after one of those routine traffic violations on the first offense is a really significant expansion of authority that is likely to fall most heavily on Black and brown drivers. Second, this bill would substantially increase the caseload of the Public Defender's Office, but also the courts overall, by moving a whole set of payable traffic offenses onto the jailable criminal docket, even when there is no course of conduct. I would urge the committee to make an unfavorable report, and I'd be happy to answer any questions.
Thank you for coming in to testify. So under this negligence driving, that would give the right to search the vehicle?
So this would be a criminal bill under the criminal law article. It has a maximum penalty of 6 months, which means it's not a citation offense. The police would would be an arrestable offense, and that would be even the first time for conduct that amounts to reckless driving.
And could you get that for, let's say, a high-speed lane change at maybe 90 miles an hour in a 65?
Absolutely.
Thank you very much.
Further questions? Okay, Delegate Simmons, then Phillips.
Thank you, Mr. Chair, and thank you for being here. Can you give me an example when we are talking about high-speed or reckless driving, for example, in a work zone, and how we have in the state of Maryland a lot of accidents around work zones and reckless driving, and how that can affect this type of scenario?
So I think there are already significantly increased penalties for work zones. If obviously, as we talked a lot about, if somebody is injured, there's a whole host of criminal laws that already exist. If the conduct is reckless driving that doesn't result in an accident, right now that's punishable by 6 points, which is enough to, somebody mentioned diversion programs earlier, automatically through the MVA send somebody to a driver improvement course required. and a maximum fine of $1,000, which is higher than almost all the other penalties in the traffic code. So in a work zone, I imagine that a person could be, if they had driven recklessly in that scenario, they might be looking at a higher fine, and they certainly would have a difficult time convincing a judge not to impose the points. But that is different than an offense for which somebody would need to be arrested, taken to jail, go through the bond hearing process over conduct that has for a very long time been, even for a first offense, a payable citation.
Thank you, Mr. Chair. I'm not a big fan of traffic stops, right? So I think my team over here knows me. However, I am concerned about some of the driving patterns that are taking place. In my district, on the edge of my district, in Catonsville, was a very severe accident where two individuals, first thing in the morning, were flying around 695, kind of racing each other in the middle of morning traffic, which led to several people dying who were in a work zone. If a police officer was able to, let's say, pull them over prior to the actual accident, that was pretty egregious, right? And we're seeing a lot of that. Would the OPD be willing to look at something that says if actions are, and maybe we have to define it differently, but actions are so egregious that it does kind of rise to this criminal nature before an accident occurs? Would that be something that OPD would be willing to consider?
So I am but a deputy. I cannot bind my organization, but I think the question, there's sort of two separate things embedded in that question. One is, what can an officer do when they manage to stop somebody before anything terrible has occurred? And I think that current law says you can already cite that conduct. It has a bunch of points. It has a big fine. And I think any discussion of what else the officer might need available should happen in the context of 21901.1. As to what OPD would say about that, I think, as one of your colleagues earlier said, we are rather allergic to penalty increases overall. But I think
as am I.
Yes, thank you. But the other piece of that is the example that you cite where people ultimately were injured. There are a number, perhaps an unnecessary number, of different offenses that can be charged when there is a serious injury, when there is a life-threatening injury, when somebody's driving under the influence in conjunction with bad, reckless driving behavior. Those laws absolutely already exist. So that case would certainly not go unprosecuted and is very much a jailable offense, in fact, a felony.
Okay.
Seeing no further questions for this panel, we thank you very much, and that concludes the testimony for House Bill 883. Now, House Bill 818. Delegate Ruff will be joined by Billy Murphy, Carrie Hansel, and Deborah Gardner, who should be on virtually. There are several people testifying in opposition, including one that's virtual, and we'll hear from them next. But Delegate Ruff, you have 3 minutes, and go when you're ready.
Thank you, Mr. Chair, Madam Vice Chair, and esteemed members of the House Judiciary Committee. This is House Bill 818. For the record, I'm Delegate Malcolm Ruff, District 41 in Baltimore City. I want you to put yourself in the shoes of a pretrial detainee in prison who one day, because the guards refused to give them recreational time, you protest by refusing to go to your cell. In response, one of the guards yanks you off the floor by your neck using a prohibited chokehold and puts you unconscious. The guard then drags you by your neck to your cell and then intentionally drops you on your face on the jailhouse floor, causing you to suffer a fractured eye socket, a fractured skull, sinus fractures, severe bruising to your forehead, and internal bleeding behind your eye. And despite the heinous nature of your victimization, it takes you 2 years to find a lawyer during that time which you represent yourself pro se in the federal courts. Because here in Maryland, the law deters private lawyers from getting involved in meritorious excessive force cases just like this one. This is just one real-life scenario of a myriad of instances where everyday Marylanders have had their civil rights violated by the people we trust to protect and serve. Unfortunately, most of these victims will never receive justice from being dehumanized because the law in Maryland discourages private attorneys from taking on these cases in state court for 2 reasons. First, our current law not only limits the amount of money that a plaintiff may recover for such a case, but it also limits the amount of attorney's fees that a lawyer may receive and essentially cuts them in half compared to personal injury lawyers. Second, our current law doesn't permit plaintiffs to seek reasonable attorney's fees in state constitutional violation lawsuits. As a result, countless Marylanders frequently find themselves shuttered from the state courts and the opportunity to have counsel to help them competently seek recourse for their pain and suffering. And that's why I'm bringing House Bill 818, which will authorize the courts to award reasonable attorney's fees and expenses for a claim against the state, any local government, or any agent of either. By allowing our state judges to award reasonable attorney's fees to a prevailing plaintiff in these cases, we will ensure fair access to justice for all Marylanders while also dissuading our public agencies and officials from committing such atrocities in the first place. So I'm fully prepared to answer questions about the inner working of the bill during the questions section, but let me just close by saying that the Maryland Constitution is a critical cornerstone of our democracy. It enshrines the freedoms that are essential to our identity as a state. As elected officials, it is our solemn duty to ensure that these rights are not merely symbolic, but are vigorously protected by affording the people the means to effectively seek justice. For these reasons, I urge you to issue a favorable report on this bill, just as this committee did in 2015, 16, and 17. I thank you for your time and attention and look forward to your questions.
Thank you, Mr. Chair. I appreciate the opportunity to address the committee. My name is Kerry Hansel. I have been a civil rights lawyer here in Maryland for 25 years. This is an incredibly important bill. The thing to keep in mind is that someone pays these fees. It is either the victim or the wrongdoer. This bill brings us in line with federal law where the fees are paid by the wrongdoer for very important policy reasons. One, as Delegate Ruff says, is to encourage lawyers to take these cases. Two, there is a very high public interest in helping the powerless and helping the victims of civil rights. Here, there is an important question that might be asked, well, why not go to federal court then? And there are 2 critical answers to that. The first is, our Maryland rights ought to be decided here in Maryland by Maryland judges that are chosen from the people of Maryland by our governor and through the appropriate process. The second one is a critical change in the federal judiciary. We now live in a country where 28% of the federal judiciary are MAGA appointees. That soon will be over 50%. States must act to protect their citizens against a world in which our civil rights are being actively dismantled at the federal level. The way to do that is to pass this bill and provide our citizens here in Maryland with the same rights that they still enjoy for the moment in federal court to protect those rights in perpetuity. So I would ask you to please report favorably on House Bill 818.
Judge Murphy for 2 minutes.
Good afternoon, everybody. I feel sorry for all of you, but I understand. We see people come to our office, call us repeatedly, who cannot afford lawyers, and we can't afford to represent them. This bill would change that. This bill would enable people to vindicate their Maryland constitutional rights, even if they don't have money to do it. And it's abuse-proof, because if lawyers bring suspect cases, they're going to be the ones that have to pay fees to the defense if the issue that is being brought before the court is not a substantial violation of the Maryland Constitution. And so there's no reason not to pass this bill, and there's every reason to pass it, because we don't want people not to be able to vindicate their constitutional rights just because they're poor. We want everybody's rights to be respected. And the poor get their butts whipped because everybody knows that they can't afford a lawyer.
Delegate Valentine.
Thank you, Mr. Chair.
Oh, wait a minute, wait. There's a person who's virtual. Sorry. Deborah Gardner. She's there. Deborah Gardner, please. There she is for 2 minutes, please.
Thank you very much, Mr. Chair, Madam Vice Chair. I really appreciate the opportunity to testify on this bill. My name is Deborah Gardner. I'm the legal director of the Public Justice Center. I also want to thank Delegate Ruff for bringing this bill forward again. It is an incredibly important measure, access to justice measure. I can echo Mr. Hansel's testimony, but from the perspective of public interest organizations, we have supported this bill for a very, very long time. It originated with the original Access to Justice Commission created by Chief Judge Robert MacBell, and was spearheaded in that commission by Pamela Ortiz, the director at that time. The Access to Justice Commission of Maryland continues to support this bill, as does a wide array of public interest organizations. Our client communities need this bill because we need for private attorneys to be able to make a living representing members of our client communities in the kind of litigation that Delegate Ruff has discussed, and many other enforcement actions of the Maryland Constitution, including, importantly, actions for injunctive relief, where the monetary recovery is not an economic factor. You need the fee shifting provision in order for private citizens to be able to enforce the Maryland Constitution. Now more than ever, we need the protection of the Maryland Constitution, and we need to be able to seek that protection in our own courts, because the federal courts typically ignore state constitutional claims and just look to the federal Constitution. Excuse me. You'll probably hear from opponents that this is going to raise the cost to the government of litigation. That's not so. They'll just be litigated in state court where they belong, rather than in the federal courts where they're currently being litigated. Thank you very much. I heard the favorable report.
Now, Delegate Valentine.
Thank you, Mr. Chair, and thank you, Delegate, for bringing the bill and the panel for being here today. I did have one question to the gentleman in the middle. I'm sorry, I don't remember your name. You referenced the percentage of MAGA judges. Could you give me a definition of what a MAGA judge is? I was looking here and I couldn't find that and how it impacts this legislation.
Our president says he appointed MAGA judges, so I'll adopt his definition.
Definition for that.
Here's what it doesn't mean. It doesn't mean Republicans. It doesn't mean conservatives. Because my Republican and conservative brothers and sisters are people who stand up strongly for individual rights, and that's what we as civil rights lawyers protect. What it means is extremists who would strip those rights serve from all of us. And that's exactly what it means, and I think that's what it meant when the man who appointed him said it.
And could that be extremists on both sides of the aisle?
Right now, the concern in this country, from where I sit, are the people who would erase the rights of my clients. So I represent, sir, in protecting people's rights. And to let you know, I'm also one of the leading Second Amendment lawyers in this state. So I represent your rights no matter who you are and no matter what community you come from. But today, in this world that we live in today, the people who need our help the most are our trans brothers and sisters. It's our gay and lesbian brothers and sisters. It's people of color. And those are the people whose rights are at serious, serious risk in this country by extremists from a particular side. Now, if any side has a constitutional concern, I will be the first to stand up for it, and I have a 25-year record of both left and right issues. But when all of our rights are being stripped away, and when there's a certain population that they are starting with, sir, and they will get to the rest of us because that is how this works, we have to protect them. And so it is absolutely the case when we see a federal judiciary moving further and further away from principles like stare decisis, further and further away from individual rights, that we have to protect ourselves here at home. And my most conservative brothers and sisters would remind us all that states' rights is a critical component of our Constitution and of the arrangement that brought us together as a country. So isn't this absolutely the most states' rights thing to do, is to provide this state, the people of this state, with the exact same rights that our federal government provides at the federal level? And shouldn't we as a state take those cases back from the federal court where they don't belong and put them here where our judges can make decisions about them? So when I say MAGA, sir, I'm referring to the words of the man who appointed those people, and I'm referring to the most extreme and outrageous denials of some of the rights of our brothers and sisters. I'm not referring to Republicans. I'm not referring to conservatives. I grew up in West Virginia, and I am a member of a long line of very conservative folks, and so it's not those people with whom I am concerned.
May I answer your question?
Sure. Well, I appreciate, Mr. Chair, I appreciate the answer, and I, too, am more concerned about everyone's rights, so I just wanted to.
Thank you, sir. On that, we can agree, and it's a pleasure to meet you. My name's Kerry Hansel. You asked earlier.
Well, let me point out something. When the president himself ended the enforcement of the civil rights laws, which keep avowed racists from not giving us employment, not selling us homes, not doing this, not doing that. When he ends that enforcement, which he's already done, Maryland shouldn't sit by and let that happen. Maryland has laws, and we don't want those laws to become like that. As a black man, I say that confidently, courageously, and unequivocally. We need enforcement of those laws. And this statute will enable us to do that.
Delegate Kern. Thank you, Mr. Chair. Thank you all very much for coming. Delegate Ruff, I just want to confirm I came in a little late. I was here listening to your testimony outside, but I didn't want to interrupt. This doesn't require a judge to give attorney's fees, right? It's a may, not a shall.
That's correct. And I think maybe you might have seen in some of the testimony that was written from some of the municipalities that they completely missed the authorized word, and they are construing this as a mandate. This simply gives the power to the judges to determine whether or not there should be reasonable attorney's fees awarded based on the work that the lawyers have actually had to do. And these are complex cases that if it's a case that might garner, a seven-figure verdict or a case that's gonna garner a $50,000 verdict, the same type of work has to go into it. And so that's why there are some specific factors based on existing Maryland procedural law, a 12-step factor that the court has to go through an analysis of.
In fact, the only thing that's mandated is that they have to follow those factors. I pulled them up, like time, novelty and difficulty, the skill required, whether acceptance of the case precluded other employment by the attorney, et cetera, et cetera, et cetera. So the judge is required, if he's going to offer it, is required to follow those parameters. Is that correct?
Absolutely. Yes. And in fact, there is a provision in that procedure rule that allows the judge to have more enhanced oversight over the actual keeping of time contemporaneously with the actual litigation of the case, quarterly reporting, enhanced evidence on the actual time that is spent on the case. So there are super strong guidelines that will ensure that the courts won't overstep awarding reasonable attorney's fees in these types of cases.
And one last question. So, but that it's actually not the same for the defendant. The defendant, they have to show bad faith. So if the defendant wins the case, but it was a colorable case that was not brought in bad faith, they're prohibited from awarding attorney's fees. Is that correct?
But I would disagree that it's different. Essentially, if you have a finding from a jury or a judge that a government violated somebody's constitutional rights, that's bad faith in itself, right? So on the other side, if a plaintiff brings a case in bad faith where there is no constitutional violation, certainly this law provides for it, that that plaintiff should have to pay the reasonable attorney's fees of the municipality.
I like that perspective. Thank you, Mr. Chair.
Thank you, Delegate. You touched on this, but I just wanted to draw it out a little bit more. You talked about cases where there's big dollar amounts and someone could be, grievously injured and there's large damages. But there's also cases, aren't there, where it's a small dollar amount, but there's policy issues that are in play.
Correct.
And so groups like the Public Justice Center and private lawyers may be more willing to take those cases where they're not going to get a lot of money, but there will be possibly injunctive relief or other settlement agreements that aren't, again, necessarily monetary. Is that fair?
Absolutely.
And that's an interesting point because lawyers can't make money getting injunctions. Where's the money going to come from? And so injunctions are a powerful tool to prevent government from breaking the law, from violating the Maryland Constitution. And so if we don't have the ability to stop these violations, not just get compensation for people, what's the point? And so a lot of things will happen with no redress. The second is declaratory judgment. Declaratory judgment means you're going into court to have the judge declare what the rights of the parties are. You don't get any money from doing that. It's a declaration of rights. And so imagine all of the situations that will arise where those things need to be done because of the wrongdoing to the person, but the person can't hire a lawyer because lawyers won't make any money off of it.
Thank you, Mr. Chair. I'm going to ask a really simple question, I think. Does this differ from the federal process?
It only differs in the factors that the judge has considered. That is specific to Maryland, but in any other way, it mirrors the federal process, which is the reason why we as civil rights lawyers bring these cases in federal court on a consistent basis, which is not preferable, right? For all the reasons that Carrie pointed out earlier.
Thank you.
And I would add to that in addition to mirroring the federal process, in some ways, there are more hoops to jump through in this approach. Because when we look at the 12-step rule, although it echoes, I guess I should say, the federal process, the way this is organized, it is probably going to be, in my judgment, harder to get awarded fees. You start under this statute with a may, not a must. You then move on to it has to be reasonable, and then you move through a 12-step analysis that the court has to do. So in my judgment, it will likely be harder, particularly because in federal court, this has been part of 42 USC 1983 and other laws for decades. And so in Maryland court, moving judges past this may, I think is going to be a lot harder than it is in federal court. But this at least begins to level that playing field so we can start to make a difference here at home.
Thank you.
Thank you, Mr. Chair. Mr. Hansel, your assertion that since you're related to Republicans, you must like them is a lot like saying I can't be a racist because I have a black friend. Your comments were pretty derogatory towards conservatives. And I pulled up the bill and I see you got 6 votes so far on this bill. All of them are Democrats, and as you can see, that's not enough to move this bill. You might actually need Republicans. So how do you expect to get Republican votes on a controversial bill that I would be inclined to consider if you come in here and pretend like you love us because you were raised next to us? You clearly don't respect us, sir.
Let me answer that.
No, sir, I'm asking for Mr. Hansel to answer because I've had a lot of respect for him over the years, but his preaching to us was really uncalled for. And also, the MAGA comment, MAGA judges, I've been Googling. Chat GPT says, never been spoken by the president.
Well, that's the difficulty of relying on AI, but I will send you a copy of the article.
Please do send it, please
that
do.
I was referring to.
Yeah.
I think this is a bill everybody should get behind. I think it affects everybody's rights. I think it makes a difference for everybody. I think that's true all across the political spectrum.
No, thank you, sir. Thank you, no.
Because, thank you. You know, this bill will affect you as well. Because if you have constitutional rights that are being violated against you or your family or your friends or whomever, that will be an important thing to utilize this bill, because it doesn't have anything to do with MAGA. It doesn't have anything to do with the Republican Party generally. And so if I need the bill and you have friends who need this bill, please don't get mad with him, because that'll throw out the baby with the bathwater.
Well, at least we agree that both parties should be able to.
And by the way, I get along with Republicans a lot. I was in the Ehrlich administration. So don't hurt me.
Everybody be nice. Delegate Taylor.
I'm going to ask a mild question. Delegate Ruff, you mentioned some history behind this particular bill. I think you said 2014, 2015,
15, 16, 17.
15, 16, 17. So this bill passed Judiciary, and
Yeah.
then what happened to it?
So this bill came out of Judiciary under former Chair Valerio, 15, 16, and 17. It didn't make it out of the House in 15 or 16, but it made it out of the House in 17 and then got stuck on the other side of the street.
And has it been presented since
It
then?
has not been presented since 2017.
Thank you.
It's Delegate Carden's bill. Delegate Conaway.
Thank you, Delegate. Thank you, Mr. Chairman. Thank you, Delegate and panel, for coming in to testify on this bill. So, first things first. Delegate Ruff, did I not tell you earlier today that just because I was a co-sponsor, I was going to vote for your bill? What did I tell you I might say?
You said that.
So for someone to make an ask you me that I'm going to vote for a bill just because I'm a co-sponsor is a terrible error. But I would like to ask. Thank you, sir. Thank you, sir. It was chatter in the background.
That's my seatmate.
So are attorneys' fees going to be separate from the recovery? Or?
Yes.
Thank you very much.
Stole the words right out my mouth.
Every year I kind of point out, you know, people spend a lot of time getting co-sponsors of bills, emphasizing that, you know, it takes up a lot of time, and maybe you don't want to do that and get on with it. Maybe Delegate Conaway just made my point, I guess. I don't know. Delegate Kaufman and Williams.
Well, Delegate, as I always say when you come in here, I'll try not to give you a rough time. But it's.
I hope you don't have a rough time finding that woman of your dreams.
Well, since you're married, if you have any advice, I'd apprite it.
I got you.
Anyway,
I got you.
But on the bill, my question is. On the bill, my question is, it says here, I wanted to make sure you have you had a response. It says potentially significant increase in special fund expenditures if the bill results in higher payments from the state insurance trust fund for claims filed under the Maryland Tort Claims Act. So do you have a response? And also, I wanted to ask you how you thought people with disabilities might benefit from the legislation. And lastly, just a comment, isn't that so? It's an honor to meet your legendary law partner, Judge Billy Murphy.
That is so. My first answer would be that it's similar to the first bill you all heard as far as whether or not insurance premiums for legit will rise. I'm sure that they're going to testify that they will, but there's a lot of conditional language in that report. This bill this law exists in 12 different states across the country: California, New York, Texas, Florida, Ohio, Massachusetts, Arizona, Michigan, and others. 3 of those states allow fees for any civil action against the government, period, not just constitutional claims. And some actually mandate those fees. So I don't think that there's any information that in the 12 other states where this provision, this access to justice statute is available, have astronomically raised the premiums for local governments that have insurance pools like legit. So I think that that's a misnomer, and more than likely is not going to occur based on the fact that cases, like Mr. Hansel said, are moving from federal court and like the Public Justice Center said, to state court.
What about the impact on people with disabilities, Delegate?
Absolutely. People with disabilities have God-given constitutional rights in Maryland just like everybody else. And if somebody violates, if a government entity or a government agent violates their constitutional rights, they will be able to use the provisions of this bill, hopefully to have a better chance to have competent counsel represent them in that type of claim, whether it be under Article 24 or under Article 26 of the Maryland State Constitution for any type of a violation, excessive force, false arrest, or an injunctive, a claim for injunctive relief or declaratory judgment like we've been talking about already today.
All right, thank you, Mr. Chair.
Delegate Ruff, would you please provide the information on the states to counsel, because she could write it down. We don't need you to repeat it, just provide it right now.
Will do.
Delegate Williams.
Okay, thank you, Mr. Chair. So Delegate Kaufman sort of took my thunder a little bit because I know I was going to ask about the Local Torts Claims Act. And with regards, we've had, as you mentioned earlier, we were talking a lot about caps. And I don't want to really talk about caps anymore, but under this legislation, the caps that exist would still apply under the Local Tort Claims Act as well. Is that correct?
That's correct. It would also still apply under the Maryland Torts Claim Act for any state entity or agent. However, these fees, the reasonable fees and expenses would not be subject to those caps as drafted in this legislation, as well as how it's drafted in the the Courts and Judicial Proceedings section 5-303, which lays out the caps for local governments. It's specific to damages arising from the occurrence that the caps apply to. So the fees and reasonable fees and expenses that we're seeking in this legislation would not be limited by the caps, but the damages would.
And to add to that, if this has the effect that we expect it will, of moving cases from federal court to state court. In federal court, they're uncapped. So this is going to move some number of cases from an environment where no cap applies into a capped environment. And the idea that there's going to be an increase in cost moving from an uncapped to a capped environment, I don't think holds a tremendous amount of water, especially because where these cases are filed now, attorney's fees are available. So if you move from where attorney's fees are available to another jurisdiction in which attorney's fees are also available, where's the increase? It's the same amount of time, it's the same amount of attorney's fees, but where there might be a marginal difference is by moving from federal to state court, the cap will apply. So we'll be subjecting our cases to the cap for what may be the benefits of having cases resolved at home. And so for that reason, the idea that they're going to be, that this increased costs, it's either a wash or may slightly decrease to the extent that further cases are subject to the cap.
Okay. All right, thank you. And if we pass this bill, that means I won't see you in my county anymore.
It always depends on.
Let the record reflect nervous laughter.
It always depends on the activities of the government. You know, I hope every day to wake up and have absolutely nothing to do and go out of business.
Okay, sounds great.
That's our goal.
All right.
That's our goal.
I see Delegate Grammer. My question, and I'm just making sure I have this right in my head. So you go for declarative or injunctive relief, you could get attorney's fees. Obviously,
Correct.
there's no money coming. But if there's a case where there is some sort of, there's some sort of dollar sign at the end of it, the court could opt, if I were to receive $100, the court could opt to make it $120, $125?
Correct.
Or the court could make it $75 and $25? Or no, it's just, are they adding on top of the, of whatever?
It's in addition to.
It's always in addition to.
Correct.
Okay, I just was trying to kind of wrap my head around.
Which is in line with federal law
I
and the
understand.
states that Delegate Ruff mentioned.
And by the way, this would be a tremendous deterrent to people in state government not to violate people's constitutional rights and think that they can get away with it because the person's poor. And that's something that we really need.
Right, Delegate Grammer.
Thank you, Mr. Chair. If we amended the state constitution to say a person has a right to have gender transition surgery, would that give me a right, or would that give me calls of action under this bill to sue a Catholic hospital if they didn't provide it?
No, because a Catholic hospital is likely a private hospital, right?
This is against the government only.
Well, St. Joseph's Hospital is a Catholic hospital in Baltimore County who was sued for just that, and it was, it was found against them. So that's why I'm trying to clarify, positive rights are a thing, and everything, like abortion is a right in the state of Maryland, right?
I don't know if abortion is codified in the Constitution. Okay. Oh, there you go.
Oh, you stepped in it. You stepped in it, right? Abortion.
I missed it.
This is what I'm getting at. Abortion is a right. So, I mean, I use the gender transition as an example, not because it's, gets people's attention, because it's actually a case that happened in Baltimore County. And I'm really trying to suss that out. Like, seems to me a positive right. You could force St. Joe's under this bill to provide gender transition surgeries, even though they're a Catholic hospital and they don't do a lot of procedures based.
Any right that is conferred by the state constitution would apply to this bill.
But you do still need, in a constitutional claim, state action. So you have to connect it in some ways to state action, which I don't think would be possible in the circumstance you raise. However, I would add to that, this bill doesn't create any rights. All it does is shift the burden of fees from the victim to the wrongdoer. In other words, the concern you're raising is not a concern that would be created by this bill in any way. Either it's already the case, and respectfully, I don't believe it is because of the lack of state action, but either it's already the case where that claim could be brought or it isn't, and this bill would have nothing to say about the liability or the underlying issue. All this bill does is shift fees one way or the other for already existing rights that in general require state action. In other words, that in general are brought against the government on the other side of the V. There's obviously more to that, and it's beyond the scope of our time here today. I think to get too much more in the weeds. But the key is this doesn't create any new constitutional rights. It only shifts fees. And the real question is, should the wrongdoer bear the fees or the victim? In federal court, it's the wrongdoer, and we're trying to bring state court in line with that.
All right, thank you to the panel. Thank you very much. We're going to go to those in opposition
And by the way, I really loved your questions. I really did.
Thank you.
We appreciate that.
All afternoon.
Not sure I totally appreciated that last part, but that's all right.
No, I meant.
No, thank you. Thank you all very much. All right, we're going to hear from Hamilton Tyler. It might be Tyler Hamilton. I'm not sure. Matthew Peter. Leslie Roscoe is virtual. Chris Corchiarino. And each of you are going to get 2 minutes. And we'll start from my right, your left, and move that way. So just make sure you're talking into a microphone. So you're going to need to, there you go. And you have 2 minutes, please. Go ahead.
Good afternoon, Mr. Chair, members of the committee. I am the gentleman from Legit that Delegate Ruff was talking about. My name is Matt Peter. I'm the Executive Director of Local Government Insurance Trust. We do insure 150 of the municipalities in the state. We insure 14 of the counties. You heard testimony earlier that this is not going to impact member rates because you can already sue in federal court and get attorney's fees. Well, what that doesn't take into consideration is that when we look at the number of cases that are brought, we know that in any given year, only about 50% of our cases are going to be brought in federal court that includes some type of constitutional challenge. So we bake that into the pricing, knowing that there's a chance in 50% of our cases that there's going to be an attorney's fee award. What we do now, if we create this, is you guarantee that in 100% of the cases, there's the possibility of an attorney's fee award. So there certainly will be a possible increase to, I can guarantee there would be an increase to rates and premiums for our members if this happens. We live in a difficult world today, and I know we're not here today to talk about climate, but if you want to talk to me about property rates and the property rates that our members have to pay because of issues that are going on across the country, fires and hurricanes and such, that's also impacting their premiums. All right? So insurance, we're not just looking at it in this little vacuum here. There is more things that we do need to consider. And I do know that Hamilton Tyler is going to talk about Rule 68, but I do want to take exception with the testimony that this is identical to the federal rules, because this does not include a federal Rule 68 offer of judgment, which is a valuable tool that we use in federal court that Mr. Tyler will explain. Thank you.
Members of the committee, my name is Hamilton Tyler, frequently reversed, and I'm Deputy County Attorney for Anne Arundel County and work for their Office of Law, where I've been for the last 25 years defending these types of claims. Many large counties like Anne Arundel County are self-insured, so these monies for judgments and attorney's fees come right out of county funds. I'm opposed to this bill for a number of reasons, but I'm going to talk about the offer of judgment difference, which is a vast difference from the bill and what the federal law is. There is something called a offer of judgment under federal law. Federal Rules of Civil Procedure 68 provides that a defendant may make an offer of judgment to a plaintiff in a case brought under 42 U.S.C. 1983 that was discussed before, civil rights claims. And when that defendant makes the offer of judgment, the plaintiff has the opportunity to take that offer of judgment in the amount and take that money in settlement, and they will get their fees to that point. If the plaintiff refuses that judgment and the case proceeds to trial and the plaintiff receives less than the amount of the judgment, what occurs and what we often use it for is it cuts off attorney's fees as of the offer of judgment date. So the plaintiff cannot continue to get attorney's fees. The absence of that provision in this bill means that if there's a small violation with $5,000 of damages and an offer of judgment is made early on, were this bill to have that would cut off the attorney's fees right then. The lack of that provision in this bill provides incentive to take that case all the way to trial, where they still may get the same $5,000, but it then becomes a $55,000 cost to the county because they're paying $50,000 of attorney's fees in what should have been a $5,000 case. So for those reasons and others, we oppose this bill. Thank you.
Microphone, please. Go ahead.
All right. Mr. Chair, members of the committee, my name is Chris Corcorino. I'm a county commissioner for Queen Anne's County, and I'm here to give the impact this would have to local governments, in particular smaller local governments like Queen Anne's County. And this bill will have significant negative consequences to local government and to our citizens. And those with less financial resources will as a group be burdened most by it. So let me tell you about Queen Anne's County. We are a rural county of about 50,000 people, but a land and water mass larger than Prince George's County, and we operate on a very tight budget. And within that tight budget, we have to do education and law enforcement and roads and parks and recs, among many other things. And even a small cost change challenge impacts our budget. I heard testimony earlier about how this wouldn't be astronomical on local governments, but astronomical isn't what it takes to break our budget. Just a little bit can do it. So imagine that you have a lawsuit that is brought after this bill passes, and there's a verdict for a nominal amount or just maybe injunctive relief. And the county has spent $300,000 or $400,000 defending that, and the plaintiff's counsel as well has spent $300,000 or $400,000 now shifting that burden on. I now have to find out, where do I pay for that $800,000? Do I have less teachers? Do we not have math and reading specialists for the elementary school? Is it not doing summer programs through Parks and Recreation? Or do we have to put off that overdue and long-needed ambulance from going into service? These are the realities of the decisions that we have to make in local government, which is where the rubber really does hit the road. And these cuts to local government services hit hardest on the citizens that depend most on these services. Wealthy citizens can pay for tutors, and they can buy a security system for their house, and they can pay for summer camp. But it's those on the lower end of the socioeconomic scale who cannot do that, and so we're asking for a negative referral.
Mr. Leslie, please.
Thank you, Mr. Chair, Madam Vice Chair, and committee members. My name is Roscoe Leslie. I'm the county attorney for Worcester County, Maryland. I'm here to testify against HB 818. Before Worcester County, I had represented other local governments such as Wycomico County, the city of Salisbury, Pocomoke City, and other small Eastern Shore towns. I oppose this bill because it will create an unfunded mandate on our local courts. Fee shifting is designed to encourage and increase litigation. If this bill accomplishes what it is designed to do, it will create a new category of civil litigation in our local county circuit courts. And I believe that was the testimony that was given earlier, that there would be a shift of cases from federal to state court. Our court systems will require more judges and more staff to handle the increased demand. As noted, these cases can be complicated and intensive. Ultimately, the costs of the additional litigation will be borne by the local county taxpayers who fund the local courts. Currently, the federal court system handles federal claims that are substantially identical to the ones covered by this bill. Fee shifting is available there, and the federal courts offer a neutral and highly professional venue for this litigation. Additional venues are not needed. More litigation would burden state courts and ultimately local taxpayers. I ask for an unfavorable report.
Questions? Delegate Phillips.
So I want to make sure I'm clear. If these cases were brought in federal court and your jurisdictions were participating in some way, you would be in an environment where there were no caps. So how does this then benefit when you now will have caps? Because any of these cases could still be brought, but they could be brought from a federal perspective. So how does this change?
Well, for one, we have the offer of judgment that I discussed. There's no offer of judgment provision in this bill. And so in federal court, if we get that small violation case early on, we can make an offer of judgment of $5,000, $10,000 in that case and cut off attorney's fees at that point if there's not a judgment in a greater amount later. We don't have that in this bill.
I think I'd answer your question a little bit different. They talk about, the proponents of the legislation talked about, well, now we'll have cases filed in state court instead of federal court, right?
Correct.
And that's going to save us money because there's a cap on damages. My question to you is, what plaintiff's attorney can decide that my client might have $1 million case, but I'm not going to bring it in federal court where I can get uncapped damages. I'm going to bring it in state court and limit what he or she can recover to $890,000. I don't see that. If any of you had a claim that was worth $1 million and your attorney said to you, well, we can bring it in federal or state court's going to be $890, your cap, but I can get you more in federal court. Where are you going to go? So I don't see that change happening the way they suggested. To be honest, I would almost think it's malpractice if you think your client has $1 million claim and you decide to file in state court where the cap is $890. But that's the way I look at it.
That's fine.
Thank you, Delegate.
Can I add?
I would also to that the opponents to the bill also said that this will increase additional litigation. Those who cannot currently find lawyers will now have lawyers who will be funded by the county to have the county be sued. So we're talking about a significant increase in litigation. And the cap may be on the damages, but there's no cap on the attorney's fees. You could have attorney's fees of $500,000, dwarfing the cap. And so then the local governments aren't getting the benefit of that cap anymore.
I would also offer that currently these cases, these types of claims are handled in federal courts, and the federal courts have expertise and experience in these cases, which leads to predictability for the local governments. If we start shifting these cases to local government, there will at least be some period of time where new law will be created that will create much uncertainty for local governments.
Delegate Cardin.
Is just to the gentleman on your left, my right. If I, as a experienced attorney, say to my client, we have a 50% chance of getting $1 million verdict federally, but we have an 80% chance of getting $890,000 in the state court, or 90% chance because I know these jurisdictions well and I feel more comfortable in that jurisdiction. Are you telling me it's malpractice for me to go to federal court? Is that what you're saying? I just want to make sure I understood what you were saying.
I don't, when I look at a case, when I value a case, I've only ever been a defense attorney, all right? That's all I've ever been. So when I look at a case, my likelihood of success is based on the facts and the law. It's not based on jurisdiction. So in your question, your assumption is I've got a better chance in county court, in circuit court, it's 80%, but it's a 50% chance in federal court. My mind doesn't work that way. I think every case, it is what it is. It's either 50-50 or it's 80-20, and it's going to be the same in either jurisdiction.
Thank
you. I have a hard time with your question, and I apologize.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. On attorney's fees, while they are not capped, can the judge modify the amount that will be awarded?
The judge has a lot of discretion, especially under this bill, on what will be afforded, yes. And that's true under federal court, under the federal rules, and this bill.
Thank you so very much.
Don't see any further questions. We thank you all very much. And that concludes the testimony for House Bill 818, our fourth bill of the day, and we're only 4.5 hours in. All right, so we're going to go now to Delegate Lopez, who has two bills. The first of which is House Bill 670, and I'm just going to call off the lists. Delegate Lopez, Leslie Jordan, Jennifer Mercer, Jonathan Alexander, and then virtually Gregory Pilgrim and Jennifer Tisdale. Pilgrim and Tisdale are virtual? Yep. Everybody take a seat.
There we go. Sorry.
Delegate Lopez for 3 minutes.
Thank you. Thank you, Mr. Chair and Madam Vice Chair and members of the committee. For the record, I am Delegate Leslie Lopez, here to ask for your favorable support for HB 670, which allows recipients of unsolicited obscene materials, commonly known as cyberflashing, to take legal action against the sender. This bill provides a private cause of action, including attorney fees and injunctions. This legislation reflects years of research and collaboration. In 2023, I introduced a similar bill, but after discussion with the Attorney General's office, concerns were raised about First Amendment protections. In response, we attempted to create a task force to examine women's digital rights. Since then, additional legal reviews have taken place, and similar laws have successfully passed in California and in Texas. HB 670 now aligns with the Supreme Court's definition of obscenity from Miller versus California in 1973, ensuring that it meets the constitutional standards. This issue is personal, but it is also widespread. A friend of mine, Jen Tisdale, who will testify today, came to me after receiving illicit images and asked what protections existed. The answer, none. Cyber flashing is a glaring legal loophole and one that disproportionately impacts young women. Here's an alarming statistic. 48% of women ages 18 to 24 have been cyber flashed, according to Bumble, the dating app. That's nearly half of all young women. These images aren't just sent through messages directly. They're frequently airdropped in public spaces like concerts, lecture halls, and even metro trains. And so that's another issue. Our metro system crosses into jurisdictions that have or are already addressing cyber flashing, like Virginia and DC. So right now, riders are only protected from part of their commute. Maryland needs to catch up. HB 670 makes Maryland a leader in addressing cyber flashing, encouraging that everyone has the right to exist in public spaces without fear of sexual harassment. I urge your support for this bill.
Whoever would like to go next?
Good afternoon, Mr. Chair, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in strong support of House Bill 670. Thank you, Delegate Lopez, for your continued leadership in this area. You really have covered everything that I was going to say, and since this is the second evening in a row, I'm here with you very late. I'm not going to say anything other than, you know, it's not just some sort of fun thing that, ooh, I got a picture I didn't want on my phone. This is really disturbing. And the limits of the First Amendment means the only thing that you all can criminalize are the obscene things. And so those are defined carefully in the statute. And these are really very graphic and detailed pictures. And you shouldn't have those sent to you unless you want them sent to you. It's as simple as that. For those reasons, we ask for your support of House Bill 670.
Whoever would like to go next, please.
Good evening. My name is Jennifer Mercer, and I'm the Legislative Director of Reproductive Justice Maryland. We are proud to support House Bill 670 in keeping with our mission to promote reproductive justice and bodily autonomy for all Marylanders. We affirm that each and every sexual act must require the clear and unequivocal consent of all parties involved. The sending of unsolicited obscene material violates this common sense standard and must be prohibited. The practice of flashing or exposing one's intimate parts in public to unsuspecting strangers is an act of harassment and aggression that our law does not tolerate. Prior to the widespread adoption of the internet and smartphones, a flasher would have to go out in public at minimum in order to victimize others. Likewise, people could at least be assured to be safe from flashing within the confines of their own homes. With modern technology, both of these statements are no longer applicable. Now it's possible to flash anyone, anywhere, at any time, all without leaving home. And if a flasher does leave home, location-based technology makes it possible for him to victimize large numbers of people via airdrop. The victims of cyber flashing are mostly women, and a startling number of them are minors. A 2021 study found that 3/4 of girls ages 12 through 18 had received a photo of male genitalia on social media. Cyber sex harassment, including cyber flashing, leads to depression, anxiety, and trauma, and makes the digital world unsafe for girls and women. Simply blocking the sender post hoc does not solve the problem, as it is easy to spoof phone numbers and create no counts. House Bill 670 will allow victims of cyber flashing to bring a civil cause of action to hold perpetrators accountable. It will deter would-be perpetrators and send a message that consent is mandatory for all sexual acts, including the sharing of images of a sexual nature. Importantly, the bill also provides for recovery of attorney's fees for successful plaintiffs, which is crucial for victims to have access to justice. Reproductive Justice Maryland is proud to support House Bill 670 and urges a favorable report. Thank you.
Members of the committee, I'm Jonathan Alexander of Maryland's Family Institute, in strong support of 670 as it establishes clear prohibitions against the electronic distribution of unsolicited obscene material and ensures that the victims of this material have legal resource. we ought to already recognize that handing someone obscene material in person without their consent is an act that ought to be penalized under existing laws. And so this bill simply extends that same standard to digital communication. It keeps up in an era where technology allows for instant and mass distribution, and so it's critical that our laws keep pace. Unsolicited obscene material, as you've heard before, is given a name. It's referred to as cyber flashing. But what it does is it violates the person's dignity that receives it, causes emotional distress, and it is a form of harassment. HB 670 provides necessary protections to allow those victims to seek damages, ensuring that perpetrators are held accountable. And it's good that the updates to this bill follow the legal standard that do characterize and are recognized in the state already as characterizing obscene material that an average adult that applies community standards would find that this material excites lustful thoughts or pure interests, and it depicts or describes sexual conduct in a way that is patently offensive to the prevailing standard in the adult community, and also has no redeemable value. By passing this bill, we affirm that consent matters, whether it's in person or via devices, and so we urge a favorable report on 670.
Ms. Tisdale, please.
Thank you. I testified about the previous version of the bill. Thank you again, Leslie, for involving me 2 years ago. And I looked back at what I said, and my statement was primarily focused on how the recipient is affected by these unsolicited images, because I've received several in my lifetime, and all I did was just be a woman on the internet. That was my biggest fault. And I still believe it's harmful. But I did want to pivot today to talk about mental health. I'm not suggesting that every person who sends these unsolicited images suffers from some sort of mental illness, but it's clear that something's wrong. And in a perfect world, the state of Maryland would have the means and ability to help everyone when it comes to their mental health. I understand that's a difficult thing to do. In the meantime, I think a bill like this could either prevent someone from engaging in this activity or throw a switch in the brains of those who do, thus putting them on a different path, maybe. I think consequences remind folks that there are people on the other side of their screens. I do not subscribe to the idea that all men are bad, and I want to live in a world where we help demonstrate that. And I am extremely proud of my state. I love Maryland. Not enough to get a Maryland state flag tattoo, but there are plenty of those out there. But I am constantly proud of what the Maryland government has done for its constituents. And I think that passing a bill like this would just be another reason for me to feel that way. Thank you.
Mr. Tisdale, please. Or Pilgrim, I'm sorry, Mr. Pilgrim, please.
Hello. Thank you for having me. I'm just a member of the public here in Maryland. But I think fundamentally, cyber flashing is an emergent phenomenon that nobody's asked for. Certainly the recipients of unsolicited lewd material didn't ask for it. That's why it's unsolicited. And I think in some ways, people sending this material maybe didn't ask for this dynamic either. Social media and the rise of dating apps has caught everybody kind of with their pants down, as it were. I think about my grandparents. They've been married 70 years. My parents were 40. They've got a lot to say about how to meet people, how to be a good partner. But certainly dating apps, when I started using, I was completely outside their experience. And I've never sent any unsolicited lewd material, but I can understand somebody in that environment thinking that that's just how the game is played now. There's very little guidance on how to behave. The internet is famously a mess, Wild West out there. This bill is an opportunity to provide some of that missing guidance, to create a signpost for how people ought to behave here in Maryland. I'm in favor of codifying cyber flashing as bad behavior and something that one would face consequences for engaging in. I urge your support on this bill. Thank you.
Questions, Delegate Conaway?
Chairman, thank you, Delegate and panel, for coming in to give this bill, present the bill. I believe women cyber flash also, but that's a different subject. I would like to find out when somebody airdrops someone, or are we talking about one person sending it to somebody else who's in their contact? Or is it like if you're at a concert, you can send it to everybody that has the same type of phone that you have, maybe an Apple phone or iPhone? How does this work?
Yeah, so we just checked to see who might have their airdrops open here, and there are several folks on the committee, 3 folks on the committee, 4, including the chair, who could be, who have their airdrops open, and therefore anyone who has the airdrop function on their phone can share images.
So these people have agreed to be in part of the airdrop group, I guess?
They have the airdrop function open on their phone, but they haven't agreed to accept any images from people.
Okay. And what about the $30,000 damages, $30,000 in damages that's listed in the bill? What would that be for?
So we would like to cover attorney fees, injunction.
Go ahead. It says and. So it's statutory damages of at least $1,500, but not more than $30,000, and punitive damages. A person may also seek and be awarded reasonable attorney fees. So that's not the attorney fees.
Sure.
Right?
Well, let me give you an example. Okay. So if you are someone who's in a profession where you have to constantly be looking at your phone, say you're, a real estate agent or something like that, or you're in a position where you have, billable hours where you're constantly checking your phone to respond to clients, having someone harass you by sending you images, who would be, perhaps harassing you otherwise, but is using this form of technology to harass you, that impedes upon your amount that you could be charging for your work. It might even make you change your profession.
Right,
and so there's professional.
You can't block the person. You can't block.
But
Can you block the person?
But that's really not the point.
No, that's not your point. My question is, can you block a person?
Sure. I mean.
So the answer to that is yes. Okay, thank you very much.
I can help. I can answer that question and say the damage is already done. Bringing it to the real world, if that same individual were to walk in and try to display themselves in that fashion to this committee or the persons in this room, we'd know right away that it was either a criminal act, and hopefully if a bill like this was applied, you could have civil damages against that person. It would act as a deterrent for that person, but also allow you to remedy whatever emotional distress you faced by being in the physical presence of a person that did that.
Wait a minute, you're going real fast. You're real good. You're going real fast. What do you mean in the physical presence?
I was using a real life example. If that individual were to walk into this room, we're saying that the damage is similar now with those images being spread through devices.
So if a person cyber flashes me from, let's say, the State House, that's the same as if they came in the room and flash me or cyber flash. That's what you're saying?
Yeah, we're saying the result to the victim is, as this legislature should perceive it, the same, yes.
In your opinion, is that your opinion?
Yeah, that's the purpose of this bill.
Yeah, that's your opinion. Thank you.
Thank you, Mr. Chair. Thank you, Delegate, for bringing this important piece of legislation to us. Two things. I'm so sorry, I don't remember your name with the dark hair on the end. You mentioned a statistic, 3/4 of minors. Could you just read the statistic again? I just want to make sure I got it right.
Sure. So for the record, my name's Jennifer Mercer. Okay. And this statistic is also referenced along with the citation to the study in my written testimony that I submitted. But the statistic was that 3/4 of girls ages 12 to 18 had received a photo of male genitalia.
Wow, that's so gross. And
I agree.
That kind of leads into my next question, which is, and I perused the bill, how can a minor file civil action? Could a parent or guardian do that on their behalf?
Yes, I would presume that it would be a next friend sort of thing where a parent acting as a next friend would be able to file on behalf of the minor.
Okay, so, and then I could sort of seek, like, let's say this happened to my child, like costs of therapy, things like that. Is that the kind of damages you guys are looking to have compensated?
that's certainly something that could be accounted for because the statute sets a floor of $1,500 and a ceiling of $30,000. So I imagine if I were a plaintiff's attorney presenting this case to a judge, one thing that I might perhaps use as evidence to sustain damage would be something along the lines of if I had an invoice from a therapist for my child.
Okay.
That might be something that would cut in favor of a higher award.
Okay, and I'm just trying to think through what kind of downstream effects. What if my child refused to go to school for a week, things like that? Like how, is there any other type of compensation you can get, or is it all sort of like economic damages?
Ms. Mercer, if I might just say, so it's, if you look on page 3 of the bill, beginning in A and B and C, you have a variety of different types of damages. So you have both economic and non-economic damages. So that's kind of pain, suffering, that sort of thing.
Got it.
Statutory damages means that I don't need to get a number on it. So like if I'm asking for compensatory, I need to bring in my counseling bills.
Costs.
Statutory is just kind of an automatic.
Okay, great.
Punitive damages. Yes, you have a whole good list of things here.
Awesome. Thank you, guys.
Thank you, Mr. Chair. This is a challenging area for me, only because I'm concerned that we're in a place where, it's my understanding that a lot of young people do a lot of this, what we would call sexting. And I'm concerned that we could end up with people doing this not for the intent of being obscene per se, but it's this, I think it's crazy, but it's this value that this is okay. And we're issuing civil penalties for something that some people might consider normal. Once again, I don't think it's normal, but and I'll share a situation. It actually led me, and Lisa knows this, for a bill that we did a couple of years ago having to do with child victims. And in that scenario, there was one of the people that brought this thing to mind. He didn't want to testify because he had sent a picture. But he was goaded into sending this picture. And then he was, they blackmailed him, basically, right? So that wasn't his intent. It was this back and forth, and he fell into it. What are the guardrails?
Sure. Well, we've thought through this scenario quite a few times. I remember being on this committee and hearing testimony that was very similar. And we are in a murky time that is growing in technological sophistication, but our culture is still a little bit messy. And so in this revamped version of this bill, we've put in guardrails defining that it is obscene material and then also it is not solicited. So to be goaded, I mean, there's messages exchanging to like get you to that place. This is intended to protect against people who are being threatened or intimidated by images that just happen to be of a sexual nature, right? Just like with all forms of sexual harassment, it's harassment, but it's done through the lens of, sexual imagery or comments and things like that. And so it's not wanted sexual behavior. It's a form of intimidation and harassment that just takes that modality. And so I hear you about that, and we've done our best to include language that would be sensitive to scenarios like that.
I'm concerned about the cultural piece, because one person may think because culturally these things are just flying around that it's okay, and the recipient may think this is definitely not okay, right? But culturally, this person is thinking this is acceptable. So are we setting a cultural standard?
Let's say within the bill, it does say, and as a definition, an average adult applying contemporary, so speaking to where we are now, community standards. So it'd be something that would otherwise pass sort of the litmus test of what the community considers obscene. And it would be those extreme, as it's defined in the Miller test, sort of hardcore type images.
Okay.
Briefly, Delegate Conaway.
Thank you. Ms. Jordan, how would sexual images be intimidating?
So Delegate Conaway, I believe that it was something that Delegate Lopez referred to as sexual images be intimidating. So I don't want to take words or put words in her mouth. But
Well, I'm just looking for the definition, but you can get back to me. So I don't want to annoy the chairman. Thank you.
Okay, certainly.
All right, are there questions, further questions? Seeing none, thank you very much. That concludes, I believe, the testimony on House Bill 670. Now, I have made an error, and I missed two people who were signed up to testify on House Bill 818. Lee Beeman and Angelica Bailey-Thupari. We're going to have you come up for House Bill 818 in opposition. Going to have you testify, and keeping in mind that the rest of the people who are here have left. Apologize for that, but my list was disorganized. So hear from both of you for 2 minutes, please.
Thank you, Mr. Chair. Good evening, committee members. Angelica Bailey-Thupari with the Maryland Municipal League. We will keep it very brief. We greatly appreciate the opportunity to come back to the table and speak with you all this evening. I will echo everything that the opposition panel mentioned earlier. We are very concerned about increased litigation, increased cost, even though this is authorizing, not a mandate, which we understand. We have spoken with the sponsor, and we are working closely with MACO, but at this point, we are strongly in opposition to this bill. Thank you.
Thank you. Good evening, Chair Kiplinger, members of the committee. My name is Lee Beeman. I'm the county attorney for Allegheny County. I'm here on behalf of the Board of County Commissioners of Allegheny County. We oppose House Bill 818. Very, very briefly, you heard from my colleagues in Anne Arundel and Worcester County. I want to give you two real-world scenarios that I believe that I have been involved with in employment-related claims related to fee-shifting provisions. The first one is a claim, there was a claim for straight wages and unemployment. It lasted over a period of 5 years. Plaintiff was seeking hundreds of thousands of dollars in damages. Ultimately, federal court and United States District Court of Maryland awarded the defendant, or awarded the plaintiff $8,000 in damages. The fee petition came next. $363,000 was the fee petition. Ultimately, after months and months and months of litigation, that was reduced to $22,000. The attorney's fee cost for filing the fee petition itself, $20,000. Plaintiff was awarded $8,000. Wrongful termination case, again, seeking hundreds of thousands of dollars. Jury awarded $4,000. Attorney fee petition, $260,000, reduced to $90,000. Petition cost, $13,000. These are real-life scenarios that county attorneys' offices across the state will be dealing with, that our Attorney General's office will be dealing with. And the reason that I bring this up is fee shifting will discourage settlement. It discourages settlement on behalf of the plaintiffs because it allows them to run up the bill, and it places a very strange dichotomy between the plaintiff themselves and the plaintiff's attorney. In the second example that I gave you, there were significant offers made that would have netted the plaintiff more money. For these reasons, we ask that the committee report unfavorable.
Real quick, do you think this should be capped?
I think the problem with capping it, Delegate Conway, is that the process to determine the fee is just so engaging that it makes it difficult.
Thank you very much.
No other questions now.
Thank you.
House Bill 663 is next. Lopez again, along with Lisa Jordan, Jennifer Mercer, Jonathan Alexander, and that's it. Yes, that's it. Delegate Lopez for 3 minutes, please.
Thank you.
go. Thank you again to the chair and the committee for the opportunity to present to you this bill today. I am still Delegate Leslie Lopez, here to ask for your favorable support of HB 663, excuse me, which allows for a private cause of action for victims of deep fake and revenge porn to sue their abusers in open court. Whether someone steals your image to create pornography or an ex distributes your private photos, you should have the right to sue and seek injunctive relief. That's what HB 663 provides. While deepfake can refer to various altered videos, the reality is stark. 90% of deepfakes are non-consensual pornography, with 95% of those targeting women. Once online, these images, real or fake, are nearly impossible to remove. Likewise, 90% of revenge porn victims are women, and younger women are especially at risk. 68% of victims are between 18 and 30 years old. Maryland law already defines revenge porn as the non-consensual distribution of sexually explicit material with intent to harm, but current protections don't account for deep fake pornography. The impact is devastating. Victims face job loss, extortion, severe mental health consequences, including suicide attempts. Yet AI-driven deepfake creation is becoming cheaper and more accessible, with websites charging as little as $30 for custom videos. With no federal protections in place, states must step up. HB 663 ensures Maryland keeps pace with evolving technology by giving victims a civil cause of action to hold abusers accountable and recover damages. This is my, I think, third or fourth try working on this issue. And each year, the technology advances dramatically. HB 663 brings Maryland into the technological present, empowering victims to fight back against harassment, exploitation, and abuse. I would urge your favorable report.
Good evening, Mr. Chair, Madam Vice Chair, members of the committee. I'm Lisa Jordan with the Maryland Coalition Against Sexual Assault. We're here in support of House Bill 663. As you heard last evening at about this time, there are at least four bills on this issue this year, and Delegate Lopez actually has the most comprehensive bill, I believe, that will be in front of the House, in that she both addresses civil issues and criminal issues. The criminal issues you also heard last evening in Delegate Pippi's bill. On page 2 of our written testimony, I did kind of write down all of the various issues, because each of the bills does have a little bit of a gap. In this particular bill, there is a civil cause of action if you've got a deep fake image, but not an image of your actual body. And we would respectfully suggest that you should also be able to seek compensation for that. There also seems to be a drafting error in that there's punitive damages but not actual damages, and the technical issue of adding costs. I again really just want to repeat that last year the committee got kind of tied up in maybe having a different penalty for real pictures of your body, your actual body, versus images that were generated by a computer but were indistinguishable from your actual body. And just remember, it makes absolutely no difference for the victim. Their mothers, their future employers, the people they might want to date, the people that they work with are going to see their naked image on the internet, and it's indistinguishable from an actual picture of them. So it's not something that we should be treating differently under criminal law. And it's also impractical, because if you make different penalties, different types of recovery for real images versus computer-generated images, you're going to have a mess on the stand of people having to testify about why something looks real versus why something might be computer-generated. For those reasons, we ask for a favorable report on, we really like House Bill 663, but on at least one of the bills that are presented to the General Assembly this year. Thank you.
Good evening, Madam Chair, members of the committee. Once again, Jennifer Mercer, Reproductive Justice, Maryland. We are proud to support House Bill 663 in keeping with our mission to promote reproductive justice and bodily autonomy for all Marylanders. In 2018, both houses of the Maryland General Assembly unanimously passed a bill that became a law, now codified at Criminal Law Article 3-809. That statute prohibits the distribution of pornographic images of another person without that person's consent. also known as revenge porn. At that time, the General Assembly spoke loudly with one voice to affirm that no Marylander should be subjected to the indelible and grievous harm of having one's trust, privacy, and bodily autonomy violated via the non-consensual distribution of intimate images taken in confidence. 7 years later, the technological landscape has changed, and with it, the pool of both potential victims and perpetrators has grown. Deepfake technology makes it possible for anyone to create highly realistic pornographic images of intimate partners and complete strangers alike. All a perpetrator needs is any image of a person's likeness, which they can easily find on someone's social media, school or work page, or campaign website. With that image, someone can generate all manner of pornographic content that is indistinguishable from an authentic image. The grievous emotional, reputational, and economic harm caused by non-consensual pornography cannot be overstated, as the General Assembly recognized in 2018. Now that it is possible to create false pornographic images, we must update our laws to reflect this new technological reality. House Bill 663 will create a civil cause of action against individuals who abuse technology to create and disseminate non-consensual pornography, as well as updating the criminal law. This will serve as a deterrent against this kind of technological abuse. Importantly, this bill also contains provisions for victims to recover attorney's fees and to shield sensitive evidence from public view. Reproductive Justice Maryland urges a favorable report on House Bill 663. Thank you.
Good afternoon, members of the committee. I'm Jonathan Alexander, Legislative Counsel for the Maryland Family Institute. In support of 663, as this bill makes clear that distributing a visual representation that is indistinguishable from an actual image of a person and falsely depicting them in sexual activity constitutes defamation per se, treating it in the same way that we already treat revenge porn in Maryland law. This bill also allows victims to pursue civil actions against perpetrators. It enables them to seek damages. What this legislation does is acknowledges the time that we're in, the evolving use of AI-generated images, and it ensures that the victims of this new modern form of abuse have legal protections. The abuse of deep fake and revenge porn is admittedly new and is evolving, but what it does is causes a person's image to be redistributed to others on social media sites, uploaded to pornography websites without the permission of the person depicted. And that image is used as blackmail. It's traded back and forth as social currency amongst traders and collectors. It's a form of theft of that person's identity. It's extortion and many other predations. As the person that holds that picture or the video of that individual in the palm of their hands also holds the reputation of another person's intimate moment, even if it's real or fake. Right now in the law, victims have little recourse, and so HB 663 does close that gap and allow them to sue perpetrators for fees and damages. This bill ensures accountability and will act as a deterrent against this growing form of exploitation. For that reason, I ask that you give a favorable report to HB 663.
Thank you. Are there any questions? Delegate Conaway.
Quick, Chair. Thank you very much. I just want to understand this deep fake. So let's say if I wore a toupee every day and somebody who was my friend or wasn't my friend said, hey, this is what he looks like probably without his hairpiece, you know what I mean? Would that be a deep fake?
In the context of this bill, you'd have recourse if it rises to the level of obscenity. So if it was used to depict sexual activity that you weren't participating in.
I'm just trying to understand one part, what is deep fake? Because that is like a deep reality.
Yeah, it's making an image that's indistinguishable from your actual image. And we do recognize that in other areas of law and copyright laws, name, image, and likeness are able to be protected in other areas of law. This is just extending it to a very particular area that deals with sexual explicit content, which isn't protected by the First Amendment.
Okay, but I was just trying to understand what defines deep fake. Okay, thank you very much.
No further questions. That concludes the testimony of Bill 663. Now we're going to call up Delegate Long. House Bill 796. Delegate Long. Yep. So, is this Ms. Ruth Griffin?
Say it again.
Ruth Griffin, Claudia Wilson, Randall. And do we have Allison Harris? Okay. Okay, you want to go ahead and you can bring her up? And Delegate Long, whenever you're ready, you'll have 3 minutes. Everyone else will have 2.
Great, thank you, Madam Chair, distinguished members of the House Judiciary Committee. I want to thank you for the opportunity to present House Bill 796, which I've dubbed, in short, the Foreclosure Prevention Act. HB 796 is a necessary measure designed to increase the fees collected from residential mortgage foreclosure actions, which will directly support the Maryland Housing Counseling Fund Program, MHCF, administered by the Maryland Department of Housing and Community Development. The MHCF has been a lifeline for Maryland's nonprofit housing counseling agencies and legal service providers assisting residents at risk of losing their homes. However, in recent years, funding for these essential services has declined significantly, leaving nonprofit partners struggling to meet the growing demand for foreclosure prevention assistance. To address this issue, HB 796 proposes raising the foreclosure filing fee from $300 to $600, an increase that reflects the rising cost of services and inflation since the fee was first established in 2008. Importantly, this increase will not be a burden on the state budget. Instead, it will be paid by the parties initiating foreclosure actions. These entities, which are often private equity funds with significant resources, can typically recoup this fee later in the foreclosure process. Just some quick stats. The report highlights that persistently high foreclosure activity in Prince George's County, Baltimore County, and Baltimore City experiencing the most significant impacts. In total, there were 79,577 notices of intent to foreclose and 7,786 notices of foreclosure statewide. I don't have to highlight for all of you that, especially in Prince George's County and Baltimore City, most of those have been Black and brown homes and marginalized communities. Nonprofit partners play a crucial role in helping homemakers avoid foreclosure, and ensuring they have the resources to continue their work is more important than ever. Increasing this fee would directly support those services, protecting homeowners and stabilizing neighborhoods without drawing from already limited state funds. This legislation is about fairness and sustainability. It ensures that the entities driving foreclosure actions contribute to the cost of mitigating the impact on communities. It empowers Maryland families with access to the counseling and legal services they need to find sustainable solutions. And for these reasons, I ask you for a favorable report on House Bill 796. Got a great panel here that will go further into detail. Thank you.
Thank you, Mr. Long, and whoever's ready to go next.
Good evening. Thank you, Chairwoman and members of the committee for taking the time to listen. I'm Ruth Griffin, Housing Counseling Coordinator for the Community Development Network of Maryland. For those of you who are not familiar with housing counselors, these trained, certified professionals inform and support consumers in meeting their housing needs or working to achieve their housing goals. In 2023, the most recent year for which we have complete data, our network of HUD-certified housing counselors provided services to over 23,000 hardworking Marylanders. From Western Maryland through the Lower Shore, our housing counselors' small but mighty workforce serves individuals and families buying their first home, renting safe and stable housing, or saving the family home from foreclosure. Fortunately, more homeowners are seeking foreclosure prevention counseling early in the process when options to resolve delinquency are better. That's no coincidence. You see, in conjunction with the original legislation for this fee, Maryland required mortgage lenders to send a notice encouraging housing counseling and letting struggling homeowners know what not-for-profit organizations provide free services in their area. When a housing counselor is engaged with borrowers, the foreclosure prevention success rate is higher, both in the number of workouts agreed to and in the sustainability of the workouts arrangements over time. You can review the studies which show this in my written testimony. Over the years, Maryland has developed one of the strongest housing counseling networks in the nation. Still, because our home prices are high and properties are in demand, Maryland's foreclosure rate is among the highest in the nation. At the same time, our housing counseling workforce is at a crossroads. Since this fee was initially enacted, costs of service provision have risen substantially. Meanwhile, federal funding for housing counseling has been largely crisis-driven, and those emergency interventions have stopped. Without this fee increase, reduction in housing counseling capacity will result in loss of jobs for experienced, committed housing counseling professionals. Foreclosing filing revenue is a very sensible process since mortgage lenders benefit from preventing avoidable foreclosures. The fee is only paid if the lender files for foreclosure. Despite drastic home price increases in the last 15 years, the fee has not increased. Please support this legislation to keep Maryland consumers informed and housed. Strong housing counseling builds strong families and strong communities. Thank you for your attention and for all that you as legislators do for Maryland. We ask that you give House Bill 769 a favorable report.
Good evening, members of the committee. My name is Claudia Wilson-Randall. I'm the Executive Director of the Community Development Network. And I just want to highlight a few points that my colleague just went over. First of all, in recent reports, Maryland may be 5th in foreclosure, maybe 3rd in foreclosure, maybe 6th in foreclosure. Either way, we are among the top 10 states in foreclosure. We can argue about which report we like better, but this is a serious issue and will continue to be a serious issue for the state. And we have to address it because it impacts not only state fees, but also local taxes and tax revenue. I would just say that what we hope to do by raising the fee, which has not been raised since it was established in 2010, is to get greater intervention with professionals to stop and mitigate the harm of foreclosures. And foreclosures harm not only people, but also harm place. So foreclosures are also where disinvestment begins in most communities. So we see vacancy and abandonment closely tied with foreclosures. And so we really need to figure out how to intervene and how to intervene early. And housing counselors and legal services providers funded by the Maryland Housing Counseling Fund have been an effective intervention in foreclosures. So I would just ask that you support House Bill 796, and I look forward to any questions. Thank you so much.
Thank you. And we have virtually Allison Harris.
Good evening. I'm Allison Harris. I'm the director of the Home Preservation Project at the Pro Bono Resource Center of Maryland. I'm here as a provider of legal services to low-income homeowners in Maryland facing foreclosure. The foreclosure filing fees, which pays for these legal services and housing counseling services, has remained unchanged at $300 since 2010. As you can imagine, the need for free services for homeowners has increased while this filing fee has not. The Maryland Housing Counseling Fund grants have enabled my organization and my partner organizations to serve hundreds and hundreds of clients over the years. This grant allows us to provide foreclosure counseling to homeowners anywhere in the state, regardless of income, which helps to close that justice gap for middle-income homeowners who cannot afford an attorney but are just over the income threshold to qualify for other available services permitted for only very low-income homeowners. Notably, the other source of funding for this foreclosure work is ending in June. The Maryland Legal Services Corporation, or MLSC, has funded foreclosure legal services across Maryland for many years now, but their funding stream for this work has been depleted. The last fiscal year of MLSC grant support for foreclosure is this year, ending June 30th. This means that those of us providing pro bono legal services must make up these funds elsewhere to continue assisting homeowners, and the Maryland Housing Counseling Fund is without question our main alternative source of funding for this work. Increasing the foreclosure filing fee will help ensure that homeowners across the state have access to expert assistance to avoid foreclosure. We know the positive effect of providing free counsel when something as fundamental as housing is at stake. I urge a favorable report on this bill. Thank you for the opportunity to testify.
Thank you. Are there any questions? I'm going to go to my right and go around. Delegate Embry.
Thank you, Delegate, for bringing this great bill and for having such a wonderful panel.
Could you talk about, I mean, foreclosure is obviously awful for the people involved, but it also impacts the state, and I think that was touched upon. Could you go into a little more detail about how it saves the state money?
Right, and I think it was mentioned that it could save the state money, and roughly, just according to data and stats, the state saves about $30,000 every time we are able to prevent someone's house from going to foreclosure. Thank you.
Delegate Simmons.
Thank you, Madam Chair, and thank you for bringing the bill. Just a follow-up from that, I was just looking at the fiscal note on it. Can you talk a little bit about the fiscal note and what's the impact there?
I'm going to defer to my colleague there.
So I would just say that the fees that have gone into this, traditionally have been, over time, we see that, it has changed. It went down, the fees for the Maryland Housing Counseling Fund went down significantly when foreclosures were stopped during the pandemic. So we've seen it fluctuate a bit, but it's important that we keep that fee coming in and that we're able to sustain the workforce that we have currently. So that's what we're really, I think that's consistent with what the analysis says.
Ms. Harris, do you want to add anything to that?
No, I think that, we've talked about the fact a little bit about how much money it does save the state to prevent, and I think Claudia Randall Wilson has some numbers on this, but how much it can save the state and to rehome folks when they are displaced from their home, and to provide foreclosure prevention services to keep those families in their homes. So I think that is a notable consideration when we're talking about this bill.
Thank you. Delegate Kaufman?
Yes, thank you. Good to see you, Delegate Long.
Likewise, my friend.
I just wanted to give you a chance to respond to the opposition from the Maryland Bankers Association. I'm sure we'll hear from their lobbyists in a minute, but I wanted to hear from you.
Honestly, Delegate, I would love to hear verbally just to get some more understanding as to the opposition, honestly.
So what they say is that your bill increases the cost of mortgage servicing in Maryland. And they also say that they highlight a variety of different services that are already existing for homeowners who are in trouble. For example, foreclosure help for homeowners and mortgage late, don't wait. And so they seem to be suggesting that that it's not necessary because of those resources. And they also say they've seen a decrease in the number of notices of foreclosure and foreclosed property registration. So, what is, can you tell me why they're wrong?
Honestly, Delegate, I believe that because of the amount of foreclosures that we have, of course, seen, but then also the fact that the fund is decreasing, and the fact is also too, I believe on the value of just the argument itself, they'd be opposed in opposition no matter if the fee was $300 to $400 or $400 to $500. I think it will just be a matter of principle.
Yeah, I agree. Thank you.
Thank you.
Thank you. Delegate Conaway.
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. Of the 4,672 foreclosures, what percent of them had a notice and they redeemed their property?
Do you want to respond to that one?
I do not have that data, but I can get that for you.
Okay, so when they do redeem their property, does the homeowner wind up paying the $300 filing fee back?
It's not a direct, but yes.
What do you mean it's not a direct?
So it's in order to, like, once the foreclosure is
been filed,
and then the person is able to redeem.
Yes.
It's wrapped up in the fees, but it doesn't automatically say notice of intent that
but it's wrapped up in the fees. So ultimately, to get your house back, now you would have to pay the $600 instead of paying the $300, right? It's okay to say
yes. Yes.
Just like
yes.
It's okay.
Yes.
No
Okay.
Thank
yes.
you very much.
But it is not directly passed on to the homeowner.
then how is it not directly passed on to the homeowner?
I guess the way I see it differently, because when the foreclosure filing is made,
Yes.
right, and that, you know, there's a lot of fees that are, you know, added, you know.
Sure.
And I just see it.
And in order to get your property back, you have a list of those fees, and you have to pay all of those fees back so that you can redeem.
Ultimately, it's always going to be passed along back.
That's all I ask.
Yes, ultimately, yes.
Thank you very much.
Delegate Taylor?
Quick question, and thank you for this. You said your funding runs out in June of this year, or the funding for the fund via
That's the Maryland Legal Services Corporation. That Maryland Legal Services Corporation, that runs out. The Maryland Housing Counseling Fund does not run out because it's still being funded by the existing $300 filing fee. So those are two different places.
Got it, but if we don't pass this bill, then you don't have the money you need to sustain the support services.
That's correct.
As of June of this.
That's correct. Particularly for the legal services, the housing counseling and legal services.
So is this considered an emergency bill then? Would it be considered an emergency bill
I think it's urgent. I think it's urgent.
You know, because that would have it.
Yes, I don't know that it's an emergency. I think it's urgent. And I think that the point that I'm making is that foreclosure in Maryland is increasing.
Yeah.
And it's not something that we're necessarily focused on right now, because we're not in a situation like we were in 2008 where it was a crisis, right? But I still think that it's a crisis, and it's important to the overall sustainability of taxes and local fees in the state of Maryland.
Thank you, Ms. Wilson-Randall.
Madam Chair, if I can respond as well, too. As it's written, no, it's not drafted as an emergency piece of legislation, but of course, you know, the moment it could potentially take effect, it would be most beneficial to all Marylanders.
Okay, seeing no further questions, that concludes this panel. We have testimony unfavorable. Mr. Robert Enton, let me come on down.
Thank you, Madam Chairman. Robert Enton on behalf of the Maryland Bankers Association. And with all due respect to the sponsor and the proponents, we are opposed to this bill. You know, when we passed the foreclosure bill back in 2008, 2009, 2010, the filing fees then, I believe, were maybe like $100. We had a task force that worked on this, and the industry, the lending industry, agreed to a $300 fee, 3 times what any other filing fee was at that time. And that was in order to fund the counseling. Now, here we are now, and I think the most important thing, and the thing that hasn't been said, is that the number, because we have such a robust and excellent foreclosure process in the state of Maryland, the number of foreclosures has dropped. And when the number of foreclosures drop, in this case by 50%, of course, the $300, you know, the fee, the gross amount of those fees go down. But the reason they go down is because the number of foreclosures has gone down dramatically. So just looking back, you know, in the Department of the Commissioner of Financial Regulation tracks all of this. So from December of 1922 to December of 2022 to 2023, we had 10,783 foreclosures that were notices of foreclosure that was sent out. In the last calendar year, we had 6,542 for and then out of all those loans, out of all those notices of intent to foreclose, the total that actually went to sale and it was 772. We have 1.1 million mortgages in the state of Maryland, and we had a total of 1,772 that went to sale. So with all due respect, the reason that the proceeds have gone down is because the number of foreclosures have gone down so dramatically. That's why we don't think the foreclosing party who hasn't been paid should sustain a 100% increase in the fee to file. Thank you.
Thank you. Are there any questions? Delegate Carden.
Thank you, Madam Chair. Just real quick, ask you to respond to the question that Delegate Conaway asked. If a person gets legal counsel, they redeem, they work everything out, those fees are going to ultimately be paid by the homeowner. Is that correct?
Absolutely. And
that's it.
Okay,
Thanks.
fine. I mean, absolutely.
Delegate Williams?
Yes, thank you, Madam Chair. Good to see you. Quick question. So you mentioned we have a very robust process, and
yes.
At the time when was the fee last increased? I guess it's really the heart of my question.
The what?
When was the last time the fee was increased?
Well, it hasn't been. We agreed to the $300 back when foreclosures, during the, when the
So
bottom
like
fell out of the housing market and
2008.
foreclosures were at an all-time high. We agreed to $300. So it hasn't increased since then, but by the same token, the number of foreclosures has gone down tremendously.
So was that about what, 2007, 2008 during that time?
I think the final legislation may have been enacted in 2010.
2010?
Yeah.
Okay. And Delegate Carden asked the question I was going to ask about the pass along of the fees. But you mentioned that foreclosures have gone down greatly since then, which I think is a good thing.
Yes.
I think that's great. But you're opposed to this, and I guess because of the burden it would place on the party that is.
Let me just say this, that, if I'm, whether it's a bank or whether it's you making a loan, whatever, the bottom line is you made the loan, and now you haven't been paid.
Right.
There are no surpluses in any of these foreclosure sales whatsoever. The lender takes a loss every single time.
Okay.
And, eventually, so what happens is in response to the questions, what happens is, let's say that after the sale, there's a $50,000 deficiency. Okay, so there was $300,000 owed, and it went to sale, and maybe it brought $250 or $200, and that deficiency turns into a deficiency judgment, and that's going to have to be paid ultimately by the borrower. I mean, if he's going to go ahead and borrow money again, get a new home, whatever he's going to do, or if he's going to try to redeem it, and that's why when you look at the statistics. It's amazing to me. We have 1.1 million outstanding mortgages in Maryland, and a total of 1,772 last year actually went to sale.
Got it. And then Delegate Kaufman was citing, I guess, some of the testimony about the increase in the mortgage servicing fees. So when the fee went up back in 2010, when the previous legislation enacted, what percentage of the mortgage servicing fees went up at that time when it was increased previously?
I don't think the mortgage servicing fees, so that's the fee that whoever owns the mortgage, most, 80% of all the mortgages get sold into the secondary market. And that's those companies, they get put in a trust, and those trusts have a licensed mortgage servicer who services the mortgage. And, they're the ones that deal with the foreclosures. I don't think that has any impact whatsoever on what the amount of the filing fee is to file the foreclosure, except that whoever the lender is, whether it's you, me, or whether it's a bank, you're probably going to end up eating it. But at some point, if that homeowner then wants to go, restore their credit and be able to go out and buy another home, they're probably going to have to try to pay it.
Right. Okay. All right. Those were all my questions.
Thank you. I appreciate it.
Thank you. That concludes our testimony for House Bill 796. Now we're going to have testimony for House Bill 85, Delegate Mangione. And we're going to start with just you, Delegate.
Yes, Madam Chair. I don't think Mr. Ellison was able to make it today, so thank you.
So you'll have 3 minutes.
Alrighty. Thank you. I'll be brief, and I know this committee is here late very often, so I'll get right to it. Thank you again, Madam Vice Chair, members of the committee. House Bill 85, this bill is being introduced today as a result of a number of stories across the state of Maryland, including, most importantly, the tragedy that struck a Harford County native, Rachel Morin, a 37-year-old mother of 5 children, who was murdered while going on a run on the Ma and Pa Trail. She was found raped and murdered along the side of the trail. Rachel's murderer hid in a drainage and attacked her as she was running down the trail. This tragedy becomes even worse when we learned that the murderer, Victor Martinez Hernandez, was in this country illegally. This murderer, that was linked to this and other violent crimes by DNA evidence. He crossed the United States border illegally from El Salvador after a warrant for his arrest was issued there. Even worse, this violent criminal was in our country illegally after being expelled 3 times previously. I say again, this murderer, this monster who took the life of a mother of 5, had already been expelled 3 times prior to this murder. HB 85 will not bring Rachel Moore her life back, nor to her 5 children their mother back, or the daughter or sister. However, what HB 85 will do, hopefully, is prevent another horrible tragedy like this from happening and send a message to the world that we will not tolerate these atrocities in the state of Maryland. HB 85 takes 2 important steps. It prohibits a county or municipality from enacting or enforcing a sanctuary policy. It also requires a county or municipality to fully cooperate with ICE, the federal immigration authorities, regarding any individual unlawfully present in the United States who has been convicted of a crime of violence. These tragedies involving violent, illegal alien residents of other countries happen too far often in this country, and now we see tragically in our beloved state of Maryland. If local jurisdictions are required to cooperate with federal authorities in the way HB 85 mandates, it increases the likelihood that criminals may have been detained or deported before they could harm people. By enacting HB 85, Maryland will take a crucial step in preventing future tragedies like the one that claimed the life of Rachel Moore. These examples underscore the importance of ensuring that violent criminals who are unlawfully present in the United States do not remain free to commit more crimes, especially when their immigration status is known. The passing of HB 85 will provide Maryland with the tools to ensure that public safety is not jeopardized by individuals who have already violated the law, and will send a clear message that the state will not tolerate such crimes from anyone, whether they are legal residents or not. We must not allow this to happen again, and we can stop by passing HB 85. I urge a favorable report, and thank you all for your time and consideration.
Thank you. Are there any questions? Yes. Delegate Kaufman?
Yes, very briefly, I just find it interesting because you're an appropriator, Delegate Mangione. Are you aware that there's a nearly $300,000 fiscal note associated with this bill, and then it rises to $348,000, $363,000, and $396,000 by the end of the fiscal note in FY 2020, 2030?
Yes, Delegate, I am, but we have a $60+ billion budget and several $100,000 to protect the lives of Marylanders. I think is a very small price to pay, especially to the Morin family as a perfect example. But yes, I am aware of that.
Thank you, Madam Chair.
Thank you.
Delegate Erica?
Thank you, Madam Chair. Thank you, Delegate, for bringing this bill. As you probably know, the Ma and Pa Trail runs through my district. So I really appreciate you bringing this forward and talking about what happened in our community in Harford County. I just want to understand, does your bill, it doesn't mandate the 287G program, does it? Or is that kind of what you're getting at?
Well, no, it's slightly different, but I mean, obviously the 287G program's similar, but it's just a little bit different than that, yes.
Okay, so this would, I mean, I know, for example, right now Howard County is considered a sanctuary county, so it would prohibit Howard County from what they're doing, which is essentially like ignoring ICE detainers at will whenever they feel like it.
Yeah, that ultimately is what the bill is trying to have a cooperation with ICE and the counties, and there are several that are considered we would call sanctuary counties, and there's been examples where there was ICE detainers where unfortunately individuals that committed serious crimes were allowed back onto the streets because there wasn't that cooperation there.
Right, yeah, that's totally disturbing, so I really appreciate you.
Thank you, Delegate.
Delegate Grammer.
Thank you, Madam Chair, and thanks for bringing the bill today. So I remember a floor debate on the House floor one year, and I brought up the 9/11 Commission and how the 9/11 Commission talked about the need for federal, state, and local law enforcement to work together for certain, public safety capacities. When President Trump was elected, we saw a lot of different ICE activity through the state. I'm looking at an article here, a child pornography distributor, a murderer, an armed robber, and a drug dealer were all collected in one day by ICE activities. Are these the kind of, as I saw, all the initial hundreds or thousands of criminals who were detained, were these violent offenders? And I wanted to say, are these the way that this is sold to us is we shouldn't do this, as there are folks sitting on a bench eating a peanut butter and jelly sandwich who are going to get snagged up under this. Is it the peanut butter and jelly sandwich eaters, or is it, the more violent offenders who you're going after with this bill?
Thank you, Delegate. It's precisely the more violent offenders. And after conversations with Mr. Elston, the ICE director in Maryland, he explained to me specifically that they are targeting violent offenders. That's solely violent offenders, and the narrative that they were going into schools, for example, was a false one.
Do you mean they're not going into schools whatsoever? Is that what you meant?
That was his words as the ICE director.
Gotcha. Thank you so much.
Yeah.
Delegate Thomason, and then Delegate Valentine.
Thank you, Madam Chair. I'm looking at the public defender's testimony. Spoiler alert, they don't like it. The third paragraph down, they say the definition of sanctuary policy under HB 85 is vague, overbroad, and troubling. It is sanctuary. I mean, what in your mind? How would you define sanctuary? And is it defined, or is it just kind of? I know we kind of use it a little loosely.
We do use it. I know in the fiscal note, which I have in this they gave us a definition, but for me, my basic definition is counties. Again, I can go as simple as not cooperating with law enforcement when it comes. In this particular case, we want it to be towards violent criminals, but basically counties that harbor those here illegally without cooperating with law enforcement when some type of law enforcement action happens.
Gotcha. All right, thank you.
I just have one question, and in the research you've done leading up to this bill and this legislation, have you found, based on the recent tragedies we've seen in the last year or two, in researching this, have any other states, that may have been, kind of leaning this way or moving towards this type of a statute or by policy, or are you familiar with any of that might be moving this direction?
Well, I can answer in two ways. Yeah, number one, I know there are a number of states that already implement policies that are similar to this. And number two, I would say, as an example of why, for example, that we should move to a policy like this, we're in my very own home county in Baltimore, that there were statistics that that the county, which actually to the county's credit, they're moving a little bit away from this, where they dismissed about 70% of the detainers from 22 and 23, where ICE claimed about 57 undocumented immigrants facing criminal charges were placed back on the Baltimore County streets. So yes, it's already happening in a number of counties, and I believe for reasons like I just cited is exactly why it should be happening. Other states, I'm sorry, in our state, obviously in other counties.
Thank you, Delegate. Thank you, Madam.
All right, seeing no further questions, we're going to move on to the unfavorable.
Thank you, Madam Vice Chair.
Thank you. We're going to move on to the unfavorable panel. And we have one person virtual, Eric Lopez? No? Okay. So, Ms. Hoydra?
That's correct. Thank you so much.
All right, so you have 2 minutes.
Madam Vice Chair and distinguished members of the committee, my name is Sherry Hoydra. I'm a private immigration attorney, small business owner, and the chair of the MSBA Immigration Section. We are a large group of private attorneys, judges, and other immigration practitioners. We strongly oppose this bill. As drafted, it will lead to constitutional issues, and also the language is at odds with state law. It seeks to turn Maryland law enforcement into federal immigration agents. The bill is not enforceable either due to the impossibility to carry out the bill's requirements under the Immigration and Nationality Act. The INA is a set of complex federal statutes governing who can enter and remain in the U.S., whether to release or detain a person, and whether someone's here in violation of the law. House Bill 85 attempts to punish Maryland counties and municipalities based on a misunderstanding of federal law. The language of the bill is defective. The new proposed subtitle of the local government article 1-601F2 and 1-602B use the terms unlawfully present and lawful presence. The INA does not define those terms. So it's impossible to sanction a state or municipality for granting lawful presence within state boundaries in violation of federal law. The INA also uses the term unlawfully present only in one context, and that's when you leave the country after having been here under unauthorized stay and then re-seeking admission to the United States. So the terminology itself is problematic. Moreover, as we've heard, there's a lot of fiscal consequences to doing this. The bill also violates separation of powers. The 10th Amendment makes it clear that the federal government cannot mandate state and local authorities to carry out federal immigration functions. The INA itself does not have a sanction for declining to assist federal law enforcement. Maryland criminal procedure.
You can finish your sentence.
Maryland Criminal Procedure Article 504 passed in 2018 makes clear that our state does not carry out federal immigration functions. And to do so by repealing that, what we've already put in place would put us into fiscal jeopardy in the state. Thank you. We ask that you issue an unfavorable report on House Bill 85. Thank you.
Thank you. Are there any questions? Seeing none? Oh, okay. You have to shine your light brighter, Delegate Grammer. Delegate Grammer.
Shine my light as bright as I can today. Should the state and the local jurisdictions work with ICE on detainers?
You know, they have the opportunity to do so. I mean, if there's a detainer put in place and the jurisdiction itself is willing to use or has a system in place in order to use local resources to follow through with those detainers, we hear those Howard County is a sanctuary, has a sanctuary policy, so does Montgomery County, et cetera, or PG County. Really what their law or their Liberty Act has done is to say they're not going to use Howard County resources in order to follow through on mandating or doing what they're asking to do is to hold people over for that 48 hours necessarily. But the actual law as written in those counties is not at odds with federal immigration law. It actually is still lawful based on the way the INA is actually written.
Well, it gets to my more specific question. I've heard you have a lot of problems with the bill specifically, but I'm trying to get at your opinion. Should local jurisdictions, whether we have a difference between Baltimore County and Montgomery, and Montgomery is, from what I understand, complying because they have a big problem, but Howard County does things a little bit different. They don't want to hold folks for 48 hours, even if they're, in some of these cases, actual violent criminals who end up getting puked out on the street, and somewhere else in the state they commit another crime. So I just want to suss out, is your problem with the bill a technical one, and you think that local jurisdictions, I'm going to try this a third time, local jurisdictions should find a way to work with ICE at least in a capacity for violent criminals, or do you not think they should work with the federal government at all?
So I think it's inappropriate for state law enforcement to be inquiring based on the language of the bill about immigration status and asking questions that don't go to the materiality of the criminal action itself. So I find that portion of the bill is inappropriate. Also, utilizing the term unlawful presence or lawful presence when there's no true definition of that anywhere to be found. I find that to be inappropriate as well, given that as attorneys, we seek to, state law cannot create or interpret or mandate federal law itself. So for me, a lot of it is logistical. The issues that I have with it or that we have with it as a section is the way it's drafted. About whether or not they're going to actually enforce the detainers, I believe personally, and I'm not speaking on behalf of the section, depending on the circumstances of the facts of the criminality of that action and that jurisdiction, that might be something that in that specific area is appropriate, okay? However, we just heard earlier from Delegate Mangione that this is really tailored towards violent offenses. I read the bill very clearly. It is not tailored towards violent offenses only. So I find that to be way too broad and will lead to us having a crisis with law enforcement having to answer those questions when they seek, to detain someone.
Let me make one final attempt to drive it down to what I think he's getting at. Do you think jurisdictions should work with ICE and comply to hold specifically violent offenders if ICE has issued a detainer request?
I would need to see the list of the types of offenses where they would find that to be appropriate before I could rationally answer your question.
Crimes of violence.
Depends on the fact pattern of the crime of violence.
Thank you.
Thank you.
Thank you. Okay, seeing no further questions, that concludes the testimony for House Bill 85. We're going to move on to Delegate Embry with House Bill 594. And Delegate Embry, is Eric Stravats available? Juan Puga Nieto?
Would it be all right to bring up a sponsor panel?
Sure.
Mr. Weeks is here.
Jed Weeks?
Just fill it up.
So just tell me who everybody is so I can just check you off, please.
Got Jed Weeks here.
Okay.
Samuel Canner.
Juan Puga Nieto.
Say your name again? Did you say Juan?
Juan Puga Nieto.
Nieta, I like that. Okay.
Nieto.
Isn't that Nieto, right? Yes, okay. And then we have, is this part of your panel as well, virtual Kali Crumpos? And
Yes, that'd be
Rachel-
great. Is she there? And is Rachel?
And Rachel Manning.
Perfect. Thank you so much.
Okay.
All set.
All right, so Delegate, you have 3 minutes.
Thank you, Madam Vice Chair and all my favorite committee members. I know you were hoping we could talk a little bit more about civil liability, so I have brought this bill this evening for us to do so. You're welcome. So this is a slightly different issue, quite a different issue in the world of negligence and tort claims. So Maryland is one of 4 states in the country that follows a theory called contributory negligence. The other states, the other 46 states, follow comparative negligence. I will talk about DC in a little while because what we're doing is similar to what DC did. It also had followed exclusively contributory and then passed a bill about 2016, I believe. I may be wrong about that, but in recent years, and our bill is modeled on that. What is contributory negligence? What is comparative negligence? Contributory negligence, and I know the lawyers in here know this, but I'll still just go back to basics. Contributory negligence, the theory is if the person who is harmed, the plaintiff, if they have in any way contributed to the harm, like 1%, they are barred completely from recovery. Comparative negligence says you apportion responsibility based on who was at fault. So if a person is 50% or 60% or 70% liable, that is attributed to them, that percentage. So contributory bars any recovery from a plaintiff if there's any argument or any finding that they contributed. So that is a huge burden and bar to recovery for plaintiffs. Now, we are not seeking in this bill to overturn contributory negligence in Maryland, although there's good arguments to do that, and I think some of the panelists will talk about the history of contributory negligence and why it's a problem more generally, but we're not doing that. What we're doing is what DC did. DC, Maryland, we created in 2021, a bill put forward by Delegate Stein. We created a category of people in Maryland called vulnerable road users, and that's people who are walking, that's people providing emergency services in the road or next to the road, people on farm equipment, people in wheelchairs, people on electric bikes, people on motorcycles, this category of vulnerable road users. And we carved that out because we thought they required special protections from automobiles. And so under that section of the transportation code, if you hit a vulnerable road user with a car, you're subject to specific and special penalties. So what we're doing, what DC did, is say for that category of people, vulnerable road users, they are not subject to contributory negligence. They have access to comparative negligence. But they have to show that the person who hit them in the car, and this is only in where a car hits a person, only in those incidents, they have to show that the person driving the car was more than 50% liable. So it's still an obstacle to overcome. They still have to show that the person who hit them bears more of the responsibility for what happened than they do. In those instances, they are then able to obtain relief for the portion that was caused by the person who hit them. So I ran out of time, but I have wonderful panel members who can do a much better job explaining. Thank you.
Good evening, Vice Chairs Bartlett, esteemed members.
Mr. Nieto, yes. Thank you.
Good evening. Thank you for the opportunity to speak today. My name is Juan Carlos Puga. I am a Baltimore City resident, daily walker, avid cyclist, and a personal injury attorney representing hundreds of injured individuals in multiple vehicle crashes. I strongly support this bill, which will finally bring fairness to Maryland's negligence laws for vulnerable road users. Maryland is one of 4 jurisdictions that still use contributory negligence, a doctrine that bars these, as Delegate Ember said, bars injured victims from any recovery, even if they are 1% at fault, even if it's a technicality. 46 states have abolished this. They have not gone back to it. The Maryland Court of Appeals criticized this rule in 2013 in a case called Coleman versus Soccer Association of Columbia. The court in that case asked plaintiffs to go across the street to change the law, and here we are. Judge Harrell and Judge Bell in their dissent famously described contributory negligence as a dinosaur that should be extinct by a modern asteroid strike, yet over a decade later, it's still here, roaming our courts and preventing vulnerable road users from getting justice they deserve. DC recognized this unfairness, and the implementation of this law has not led to any negative consequences. No major insurance carriers are pulled from the market. Rather, it has promoted the fairness that vulnerable road users deserve. Maryland, there's a clear and power balance on Maryland's roads. A pedestrian, a walker has no match against a multi-ton vehicle. Yet, under current law, if this walker makes a small mistake, such as crossing the road right outside of the crosswalk, when a distracted driver that's texting, speeding, hits them at a higher rate of speed, they could be denied any compensation for their medical bills, their lost wages, over that small technicality. House Bill 594 does not let anyone off the hook. Instead, it prevents the plaintiff from recovering the percentage that they contributed to that negligence.
Thank you.
I obviously would ask a favorable report. Thank you.
Thank you.
Okay. Hi, thank you for the opportunity to speak today. My name is Samuel Canner, and I'm here to share my personal experience as a victim of Maryland's outdated contributory negligence law. I urge you to pass House Bill 594. On July 29th, 2024, I was lawfully riding my bike southbound on the Jones Falls Trail, a designated two-way shared use walking and biking path. As I crossed East Fayette Street along President in a crossing explicitly marked for both pedestrians and cyclists, a driver turning right from the northbound President Street failed to yield and struck me. I was following all traffic laws and crossing a clearly designated, signed, and marked intersection with a green pedestrian light, yet I was the one left with injuries and medical bills. When I filed a claim with the driver's insurance company, I was stunned to learn that I was denied outright, not because the driver wasn't at fault, but because of Maryland's contributory negligence law bars me from any compensation, even though I was found at 1% at fault. The insurance company argued that I should have somehow anticipated the driver's failure to yield and avoided the crash, and therefore am responsible to pay all damages that the vehicle did when they struck me. This is despite the fact that I was riding where I was supposed to be, an illegally designated bike crossing with clear markings and proper signage. I used to bike to work every day, but now I'm too scared to even touch a bike in fear I'll end up hospitalized by another inattentive driver and be forced into bankruptcy or extreme debt by an insurance company. Under House Bill 594, situations like mine will be treated fairly. Instead of completely barring my claim because of some small technicality, the court would consider actual faults and responsibility. If the driver was overwhelmingly at fault, I will still be able to recover at least my portion of the medical bills and lost wages, rather than being left with nothing. It isn't about me, it's about every pedestrian cyclist in Maryland who uses designated crossings, follows the rules, and still gets hurt because drivers fail to yield. And it's about making sure that outdated legal doctrines don't shield negligent drivers from responsibility. I urge you to pass House Bill 594. Thank you.
Thank you. Yep.
Good evening. My name is Jed Weeks. I'm the Executive Director of Bike More, Baltimore City's biking, walking, public transit advocacy organization. In my line of work, I talk to too many families who've lost a father, a daughter, a husband, or whose family member will never recover to be the person they were before a crash. 2 years ago this month, I received a call about a crash just blocks from my house. I did not at all expect what I found. The victim of the crash was my wife when I arrived at the scene. The driver of a parked car, distracted while talking on FaceTime, had flung his door open into traffic without looking, hitting my wife off her bike. Her helmet was shattered, as was her right hand. She was on a loop of questions as a result of her traumatic brain injury. For 7 hours, she could not communicate beyond asking me the same 4 questions. Where was our son? If I'd called her work? If she'd been doored by a driver? If the driver had stayed on the scene? The second I finished answering those questions, the loop would start again. After multiple surgeries, months out of work, 2 years of therapy, she's regained most of the motion in her hand, and aside from no memory of that day, her brain seems to have mostly recovered. The driver was uninjured. There was barely a scratch on his car. He was able to tell his side of the story to the police. My wife was not. She was in an ambulance. The law in Maryland is explicitly clear that a driver opening their door is responsible for ensuring that it's safe to do so. My wife was operating her bicycle completely lawfully in the travel lane, and the driver admitted fault at the scene. Yet my wife received a denial letter from his insurer listing her contributory negligence. The insurer did not dispute that their driver was negligent in flinging his door open into my wife, but they claim she should have maintained control of her bike after being hit, that it was her fault that she landed on the ground and was injured. As an advocate in this field, I knew to fight this. I've referred countless families to lawyers and knew one to call. Many families aren't so lucky. They don't have the privilege or knowledge that we had. This is something we should even fight. Insurers deny vulnerable road user claims based on contributory negligence because they know they can get away with it most of the time. It isn't fair, it's not right. 46 other states and DC survive just fine with a more equitable system, so I encourage us to do the same thing. Thank you.
Thank you. Well, let's go ahead and go back to our virtual, if they're still there. Callie Crumpos and Rachel Manny. Okay, Ms. Manny, if you want to start.
Sure. Thank you very much. My name is Rachel Maney. I'm the National Director of Bike Law. Maryland adopted contributory negligence in 1847. That was 50 years before the invention of the car. The law was meant to protect industrial and railroad development in the first part of the 19th century, which is completely inapplicable now. Common law should not be static. It should keep pace with the world, and it should seek fair solutions to pressing societal problems. The common law of contributory negligence contradicts every word of Maryland's vulnerable road user law, which expressly defines the heightened duty of motorists, which they owe to cyclists and pedestrians. The natural cultural and civil progression from the updated criminal standard provided by Maryland's VRU is an amendment and carve out for bikers and walkers, exactly as DC did in 2016. Most importantly, we know it works. 46 states have switched from to comparative fault, and 0 states have switched back. When the district eradicated contrib for cyclists and pedestrians, no adverse impact to any Washington industry occurred. In fact, our neighboring jurisdiction has increased the number of insured drivers since 2016, successfully encouraged pre-suit and pre-trial settlements, and reduced the amount of taxpayer dollars needed for court resources because cycling plaintiffs no longer have to take their injury cases to trial. Maryland businesses and insurance companies simply will not suffer from this proposed tort reform. Delaware, for example, is a comparative jurisdiction which has been ranked the nation's most business-friendly state by the U.S. Chamber of Commerce for decades. For cyclists and pedestrians, liability and coverage denials based on contrib defenses are the result of police crash reports, which are inadmissible anyway. The last clear chance doctrine as a defense to contrib has actually cost carriers and defendants more. In Cook County, a defense lawyer made a study of 4,000 plaintiffs before and after Illinois switched to comparative fault. Those who recovered pursuant to last clear chance received all of their damages under contrib, while their awards were reduced by their share of negligence under the reformed comparative fault standard. There is no slippery slope. Bicyclists account for a tiny and inconsequential percentage of tort cases in Maryland across the country. However, insurance companies continue to pay significantly more as a result of this antiquated law because cyclists who are forced to sue drivers and take their injury cases to trial do win something, while their carriers incur unnecessary defense costs. Under this proposed tort reform, those defense costs would decrease. The need to prove plaintiff's negligence and last clear chance.
Ms. Manny, thank you. Thank you. Ms. Crumpos.
Chair and members of the Ms. Kelly Crumpos, and I'm the Advocacy Director at the Washington Area Bicyclist Association. We're supportive of HB 594, and we're here to support for our 1,000 Maryland members and nearly 23,000 regional advocacy supporters. HB 594 would update Maryland's antiquated and unfair contributory negligence standard. We encourage Maryland to follow the lead of the vast majority of states to apply comparative fault principles in crashes involving vulnerable roadway users to ensure fairness of recovery for injury. We've been very supportive of reforms to contributory negligence for vulnerable road users in Washington, D.C., as well as in Maryland. In D.C., the Motor Vehicle Collision Recovery Act of 2016 passed after years of long campaigning. After the reforms in D.C., as we just heard, there had been no measurable change in auto insurance rates or number of civil cases involving bicyclists. Not only that, in 2017, injured bicyclists and pedestrians were being compensated for negligent driving more expeditiously and without the need for additional litigation. In Maryland, like in the district, people walking, biking, and using mobility devices operate clearly within a context of poor enforcement of protected provisions and are vulnerable in crashes. This improper application of the law is compounded by the contributory negligence doctrine, which threatens to prevent cyclists in crashes from any recovery. The comparative negligence system is fundamentally more fair to already vulnerable road users and will improve outcomes not only for those who find access to the legal system, but also to those whose claims are denied by insurers, even when the other party is at greater fault. WABA requests that the committee support the passage of HB 594. Thank you.
Thank you. Questions, Delegate Arakan.
Thank you, Madam Chair. Thank you, Delegate, for bringing this. So I have a what if, but it's a real case. A close friend of our family's, they immigrated here from Haiti. Her daughter was working at the hospital. She was probably in her early 20s. She was crossing a portion of road where there was no crosswalk for a lengthy period of time. It's a commonly used space, though. People in the neighborhood often will walk to the services, groceries, et cetera. So people are there. I mean, I grew up in Howard County. Everyone knows people walk across the road there. She was hit. She was severely injured. Thank God she didn't die. But I mean, she lost everything. She lost her ability to work. I mean, for more than a year, I think she had so many surgeries. She was eligible for nothing, no compensation, even though the driver was driving 15 or 20 miles over the speed limit, totally irrelevant because she was not in a marked crosswalk. Is this going to help somebody like her?
Delegate, that is exactly who it's going to help.
Yeah.
That is a precisely correct example, because yes, she should have, right, of course, but that is like a minuscule portion of the fault, and the fault is overwhelmingly with the driver. And so under Maryland law, currently she gets nothing.
Yeah, she got nothing. She lost. And the saddest part was that her father was aging. She was working to contribute to support her whole family. I mean, it was catastrophic financially for the family. So I appreciate that. Thanks for the bill.
Thank you. Delegate Cardin.
Just real quick. So I actually had a real client, a client in a real situation who was killed. I represent the family. He was running across the street. He was dressed in all black with a black hoodie over in the middle of the night. She was speeding, but not speeding tremendously. I think she was going like 10 miles over the speed limit at like 35 and a 25. He was not in a crosswalk. We had a mediator who tried to, and we just decided, you know what? I knew I was going to lose on contrib. So I just made a deal with the insurance company that if I'm determined to be 50% or more, you pay $20,000. If you're determined to be 50% or more, you pay $80,000. And we were just going to leave it at that. We lost. The mediator basically said, you're 51%. So in this case, I guess, long story short, if you're determined that the car is 51%, and they're going to pay 51% of all the damages altogether, they're going to pay 51% of the damages just to the injured party. Because
so the threshold, right? So I mean, very similar to your scenario. The threshold even to be eligible would be that they have to show 51%.
Right. So I would have lost. I understand that. But if I would have won, and it would have been a case, and let's say there was $100,000 damage to the car, and let's just say, for the sake of argument, $100,000 damage to the individual hit. So would they have to pay $51,000 to me? And that's it? That's the end of it?
I mean,
I'll let the lawyers answer because it's
correct. Comparative negligence. If that case went to trial and it was determined that the damages were $100,000 and the plaintiff and the defendant had contributed, like, it was 51% of the fault, they would be required to pay 51% of the damages to the plaintiff. So it would be $51,000.
Right, but if the damages were evenly divided between the plaintiff and...
Well, I guess that would be the counterclaim, right? So you're talking, I think you're confusing the damages of the defendant claiming their damages.
I understand.
So if
so there has to be a counterclaim in order for the defendant to be able to share in the damages.
Yep.
Okay, thank you.
All right, I had some questions on last clear chance, but we could talk about it later. Thank you very much. That concludes the testimony. Well, no, it doesn't. It concludes this panel on House Bill 594. Thank you. So we have we have more people who want to testify in favor. We have Nigel Samaru and John Corrin. Okay. Oh, hi, John. Sorry. I didn't see you there. I actually don't have anybody else listed. Wait a minute. Yes, I do. Eric Strebats. Okay.
Thank you.
And Franz Schneiderman.
Thank you.
I'll go.
All righty. So let's go from left to right. Did I do that right? Yeah. All right. Thank you. If that's okay with you all. Otherwise, you can start in any order you want.
Thank you, Madam Vice Chair and members of the committee. My name is Franz Schneiderman. I work with a group called Consumer Auto Maryland. We work for safety and transparency for drivers and road users and consumers across Maryland. I'm also a fairly avid cyclist in Baltimore City and Baltimore County. Just fundamentally, we support this bill because it should give a fairer opportunity to recover to hundreds and even thousands of vulnerable road users who are injured every year, chiefly as a result of negligence or misconduct by drivers and other road users. So the lawyers can talk more to the doctrine itself, but as an advocate for road safety, it occurs to me that Maryland has made a lot of efforts over the last 10 years to try to protect, particularly people who need protection on the road. Delegate Embry mentioned the 2021 Vulnerable Road User Law. We've also worked to establish a whole bunch of Vision Zero strategies that work to protect the most vulnerable on the roads, and those are positive changes. But, the continued use of this rather antiquated negligence doctrine seems to me continues to put vulnerable road users at unnecessary risk and unfairly deny them the ability to recover for damages. So hope you'll support the bill and give it a favorable report. Thank you.
Good evening, Madam Vice Chair Bartlett, members of the House Judiciary Committee. My name is Nigel Sammer. I'm on the board of Bike Maryland, chair of the Advocacy Committee of the Baltimore Bicycling Club, and an appointed member of the Maryland Bicycle and Pedestrian Advisory Committee. Thank you for the opportunity to testify today in support of HB 594, which proposes to change the existing law of contributory negligence to comparative negligence for vulnerable road users here in Maryland. Maryland, as you've heard, remains only one of 4 states, along with the District of Columbia, that still follow the law of contributory negligence. But in 2016, DC decided to enact a law that is similar to what HB 594 proposes. And in 2017, I was hit by a driver while biking. It resulted in a broken neck and immediate right-sided paralysis. The driver admitted he saw me coming and wanted to beat me to make a left turn. He was charged with failure to yield, received a ticket, a fine, and a few points. I was transported to shock trauma. It would take me a lot of time and physical therapy to learn how to walk and recover movement of my right side. I have permanent lifelong injuries to my spinal cord that will require medical monitoring for the rest of my life, in addition to the 24/7 health conditions I'm left to deal with. Imagine if, in my case, the legal team for the driver was able to say that I in any way contributed to what happened to me that day. It would have meant being unable to recover any civil damages at all to help pay for the medical care for the rest of my life. Thankfully for me, that was not the case, but for many VRUs like myself, it is not. It's very unfair to those VRUs who are left with crippling medical bills, lost wages, etc., and medical injuries, even if there is a minimal perceived negligence on the part of the VRU. This bill will provide equitable relief for victims. It would also help send a message to all who use our roadways with respect to the safety of VRUs. Thank you for your time. I ask for a favorable vote for HB 594.
Thank you. My name's Eric Stravitz. Thank you, Madam Vice Chairman and delegates. I'm a cyclist. I walk for exercise, and I've been a plaintiff's trial lawyer for over 30 years, practicing in Maryland and DC. I come at this from 2 perspectives. One is decisions that jurors make. The other is decisions that lawyers make, like myself. I've tried cases with jurors. One juror in a Virginia case where lawyers get to question the jurors directly. She seemed very pleasant, was very nice to both me and the defense attorney. And at one point I asked her, do you have any particular feelings for cyclists? And this was in a cyclist versus car case. And she completely changed her attitude and just got really angry and talked about how all the cyclists are weaving in and out of her lane when she's driving to her commute in Washington. And it was very clear to me that my client, who was the cyclist, could not get a fair trial if she were on that panel. In my experience, jurors often assume that cyclists, walkers, and other vulnerable road users do things wrong, even when there's no competent evidence that they've done anything wrong, just because they happen to be near cars and other motor vehicles. In terms of decisions that lawyers make, Delegate Arikin had that story. 1% contrib kills the cases of vulnerable road users. A good plaintiff's attorney has to be very careful with the cases that they take because we don't get paid if our cases lose, and we'll have an upset client at the end of that case. So this affects the ability of plaintiffs who may be minimally negligent to get justice in Maryland. It's very easy for a good defense attorney to manufacture 1% contributory negligence. Plaintiffs are, thank you very much. Hope
If you
vote
wanted to
favorable.
finish that sentence.
Yeah, I was going to say plaintiffs are often deposed for hours. Depositions are stressful, they're unnatural, and it's very easy for a plaintiff to make a mistake that could then be turned into contributory negligence. Thank you.
Thank you, John.
I'm John Corrin with Bicycle Advocates for Annapolis and Anne Arundel County, but today representing a broad coalition of advocacy organizations from across the state of Maryland. I served on the 2017 Maryland Bicycle Safety Task Force that was created by the legislature. We had a variety of recommendations on how to improve safety, not only for cyclists, but for all vulnerable road users. That includes infrastructure improvements, education, enforcement, but we also had a list of legislative recommendations. This was one of the top 3. The other 2 have already been implemented. One being the Vulnerable Road User Law, which was already mentioned, another having to do with safe passing. I'm going to quote Yogi Berra, with whom I paraphrase, with whom I share a birthday. This bill is 90% about fairness, and the other half is about deterrence. Having fair relief for victims not only will give them some justice after being a victim, but it will deter drivers and encourage them to behave safely in the vicinity of vulnerable road users. The degree of opposition that we saw tells me that they care about this, and they care mostly about their pocketbooks. And the best way for them to preserve their pocketbooks is to drive more safely in the vicinity of VRUs so that these crashes don't happen. In 2024, over 570 people were killed on Maryland roadways. 43% were vulnerable road users. That's an alarming increase in both percent and absolute numbers. Please give us a favorable report, and let's get this to the House floor. Thank you.
Thank you. Are there any questions? Okay. Seeing none. Thank you for being here. Now we're going to hear from the opponents, and we have Chris Corchiarino? No? Nancy Egan, but I don't see her here, and Robert Etton.
Thank you. Long day.
Yeah, it's a long day.
Thank you very much.
You're the only one who stayed, so thank you.
Robert Etton on behalf of the American Property Casualty Insurers Association. You have our written testimony. I want to focus, let me just start out by saying this would be a sea change in Maryland law, a sea change. And this committee typically, I think when it looks at things like this, says, you know, we've got to take a look at what the impact of this is going to be. This is a step that we've never taken in, almost 100 years to change the rule that we have for contributory negligence. Now, if you look at the fiscal note, and you even just look at the fiscal summary, what does it say? Potential significant increase in special fund expenditures and general fund expenditures if the bill increases payments and tort claims against the state and assessments on affected agencies. Local effect, potential significant increase in local expenditures for tort claims against local governments. You know, the problem is that, and that doesn't speak to what's going to happen if you start down this path, because next year it'll be a bill from our good friends who were here earlier today saying, you know what, we need to change it for everything, not just for citizens. And my heart goes out to the people that you've heard, but you know that's what the rule is. If you look at Ms. Egan's written testimony from the American Property Casualty Insurers Association, you'll see there have been national studies on what the increased cost is for having comparative fault. There's a study that was done which showed that in a 4-year period after changing to a comparative fault system, premiums for Delaware drivers increased at the rate of 18.61%. Same thing, another study that was done that says that stats with comparative negligence standards have substantially higher automobile loss cost. So I understand, I sympathize with what you heard, but the bottom line is if we're going to take a step down this road, it needs to be studied. We need to have a full look at it and then make a decision, do you really want to go this way? Thank you.
Thank you. Are there any questions? Yes? No? Okay. Thank you very much. That concludes our testimony for House Bill 594. Delegate Simmons, are you ready for House Bill 713? We're going to, do you want me to call up favorable with amendment?
Yeah, that's fine.
Okay, Lorenzo Bellamy, Tony Geenan. That's it. Is Tony here? No? All right. So delegate, 3 minutes, whenever you're ready.
Thank you, Madam Chair and distinguished members. Delegate Gary Simmons, District 12B, for the record, coming to you with House Bill 713, public safety, distribution of literature and purchase of firearms and ammunition. Obviously, this is an oldie but goodie as we look at the Supreme Court on this matter, took no issue with it, took no opinion with it. We're looking to, once again, look at ways of enhancing information that's being given out during the purchase of firearms and or ammunition during that time where the state health department working with our local county health departments will issue literature to these establishments to be given out for safety concerns. With that, I have a written statement on file explaining in detail my statement. With that, I would like to move to our witness.
Thank you, Delegate Simmons. I'm looking at your bracelet there. It looks like we got the memo.
No, absolutely.
Yeah,
yes. It's totally appropriate.
Uh-oh, 5 seconds already. That's okay. Good afternoon, Madam Vice Chair, members of the committee. Lorenzo Bellamy here on behalf of a new organization that was formed in 2022 called Teachers Unify to End Gun Violence. I'm also here on behalf of Everytown for Gun Safety, and they've submitted written testimony. The organization that I represent, Teachers Unified to End Gun Violence, was formed in 2022 as a grassroots organization to give teachers the opportunity to have a voice. A lot of times teachers are not involved or you don't hear their voice significantly when it comes to gun safety. Our position on this bill, Delegate Simmons has described it as a bill that distributes literature to FFLs and those who sell firearms and ammunition in the state of Maryland in the respective counties. We have no issues with this legislation. The only thing that we would like to add is an amendment that would add the word safe storage under the list of things that the literature would include. I know that there are many things that are in there, but we'd love to see safe storage, even though it does say firearm safety. We would specifically like the word safe storage added to the legislation. Other than that, we support this bill. Thank you for your attention.
Thank you. Questions, and I see Delegate Sample Hughes.
It's real brief for you. The civil penalty, is that imposed on the store owner if they don't pass out this literature?
That's correct.
Is this like something standard that we do?
Yes.
Oh, okay. Okay, thank you.
Yeah.
Any other questions? Seeing none, that concludes the favorable testimony for House Bill 713. We're going to move over to unfavorable testimony. Mr. Jocelyn, Mr. Pinnock, and Ms. Novotny.
Chair,
My name is Mark Pennick. I'm the president of Maryland Shall Issue, and in the interest of full disclosure, I am counsel of record for the Anne Arundel case on which this bill is based. So you have my written testimony that talks about all the constitutional issues associated with this. If the state enacts this bill and the state health department issues regulations or literature that's compelling the dealers to distribute, if it's not purely factual, uncontroversial commercial speech, it will be challenged. But let me proceed on a more practical basis. And that is, I represent dealers. And I will tell you how the dealers will resent to the nth degree being compelled to be the state's puppet, which is what this bill does. If you really want to do this, then you should make it voluntary and not compulsory compliance, because nobody likes to be compelled. So what the dealers will do, and what the dealers have done in Anne Arundel County, is they put a garbage can next to the counter and distribute the literature to the customer and say, the states, or in that case, the county is making me give this to you. You are free to throw it away. And I invite you to do so because I disagree with it, and I think you should too. And poof, all that literature goes into the round bin, fills the landfills. So congratulations, the bill would accomplish nothing. It has accomplished nothing in Anne Arundel County. It will accomplish nothing in the state of Maryland, except ensure the animosity of all 760 dealers in Maryland, and ensure the animosity and continuing animosity with every gun purchaser who's forced to receive this information against his will. So I would urge the committee to look at this as a dealer would and make it non-compulsory, if you can do it at all, but have some sense about whether or not this is a good idea. I urge an unfavorable report. Thank you.
Thank you, Mr. Chairman. John Jocelyn speaking for 2A Maryland. House Bill 713 would impose a perpetual non-funded mandate upon the health departments of 23 counties plus Baltimore City. How the health departments will enforce and monitor these activities of the dealers is unknown. ATF reports over 760 firearms licensees in the state of Maryland. The health departments will then have to determine which of these are actually selling firearms or ammunition. It's further compounded with their problem is that you're not required to have an FFL to sell ammunition. So now the health department is going to have to go and interview every retail establishment in their jurisdiction, every convenience store, every mom and pop, every grocery, every hardware store to determine whether or not they're selling ammunition. The bill requires that the literature be distributed, but it's totally silent on how the various shops will be restocked by the county. It's silent on what happens if the county health department doesn't restock them. It does hold the dealer responsible for it. They can issue a non-compliance and fine them. There's no due process provision. The bill is silent on who gets the fine, whether it's the shop owner or the 18-year-old kid behind the counter. The bill does not address this. I have talked to various health departments, and they've all assured me they do not have the resources to implement this bill if it passes into law. They don't have the resources. They'll have to ask for funding from the state. We ask for an unfavorable report. Thank you.
Good evening. My name is Katie Novotny. I'm coming to you from District 35B, and I oppose HB 713. The idea that gun owners are uniquely in need of this special information is laughable. There's lots of ways that people can commit suicide and get into conflicts without firearms. Furthermore, based on similar statutes, such as in Anne Arundel County, this literature likely attributes causation where it's not appropriate. So that's going to be a problem. And forced speech is generally not well received. If the state wishes to share information on conflict resolution, suicide prevention, and other areas, they should embark on a public service campaign where they get TV commercial time, rent billboards, and distribute information in other manners than directly targeting only firearms owners. So I request an unfavorable report. Thank you.
Seeing none, thank you all very much. And that concludes the testimony on House Bill 713. Go now to Delegate Schmidt in House Bill 676. Delegate Schmidt is going to be joined by Brian Slattery, I think, perhaps, and there he is. They've been very patient, sitting outside. Mr. Slattery, if you would come up front and join Delegate Schmidt. We're going to hear from the two of you.
Tired of waiting around. I understand. Appreciate your patience.
Mr. Slattery, if you'd like to take off your visitor's tag, I think you're fine. You can take it off. Okay. It's totally fine. I need to be saying that more to the people who are here who always, anyway, it's fine. You're fine.
Thank you, Chair. Thank you, Vice Chair. Thank you, Committee. The best for last, they say.
Yeah.
This bill, HB 676, the duty to stop at the scene. So you can see there's been an amendment in the Senate, duty to stop at the scene, render assistance, and provide information. This bill was brought to me by the Vice Chair because of a constituent that had an issue in the district in Anne Arundel County. And Mr. Slattery and his family here today, his wife, Ms. Flickner, are here in support of their sister and their sister-in-law, daughter-in-law. And so I want to commend them for being here this late and bearing with us. So you can read the bill. I don't need to read it to you. It talks about staying on the scene, rendering information, helping law enforcement. Last year, Senator Gall and I passed a bill to help DNR tie together some loopholes on boating DUIs. This bill helps DNR tie together some things regarding staying on the scene. It's passed the Senate 41-0, 13 favorable testimony. You can see that. And of course, 1 unfavorable by the Office of Public Defender. I'm going to let Mr. Slattery tell his story and answer any questions. Thank you for your time. Well, on July 3rd, 2022, was another wonderful morning. I woke up and admired my wife as she slept, as I did often. She was pretty, no makeup, no stress. After church, we went on with the day's chores. I prepared the boat for our annual trip to Rock Hall for the 3rd fireworks. After pictures and videos from the show, we headed back to the Magothy. As we passed the Baltimore Lighthouse, the finale was going off at Gibson Island. I slowed the boat so she could record it. As we approached the channel, we were struck from behind. I saw the bottom of a boat coming over the back. It landed on top of our boat, crushed my wonderful wife. I pushed the boat off and saw my girl crushed in the corner. And then he took off because he had a lot of priors and he couldn't afford another drinking violation. So she was the best thing that ever happened to me. She was the best wife and mother. The children talk to her daily most of the time. She's a wealth of good, godly advice to all who asked. My children and grandchildren have been cheated out of her loving attention, cooking, and care. She did everything for me. It's been 961 days without her. And there's no justice. Here he is in the detention center. Thank you. So here we are. Thank you, Brian. He ran and no consequences. Right now, it's $500 fine in a boat. It's a lot more in a vehicle. It should be the other way around. That's all I can tell you. What if there's nobody to render assistance? Now your boat's going to drown as the boat sinks. I mean, come on.
Okay. Are there questions? And I want to ask a couple, and I want to try and understand what happened a little. And if this is uncomfortable, we could do it another time, or.
It's 900 days. I'm used to it.
I got you. All right, that's fine. But if you ever, okay. So the boat struck your boat and then took off.
Yeah. After I pushed him off, he landed on top.
Yeah, he didn't just bump it.
He landed on top of your craft. And so, and I'm not trying to be any way, I'm just saying, did you see the person who was driving the boat?
No, all I saw was the bottom of the boat. I pushed it off and checked on my girl. And there she was, crumpled up in the corner.
Yeah.
And then he took off.
Okay. All right. Are there other questions for the witnesses? Delegate Schmidt, there's a technical issue that I'll point to in the bill.
Okay.
On pages 1 and 2, and I think, well, at least 1 and the top of 2, it refers to the operator of a vessel involved in a collision, accident, or other casualty that results in bodily injury to another person shall immediately stop the vehicle. And it makes reference to bodily injury on the second page as well. I noted, is it your intent that if two crafts hit each other, and not to minimize what happened to this gentleman's family, but if the person who's injured gets a splinter in their finger, gets a smaller injury, is it your intent that would result in the penalty that's in the bill?
Well, I think.
Or did you mean that for there to be I could see that part of it is if somebody dies, but part of it would be for a serious bodily injury? Is that what your intent is? Okay.
Correct, yep.
Right. Are there other questions?
Yeah, I think sometimes the issue might be that they just leave the scene altogether, not knowing what the other party may or may not even have an injury. So there might be something that we look at regarding that as well. If the other operator of the vessel doesn't know what the injured party, happened, we might want to look at that a little bit.
Well, that's what he claimed in court. Oh, no harm, no foul. And he took off.
So I'm going to go back. So you were able to identify the person who was driving the other ship?
No, I pushed it off there and I told him he just killed my wife and he took off. I didn't see him. It was dark. I was worried about my girl.
Okay.
DNR tracked him down, sorry.
But he was ultimately tracked down?
Yes.
Oh, okay.
Yes.
I was trying to get from here to here. Okay,
yes.
That's fine. Any other questions? All right, seeing none. Thank you very much for coming in tonight.
Well, I did this 2 years ago and nobody had any objections and then nothing happened. So I'm just wondering why.
We'll do our best.
I understand. Thank you. Thank you very much for being here.
We'll see how you all vote and we'll see that you're in the paper.
All right. Thank you, sir. Thank you, Mrs. Slip. All right, Delegate Schmidt, go ahead.
That's okay.
I'm sorry, sir, for your loss. This is heartbreaking. Did the individual, are they required, I think they are required to have a boat license, obviously, on the back of their boat?
No, you're not required to have a license. Registration on the boat, and if you were born after 1970.
You want to sit down, sir? I'm sorry.
Yeah, you're not required to have a license unless you were born after 1972 to have a boater's, some kind of course showing you can drive a boat. And he's 52 years old, so he didn't qualify for that.
Yeah, that's a boater safety course that you're required to take,
Okay.
but not necessarily a boating license.
Okay, but they don't have they have like a boating license plate and all of
No,
that?
no.
Oh, it's no
Well,
boating.
you get registration, you have to register your boat, like registering your car, but there's no license, no driver's license like a boat.
I mean, no, I'm saying the plate, like a plate on your car, they don't put the plate on the back?
Just a registration number on the side of the boat.
well-
Stickers on the side of the boat
gotcha.
would be the identifier.
Okay,
That's it.
okay. And did they go after that, or?
No, well, it was too late. I mean, he ran, it was the middle of the night. They finally found.
Okay, I'm just trying to see what other recourse penalties and.
Well, the DNR was smart enough to figure out, because somebody tracked him and knew which river he went into after the accident.
Right.
And that's where they knew how to find, and they searched around, they saw people going down to this boat at the middle of the night, and they said, could be him. So
Okay.
they put it together. It took them a while, but they put it together.
Okay, all right. Well, I'm sorry again. Thank you.
Sir, did you say that that the person who did this is now sitting in the detention center?
Yes, because he violated his parole. He wasn't supposed to drive a boat for 5 years. Somebody bought him another boat in his family, and somebody said, he's not supposed to be driving a boat. They called the DNR, they caught him, and then 3 days later, he's out with his kids in the boat again.
Because one of the questions that we're asking among ourselves here is why he wasn't charged with other things.
Well, they're trying to charge him with other things. They're trying to charge him with driving the vehicle to launch the boat without a blow and go, and they're trying to charge him with using the boat.
Okay.
Since he wasn't supposed to drive the boat. And he's still sitting in the detention center instead of in prison.
And were you closer to Rock Hall when this happened or closer to Anne Arundel County?
We were Anne Arundel County. We were just past Baltimore Light, heading in. Gibson Island was having their display. She was slowed down. She was recording that. Next thing I know, over the back, here he comes.
Got it. Thank you
It's
very
a
much.
nightmare I live with every day.
I can't imagine. And I appreciate you
don't
coming
want
down
to.
here. I really do. But I wanted to get that added detail there. All right? Thank you very much. There's a person who has come, who is virtual, who's testifying against the bill. If you want to stay and hear what they have to say, you're not going to be able to respond to what they have to say. If you want to hear what they have to say, you can. If you want to leave right now before.
Oh, no, I want to hear what they want to say.
All right, but you cannot respond to what they have to say, okay? You have to step back from the table. I just wanted you to be aware, and I didn't want you to feel uncomfortable about it, all right?
I'd like to know their name.
Well, their name is Holland Brownlee from the Office of the Public Defender, and they're here for 2 minutes, please. Ms. Brownlee.
Thank you, Mr. Chair and members of the committee. My name is Holly Brownlee, and I'm with the Office of the Public Defender. HB 676 seeks to create a statutory scheme and new crimes for hit and run by boat. In doing so, I believe in the state's written testimony, they acknowledge that existing law already applies to penalize accidentally killing someone with a boat. You've got manslaughter by vehicle or vessel statutes that criminalize it under criminal negligence and gross negligence. And Maryland also already has penalties that would apply theoretically to injuring somebody with a boat, including reckless boating, which carries 30 days. Boating under the influence or while impaired, which carries 60 days or 1 year. And I'll even go one farther. You've got intoxicated endangerment, carries 90 days, and reckless endangerment, which carries 5 years. In the case involving Mr. Slattery's wife, it's my understanding after researching it that the gentleman in that case pled guilty to negligent manslaughter as well as reckless endangerment in that case. The state already has a number of different things in their toolbox that they can use. My first concern is I'm not clear that there is a need for this kind of statute. According to the DNR's website, in 2024, there were 54 total boating injuries, and that's the lowest that it has been in 14 years. And so, again, I'm somebody, I've practiced mostly in water accessible counties. I've never come across this. The best I get is maybe like a boating under the influence every couple years or an abandoned sunken boat case. I've talked to colleagues who practice longer than me. We've never seen anything that would require something like this. Existing law already requires reporting of boating accidents and injuries. Even assuming there's a need for this, how does creating new crimes meet that need? Finally, the bill criminalizes failure to render assistance. Boats are not the same as vehicles. Not just anyone can or does know how to drive a boat. I would have concerns about incentivizing people who maybe aren't equipped to render help to other boats, getting in the water, drowning, all kinds of things because of what this bill criminalizes. Please instead enforce existing law, and for all these reasons, I would ask for an unfavorable report on HB 676.
All right, there's a question. Delegate Erican.
Thank you, Mr. Chair. Thanks for being here. You said you researched Ms. Slattery's death and the prosecution. Could you tell me again the two charges that they charged?
It's my understanding, and it looked like there was a jury trial, and then somewhere on day 5 or something, the defendant in that case entered a guilty plea to negligent manslaughter, which I think is the 3-year one, as well as reckless endangerment, which is a 5-year charge.
Okay, and do you know what the final disposition was?
Yes, it appears that he got a 3-year suspend all but 18-month sentence, followed by 5 years all suspended. And it's my understanding as well that part of the agreement was that the 14 months in which the gentleman was incarcerated by agreement would not count towards that 18-month further incarceration that he got. So he ultimately would have done 22 months minus good time credits.
Okay, minus good time credits. So
32 credits. Sorry, my math is bad. It's late.
That's okay. So you may have heard Mr. Slattery testify. The guy was out the very next weekend with his children on the water again. How could that have happened?
So these cases are very interesting because I don't even know where it came from, but there's this idea. You basically, the state has a year and a day to charge somebody. So this happens quite frequently in the manslaughter context, that this will just go on and be churning, and then a year later, the charges come down.
And then
That's
at that
not
point,
uncommon.
would he be taken into custody in the courtroom at the sentencing hearing? Is that how it basically would work?
So the person would usually have a warrant issued for them, and at that point, they might be held without bond. That's usually what happens with my clients. I've had clients be able to get home detention or electronic monitoring for these things, but it's very common to wait that whole year to charge somebody because it takes so long to you know, do the investigation.
Yeah, I got it. So then the 14 months he got could have technically been also home detention, so he could be out and about in the community, be seen, et cetera.
Yes, also very true. Yes, I hadn't thought about that. That's true.
All right.
Yep.
Thank you.
Yes.
Delegate Kaufman with a question.
Yes, my question is, respectfully, I understand that you work for an organization that tends to oppose enhancements and new crimes, and you cited all of these different things. But if they're all working so beautifully, why do you think Delegate Schmidt introduced the bill? Because we do not just introduce the bills for fun. And secondly, you know, if it's working so well, why did Mr. Slattery's wife's killer only get 18 months? Because I think that's pretty disappointing.
Well, to answer,
I'm going to step in briefly here. I can't have her commenting on why she thinks Delegate Schmidt put in the bill or not.
Okay,
So
well,
we're not going to do that, but the question, the second part of the question that goes to the length of time that someone would serve in a situation like this is, I think, a fair question to ask the Office of the Public Defender, and so that, Ms. Brownlee.
I believe it was Judge Wax, from what I recall, that sentenced him. I do not know the ins and outs of how that worked. I know there were a lot of questions. I mean, it looked like the gentleman had private counsel. They fought very vigorously about different aspects of the case and the relative fault. So I don't know these. I'm not sure. But my larger point is that with only 54 boating injuries in 2024, yes, you're correct that the public defender does not like sentence enhancements or creating new crimes and things like that. But it's not to say that maybe a unique situation happens, like unfortunately this one is. I did do a deep dive out of curiosity to see, and I can't see anything in recent years. And I'm telling you that in 16 years, I've never seen facts like these. And my colleague who's worked in the Eastern Shore for 25 years, these things just don't happen. And so I have concerns just on that level about making new crimes to fit situations when you have existing crimes that do the job just fine. For example, reckless endangerment is not an expungable offense. It's a five-year offense.
Thank you, Ms. Brownlee. Thank you, Mr. Chair.
Thank you, Mr. Chair. I have two questions for Ms. Bromley. Why didn't the Office of the Public Defender provide testimony in the Senate bill?
Well, we do the best we can. I'm not sure. I was available today.
So oversight maybe? Okay. So what is the current, where is the current law that requires a boating person, what are they called? A boater, to remain at the scene? Where does that exist?
That's actually in the current statute that is in the bill that's sought to be addressed. It already says that boaters shall render all due assistance to other boaters, and there's law saying that you have to report boating accidents, injuries, even deaths, mysterious disappearances, and things like that within certain amounts of time. Now,
So
there's no criminal element to it, but
right. Tell me about the criminal element to it. That's what I want to know.
Sure. So there's, I believe there's fines that attach to failure to make a report within that statute. And I don't believe there's any fine attached to failure to render assistance to a boat in need. But there is reckless boating on the books. That's a different statute, which is 30 days. And then.
That's helpful. So, but with respect to the transportation code, we have that if you leave the scene of an accident, results in serious bodily injury, it's a felony. It's punishable up to 5 years, fine up to $5,000. And if the accident results in death, a hit and run carries a maximum penalty of 10 years and a $10,000 fine. You don't think that we can come somewhere a little bit closer to what we do on the streets? Because quite frankly, I know that it's only 54 accidents, but that's actually problematic because we probably have, I don't know, let's say, I don't know, I don't have any idea how many cars we have on the road, but we don't have as many boats. Yeah, we don't have as many boats out there. So if you injure someone and you leave the scene, then that person is out there all on their own. So don't you think that there's probably the ability to gain assistance is actually worse for the boater than it is for the car? What do they call it? The driver?
I'm just to understand, you're saying is that it's more difficult to render it's more difficult to have other people assist you on a boat? Is that what you're saying?
Yeah, because you're out there on your own. Like with the testimony we heard, he was there. He didn't have anyone around him but the boater who caused the accident, who was gone. So you don't think there should be an enhanced penalty when there's an accident that results in a death and hit and run?
Well, as far as the death is concerned, as I said, there are existing statutes that cover it, that would cover that kind of situation. In terms of the hit and run, I think that's a more difficult question, but as you noted, there's a lot less boats out there. So do we make a crime that covers one unique situation that happened just to fit that one thing that already had existing law that was able to cover that instance?
But there isn't a hit and run. Is there a hit and run boating penalty?
Not at this time, no.
Right. Okay. Thank you so much.
Yes.
Well, yes, you can. Delegate Schmidt.
Thank you, Chair. I do want to tell the committee this, and because I was unable to testify on this last year, I did lose a family member in a 2009 boating incident in Anne Arundel County as well. 2 boats collided. My cousin was decapitated at the time. So this bill is very close, and dear to my heart. You brought up some points about numbers, and I'm sure my fellow esteemed colleagues can tell you I'm a numbers guy. We lose a good amount of people, good people on the Chesapeake Bay each and every year. We somewhere average between 15 to 20, sometimes 25. And you talked about the numbers decreasing. One is too many, in my opinion. And when it's dark and there are pylons and piers, and it's tough to navigate those waters. And my heart goes out for the Slattery family. It goes out for all the families that have lost people on the waters. It's a challenge. And I agree with the vice chair. Somebody has to help, because you're out there by yourself most of the time, one person in a vessel and another person. So these enhancements are only going to help all boaters help each other. And it's a tight-knit community, just like we learned from the bikers today. We've learned from a lot of different communities. They have to help each other. And I believe that this bill helps do that. Isn't that so? Thank you.
All right, further questions? Seeing none, thank you very much. That concludes the testimony for House Bill 676, and that concludes this testimony for bills today. We will be back tomorrow with the voting session an hour after the floor, followed by bill hearings immediately after the voting session. And we have 115 witnesses tomorrow. Thank you very much.